I declare open this hearing of the Parliamentary Joint Committee on Corporations and Financial Services into the oversight of ASIC, the Takeovers panel and the corporations legislation. I begin today by acknowledging the Ngunnawal and Ngambri people, the traditional custodians of the land on which we meet, and I pay my respect to the elders past and present. The committee will be conducting today's hearing in person and via video conference. These are public proceedings being streamed live via the Parliament's website, and a Hansard transcript is being made. However, witnesses also have the right to request to be heard in camera, and the committee will consider any such requests. I remind all witnesses that the giving of false or misleading evidence may be treated by the Senate as a contempt. The committee also reminds all parties to this matter of the committee's commitment to the Parliament's procedures for protection of witnesses. The committee emphasises that witnesses are protected by parliamentary privilege, making it unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee. Any such action taken against a witness may be treated by the Parliament as a contempt, and the committee will ensure that any such action is vigorously investigated and, if necessary, referred to the Senate as a potential contempt. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. I remind any committee members and witnesses who are appearing via video conference to mute their microphones when they are not speaking. And if I can just enforce that the committee believes that this matter that we are discussing is of such significance that our efforts will be to do everything that we can today, absolutely in full public view, because of the import of what it means for the public good. I understand, first of all, can I welcome representatives from Lendlease? I understand, gentlemen, that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you both. For the Hansard record, will you please state your full names and the capacities in which you appear today?
Thank you, Senator. John Charles Gillam, the Chairman of Lendlease. I'm an independent non-executive director of the Lendlease Board.
Thank you, Senator. I'm Anthony Lombardo. I am the Chief Executive Officer and Managing Director of Lendlease.
Thank you very much for your attendance today and for your cooperation with the committee in providing documents. We appreciate the fact that you've given us documents in public, and we also accept your claim for confidentiality over other documents that assist the committee, which are very helpful but will not be released to the public as you have requested. So I also thank you for your opening statements, which you've already provided to the committee, and we will table those now. Can I just commence by giving my colleagues an opportunity to indicate who is here today, for those who might be listening, and for the colleagues at home to make sure that they're involved as well. So I'm Deborah O'Neill, Senator for New South Wales, Chair of this Corporations Committee.
Deputy Chair, the Honourable Scotty Buchholz, MP from Queensland.
Senator Paul Scarr from Queensland.
Senator Barbara Pocock from South Australia.
Tanya Lawrence, the Federal Member for Hasluck from Western Australia.
And coming in remotely.
Good morning, Senator Ellie Whiteaker from Western Australia.
Thank you. We do have media in the room who will be taking photographs and recording if there are any objections. There being none, that is agreed. Mr Lombardo, can I just ask you, and you might want to refer to your opening statement in some part, can you explain how this matter unfolded for you and your company?
Thank you, Senator. From my perspective, this unfolded back in May 2025. I had a face-to-face meeting with the then CEO of KPMG. It was an update on a number of different matters, but the whistleblower matter was raised at the end of that meeting. It was alleged that the whistleblower had information about the use of Lendlease board papers, and the allegation was around those documents being stored in an individual's locker. At the time, KPMG had informed myself at the time that they had investigated the matter and had not substantiated the matter.
Can I just flesh out this May 2025. It's before the whistleblower's declaration to me in the statement in the Senate. Was it a formal meeting?
It was a catch-up that I had scheduled with the then CEO at the time, Andrew Yates. It was a general business catch-up, and at that meeting, the whistleblower matter that had arisen I'd been informed about that, and the use of Lendlease documentation.
Okay, so how much did you actually know at that point by comparison to what you know now?
I know a lot more now. At that time, all I understood was there was an allegation around a document or board papers that were assumed to be printed and stored in someone's locker.
Okay, so it's pretty clear that in that meeting with Mr Yates in May 2025, he was aware of this problem.
He was aware of there was a whistleblower allegation which had been raised with KPMG, so they were aware of that matter.
Could I just clarify that point? Did he specifically say it was a whistleblower or a workplace grievance?
At the time, it was explained to me as a whistleblower based on my recollection. That was 12 months ago.
That's very important evidence. Thank you very much. According to your letter, there was this face-to-face meeting on the 31st of March. KPMG told you that these documents were low sensitivity and gave the firm zero competitive advantage. What's your understanding of how the firm, or how KPMG came to that view? And I'll give you the opportunity to put on the record, do you agree with that assessment?
Senator, that meeting was with my CFO.
Yep.
So he had that face-to-face meeting with Andrew Yates where he talked through the documents. There was one document related to an internal KPMG report which provided insights on the Lendlease audit, and the second document was around the audit tender, our scorecard, and assessment of that at the time. In terms of the assessment, from my perspective, that was a KPMG assessment on the sensitivity. There was confidential board papers that was assessed.
So let's be clear about the status of this document, because we're not going to table it, but it has been the subject of reporting.
Yep.
So clearly people are seeing this as an important document and talking about it. Can you explain what that document was and which companies were named in it? Not the scorecard results or any of the detail, just so that people can understand what was being used, what was being endeavoured, and who was involved.
Yeah, the document was our audit tender file. It related to the scorecard. It was an assessment by the Lendlease committee assessing PwC and EY on the audit tender that Lendlease was conducting back in 2023.
And was it a document that your auditor should have had access to, or was there a different situation around this particular sensitive document about PwC and EY, their direct competitors?
I mean, ultimately, Senator, in terms of the audit, our papers, the auditors do have access to our full papers and records. In terms of accessing this document, I didn't see it was an audit tender which KPMG wasn't participating in, which they did have access to the file but should not have been using.
Do you consider it a breach of professional responsibilities?
I mean, ultimately, our auditors, we do need to provide them with access to all of our books and records. In terms of the use of the information, I mean, ultimately, they should not be sharing that with any third parties without talking to Lendlease.
The relationship between a very large company like Lendlease, who has had many decades of relationship with KPMG, it is an important one in terms of providing transparency into the market about what's really going on inside Lendlease. You have a lot of people who are investing and want to back the company in to do what it does. They need accurate information. And it's for that reason that auditors are given access, open access to all the details. Anything that they request, you are compelled to comply. How vital is the currency of trust and the professional behaviours necessary for audit? How vital is that to your business and to your investors?
I think trust is crucial. I mean, that's what the audit practice is built on, and it's important to continue to make sure the right ethics and approach to looking at and making sure that you're auditing our confidential data is maintained with utter respect. So trust is crucial.
And after this experience, Mr Lombardo, how would you rate the trust factor of KPMG?
I think ultimately it's poor judgment in terms of how the documents have been used. I do think they've got a number of critical auditors that still have the right requisite skills to do the requisite requirements of Lendlease's audit, but it does, in terms of trust, it's led to decisions we've had to make as a company around tendering the audit next year.
So the reportage of that is that you will not consider KPMG as your audit partner going forward.
No, I think the board's resolved that. Might let John talk to that.
Mr Gillam.
Yeah, we've already taken a formal decision to change auditors, and we've advised our security holders of that via an ASIC release. We've advised ASIC, we've advised KPMG, and you have the same information in the information we provided you. The question of trust is a very interesting one. Our capital markets, our debt markets, all of the investing is based upon trust, and the financial information we put forward can be trusted because of the audit we have. So it's right at the heart of how we transact. And yeah, this is a very disappointing set of circumstances.
The whole system. And if I can put on the record early before I give the call to my colleagues, this committee is not here to address individual issues and individual matters. We are here to look at the corporations of the financial sector and assure the Australian people that the current processes and protections and regulatory framework is operating well. Your particular case study is very, very helpful in terms of revealing where there are some clear challenges in what's going on in terms of trust. And I think today of everybody who's working down a mine, a retiree who's making investments, people who are investing as trustees, whether it's in retail or industry super, they are relying on the truth of your records as a large company, your statements, your financial statements. They're relying on the trust between you and the auditor to make sure that those documents are accurate. That is the purpose of our inquiry today, to look at the quality of audit, and this is clearly a massive fail. So that is our orientation. I thank you for fleshing out how critical they are, and one of the big challenges in this particular matter, which is a betrayal of trust, the taking of confidential information and the use of that for financial gain for your auditor. Senator Scarr seeking the call.
Thank you. Mr Lombardo, you spoke about that first interaction where it was brought to your attention, this issue. Were you the only one approached by KPMG? Did KPMG actually approach the chair of the audit committee of Lendlease, who I presume would be an independent non-executive director?
They did approach the chair of the audit committee as well.
And did the chair of the audit committee have discussions with KPMG at the time they had discussions with you in relation to this disclosure?
He did.
Okay. Mr Gillam, were you the chair of the company at this time?
No, I hadn't joined the board at this time, but I'm aware of that discussion. The chair of our audit committee was an independent non-executive director, and he was informed in a similar manner by Mr Yates to the position that Tony outlined before. Okay.
Can I put it to you, Mr Lombardo, that the impression you were given by KPMG, or what you took away after that discussion, was, okay, they've raised this issue with me, but there's nothing to see here, it's been closed out, there's no need for me to take any further action?
Yeah, that is correct. They had stated that they'd done an investigation. It was unsubstantiated, and if any facts changed, that we would be contacted.
So from your perspective, you've been given positive reassurance, if I can put it that way, that an issue had been raised and had been dealt with, had been considered, and the matter had been closed out. So would you have been surprised when it arose again this year after Senator O'Neill's contribution in the Senate?
I was surprised that it had arisen again.
Right. And at that point in time, and since that point in time, could you give me your assessment with respect to the response to KPMG? Has KPMG been forthcoming to you with respect to all the relevant information since Senator O'Neill's speech, or has the response been somewhat piecemeal?
No, I would say that KPMG, we've had numerous meetings, myself personally, my CFO and my Chief Legal Officer. KPMG has responded at each of those points, and they've provided us with further information, but it has come back very piecemeal as we've been gaining more information, as it's been a live situation, and we've learnt more through this whole process.
But the fact of the matter is, isn't it, Mr Lombardo, that you would not have become aware of this situation, Mr Gillam, you would not have become aware of this situation, but for the fact the whistleblower reached out to this committee and this committee made a collective decision that Senator O'Neill should give that speech in the Parliament under parliamentary privilege. Is that correct?
Yeah, that's correct. We learnt about it again based on this committee back on the 24th of March when Senator O'Neill talked about this at the committee.
Okay. I note that subsequent you've made a decision, Mr Gillam, you referred to the decision that the board has made to discontinue the services of KPMG, but you're in this terrible situation. I used to be a secretary of an audit committee of an ASIC company. You're in this shocking situation where you're coming to year end and you're stuck, if I can put it that way, with KPMG to get through this this current audit. So how have you gone about managing that situation, and what sort of disruption is it and expense is it causing Lendlease?
There's no doubt that we're working through disruption and additional cost, and that's frustrating. There are thousands of good people inside KPMG, let's be very clear about that.
I agree.
And what we're dealing with here, as information has come out post the 24th of March, is what's apparent is a few very senior people have had a grave misuse of the access privilege they have, and there's a fundamental breach of trust. We need to have our audit completed, and that work is ongoing. It's led by someone who is completely untainted by any of this. We've made sure that there is no one under any investigation or anywhere near the investigation that's involved in our audit. And when our audit completes, which will be mid-August, in a couple of months' time, we will then formally start the process of talking to other firms to work out an appropriate timetable that doesn't disadvantage our security holders to change auditors. I doubt we'll be able to change before the half-year audit for the next financial year is completed, so it's very likely that KPMG will do that work as well. Whether we can change before the 30 June 2027 year end or not is yet to be seen. We don't feel that we should be disadvantaging our security holders because of what's occurred, but equally, as stated in my opening statement, this is a grave misuse of their access privileges, and we're deeply discontented with this behaviour. So we will move as expeditiously as we can. Lendlease is not a small organisation. We have complexities, different trust structures, different investment structures, different jurisdictions, multiple jurisdictions around the world, for example. So it's not an easy audit to change in or out of. The board went to considerable lengths to make a change a few years ago, and it seems ironic that the scandals involving the firm that was going to be appointed stalled that decision, and at that point the board stayed with KPMG and was going to review the idea of changing again next year. And we're here we're on the same track from a different perspective. But
so just my last question, the fact that a company of the size of Lendlease has made this decision, you would not have made it lightly, to change auditors moving forward, does that underline the seriousness of this conduct that KPMG, senior members of KPMG have engaged in?
Yes. The board's view is that our auditors or senior staff from our auditing firm have gravely misused their access privilege, and it's a fundamental breach of trust, and we're deeply discontented with that behaviour.
Okay, thank you. Thank you, Chair.
Senator Pocock.
Thank you for your evidence. You use a phrase in your correspondence, as I recollect, about the nature of the response, piecemeal and partial.
Sporadic.
Can you remember the second word that you've used? Sporadic, thank you. Piecemeal and sporadic. What level or what kind of response would have been appropriate in your view? I'm sure you've reflected on that.
Yeah, I think it would have been great to be able to receive everything transparent as fast as possible. It's taken a few attempts to get to the bottom of the matter and get the full information of what's occurred.
And so, if I read into your statement, you would have preferred full information at an earlier moment, and you have a 70-year relationship, I understand. What were your expectations of that relationship, and how have they been disappointed? And I'm talking about the senior leadership of KPMG.
I think we have the same expectation as any company of its auditor, that they will do their job to the best of their professional abilities, and they will observe without fail the confidentiality that they are of the access to the books and records that they must have.
Without fail, Mr Gillam.
Without fail.
That is the standard, isn't it? Without
fail. How can we trust them if they can't?
You have signalled that you are incurring very significant costs, clearly, in responding to this. It no doubt will have sent a shudder throughout your whole organisation, this kind of change in relationship and this experience. Have you had any signal that KPMG will meet all of the costs, internal and external, that you're meeting in dealing with this crisis?
We've raised that with KPMG. They are our auditor, so we do need to continue to have that dialogue around how a reimbursement will take place.
You said earlier that the KPMG, Mr Yates, when he met with you in May of 2025, used the language of whistleblower. Can you confirm exactly how he described the incident?
Yeah, I mean, this goes back 12 months ago, so based on my recollection at that point in time, he talked about a number of allegations that an individual had made. And at that point in time, it was, from a Lendlease standpoint, it was the use of board papers that were physically stored in someone's locker, and that they'd gone through an investigation and it was unsubstantiated at the time.
And did he describe the nature of the investigation?
I can't recall. I do remember him saying that an investigation had taken place at that point in time, so I took comfort that they would have taken and undertaken a robust investigation, was my assumption. And
did you assume that that was in an internal investigation? Was that the implication from Mr Yates?
Again, I can't recall if it was internal or external, Senator.
What did you do after that meeting in May 2025? That's a significant piece of information. There are, as you just said, a number of allegations, not just one. What did you do after that May 2025 meeting?
Two things we did. I had a chat to our audit chair, so I just wanted to ensure that he had received that same information. The second thing I did was, because it did relate to the storing of printed documents, we use Diligent, which a lot of Australian companies use as our, to return our board records. I spoke to our head of ICT around, can we find out whether there were logs, or could we work out whether things had been printed? The advice coming back from Diligent was we couldn't, and so we couldn't access metadata or not. So we could not prove whether printed documents had been, from a Lendlease point, had been printed or not, or could have been stored. So it was just trying to find out from our perspective.
Could you check what had been accessed and by whom and when, without going to printing?
No, because what Diligent does, it has a record of the individuals who have access. It doesn't have any records that determine dates of who's used what file or what folder or printed any documents. There's no logs retained.
Thank you. Mr Lombardo, you're a leader of a very significant and large organisation. You must have reflected on your view of the culture and leadership in KPMG. You've spoken of the many good people who work in KPMG. What's your assessment of what we are seeing, both you have experienced personally since this event happened and from your public reading of public record? What's your assessment of the state of culture and leadership in KPMG?
Look, again, it's disappointing to be in this situation from our perspective, and to have documents that were misused and used for other purposes. To me, it's very important to continue to maintain a trusting relationship with our auditor, and when these situations arise, it actually creates a lot of questions around how that documentation and our information is used. So it was disappointing.
Last question. Thank you, Chair. Some will argue, and they have argued, that KPMG did not materially benefit. That's yet to be tested, of course. Does it matter whether material benefit arises when the breach is use and access to confidential information, which should not have been undertaken? What's your view about the materiality question versus the breach of ethics?
Yeah, ultimately, it was just disappointing that our information's been used. There was confidential information, and it should be used for the purposes of the audit only.
Thank you. Thanks, Chair.
Thank you very much. Can I just clarify before I go to the Deputy Chair for a couple of questions before we let you get back to your business? In the correspondence that you have sent to us, in Annex A, there's a series of text messages, screenshots of text messages backwards and forwards. Is it fair to say that following my speech in the Senate in March, there was a flurry of activity and engagement between Lendlease leadership and leaders and partners at KPMG?
That is correct.
How would you characterise that set of communications?
I mean, from my perspective, it was communication back with Andrew Yates, and then we delved into many other questions because we learnt more information through that. And so it was really an evolving discussion over the last few months to determine exactly the use of our data and how that had all occurred. So,
how would you describe those interactions?
I had a number of phone calls with Andrew Yates, and then I'd asked my CFO to sit down with Andrew and work through that quite diligently, and the head of legal at the time. So we wanted to really understand each of the different circumstances and for them to be as transparent as possible with us to obtain all the information.
And can I go to the transparency matter? KPMG to this day are claiming privilege, legal and professional privilege over the documents. I note in your annex here you ask a series of questions, and one of the things that you request as the nearly, is it 70 years or 68 years that you've been audited by KPMG?
Circa 68 years.
68 years. So you ask of your trusted but no longer trusted auditor for copies of all internal and external investigations carried out by KPMG or its external advisors which involve Lendlease data. What is the response of KPMG been to your request when clearly you are very particularly aggrieved by the behaviour that we're considering today?
Yeah, we've asked that question and they've responded by maintaining that information's in confidence, and so they haven't provided us that documentation.
So they're claiming legal professional privilege over documents that relate directly to information that you seek to manage what's happening in your own company and about your company.
Yeah, they are seeking to protect their information. Importantly, we were trying to make sure we understand exactly the use of our information through the allegations.
Yeah, we're trying to figure out too, because we hear external investigation, internal investigation, legal advice, and we're never sure what's what.
So just on
Senator
that point, Mr. Lombardo, they have denied you the opportunity to obtain a copy of the results of an investigation into the misuse of Lendlease's information on the basis of legal professional privilege.
Yeah, they have not shared with us the documentation. What they have done is shared the incidents and where they've now substantiated the investigation.
But they've denied you an opportunity, Lendlease an opportunity. You considered it so important that you asked for a copy of it, and they denied you the information, a copy of an investigation so you could make an assessment of the investigation which was undertaken in relation to the misuse of your property, correct?
Yes, Senator, we have asked that question and they have denied.
They're protecting you from yourself. It's a little ridiculous. Deputy Chair.
Thank you. Mr Lombardo, earlier in your contribution to the committee, you spoke about the audit tender scorecard breach. Just so I've got a better understanding of where the breach occurred, how long, it's on the record, you've had a relationship with KPMG for 68 years, is that correct?
That's correct.
The audit tender scorecard breach, can you explain to me what's the significance of the breach? You know, for someone who's looking at this for the first time, you were going to market, you were doing an assessment of other audit companies and had made an assessment against a certain set of criteria that you had predetermined yourselves, and that information was breached by KPMG. Is that correct?
We had a scorecard that the committee was using to score two firms, and that was EY and PwC at the time for the audit tender, and it went through a number of criteria and evaluation to score it to prove which one of those would be selected as the preferred audit firm going forward.
And you refer to it as a grave misuse of trust. My question, and this is my last question. My question is probably to Mr. Gillen. With that grave misuse of trust, has the board then considered, with the relationship that has been in place for over 68 years, what other possible breaches have been materialising on a regular basis, or are you comfortable that this is, as KPMG's first response to you, nothing really to see here?
It's a good question, because whenever you have a fundamental breach of trust, you then have these other doubts creep in. What I can say is that we do trust our current auditor, and we've made strong representations to ensure that the team that's working on the audit are free of any involvement in this whatsoever, and that will continue for so long as they continue to complete audit work for us as we work through who we're going to have as our new auditor and come up with a transition plan, as I said, so that our security holders and our endeavours are not disadvantaged any further.
Thank you, Mr. Gilman. Thank you, Chair.
Thank you. I guess the reality is, you know that it was accessed and used. The question is, what else was accessed and used? Was the
is it recidivist behaviour?
Yeah. How much more do we know? And at this point of time, there's been no external investigation other than the people charged with that responsibility by KPMG themselves, and we're unclear what it is those so-called investigations were tasked to do. So it's about clear as mud at this point of time, really, isn't it, Mr. Lombardo?
All we know is the current allegations are the ones that have been substantiated. We can't hypothetically understand if anything else has been used.
Can I ask you on notice, having heard the evidence today, and we will be talking about the treatment of the whistleblower and the dismissal of lots of information there that would have been of interest to you, I expect, much earlier than when you found out. We'll have some questions on notice in response to further evidence throughout the day to get your views. We have one final quick question from Tanya Lawrence.
Thank you. I just want to reference the documents that you've provided, the thread message between yourself, Mr. Gillam, and Mr. Martin Shepherd, the then chairman at KPMG. His text message to you: "Hi John, Martin Shepherd, chairman at KPMG here. I wonder if you could please call me re the whistleblower matter I'm dealing with. No change or update from Lendlease perspective, but I am confidentially, and in brackets, going to take some action re-accountability for where we find ourselves, which may raise the noise a little, and I wanted you to be aware ahead of time. Regards, Martin." Can you share with us what that discussion culminated in?
I didn't have a discussion with him. He sent texts, I didn't reply.
Yeah, and you replied, "Thanks, might have been in a board meeting, I can talk tomorrow morning if that suits," and then he asked you to call?
Is this the April or May?
This is May.
Yeah, we didn't talk.
So, okay, thank you.
So when then did you become aware of the resignation of the CEO?
When I read it in the newspaper.
Thank you very much, Mr. Gillam. Can I thank you both for your attendance here today and for your cooperation with the committee? It's a very important frame for what the rest of the day will consider. Thank you.
Could I just also remark, with indulgence, I think from my perspective in terms of what Lendlease prepared and the way you've engaged with the committee, I think it's been very positive.
Thank you.
Thank you. Thank you, Senator. Thank you, committee.
Thank you. If you've been asked to answer questions on notice, which I've just indicated there will be one at least, could you provide the responses to the Secretariat by the 17th of July?
No problem.
Thank you very much. committee will suspend for just a moment to allow CANS to come forward and take their position at the table. Is from Chartered Accountants Australia and New Zealand, more commonly known as CANS. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to the Senate committees has been provided to you all. For the Hansard record, will you please state your full names and the capacities in which you appear today?
Sarah Peterson, Board Chair, Chartered Accountants Australia and New Zealand.
Ainsley Van Onselen, CEO of Chartered Accountants Australia and New Zealand.
Vanessa Chapman, the Group Executive General Counsel and Corporate Assurance for Chartered Accountants Australia and New Zealand.
Grace Kelly, Chair of the Disciplinary Tribunal, Chartered Accountants ANZ.
Thank you very much. Can I thank you for your cooperation with the committee? You have sent us quite a tranche of information and you have asked for the committee to keep that confidential in the way that we always do. We take those requests seriously. We have considered your request and we wish you best in your endeavours for the disciplinary matters that are on foot, and we will not be releasing any of your confidential material. But thank you for it nonetheless. I also thank you for your opening statement, and I just wonder if you might take us through the timeline, perhaps Mrs. Van Onselen. When did CANS first know there was an issue at all?
So thank you, Chair, and thank you for the opportunity to appear today before the committee. I would like to start on behalf of CANZ to say that we are very deeply disappointed and frustrated as these allegations that are before the committee are at the heart of trust in audit. Confidentiality of client documents is non-negotiable under APES 110, and unauthorised access to Lendlease documents is particularly concerning. It's basic professional principle. If you access something you shouldn't, you should fix it immediately and not use it to your advantage. At the moment, I'll give an update to the committee, if I may, in terms of where we are at with our investigation. So the Independent Professional Conduct Committee is progressing 12 active investigations, including 3 initiated from self-disclosures. Files opened on named individuals from 24 March onwards. We are also doing academic integrity investigations as a result of QPR, a targeted quality practice review in respect to academic integrity matters at KPMG that occurred in 2025. In relation to
just for clarity, 2 tracks of inquiry that relate to KPMG. The first is a tranche of 12 matters. The second is relating to academic integrity. That's the testing. There's 2 parts to that, though, aren't there?
Yes. So in post the 2022 KPMG academic matter that was brought to our attention through the PCAOB and our QPR, the Professional Conduct Committee instigated as part of that a targeted quality practice review in relation to academic integrity. One of those QPRs occurred in December 25. So in terms of timeline to your original question, Senator, in or about November 2025 is when we were fully aware of a number of instances of the use of unauthorised use of artificial intelligence in internal tests at KPMG, so an academic integrity matter. Immediately, we took an active and interventionist approach, opened files and started an investigation.
Okay. So let's be very clear that that is not the matter that we are really looking at today, but it does go to the cultural practice. And we see in the gap between 2022, where there was actual cheating on ethics tests, a repetition of cheating using AI in 2025.
That's correct, Senator.
Okay, so if we can go back to the 12 matters, that would be good.
In your speech on the 24th of March, for completeness, it referenced academic integrity, so I wanted to cover that off as well. We have 21 self-disclosures in respect to that academic integrity matter.
Okay, thank you. The self-reporting by 3 partners, when did that occur?
That occurred, I believe, on or about 14th of April 2026.
Okay.
I'll just check with my learned colleague.
Sorry, can I just correct that? I believe that the self-disclosures were lodged around the 16th of April this year.
And for clarity, with regard to the matters that have just been discussed with the leaders of Lendlease, exactly what date did you know there was an issue with this whistleblower formally? You write in your letter about some communications that you're sort of backtracking to find out if that was them, but tell me, what day did KPMG absolutely reveal what was going on to you? When did you really find out about it?
So post your Senate speech, Senator, on the 24th of March, on or about the 14th of April 2025. 26, sorry.
Okay. So if I can go to that speech on the 24th of March, the next day, I think you indicate that you had a meeting with Mr Andrew Yates, is that correct?
I received a text message from Mr Andrew Yates on or about the 24th of March, Senator, requesting a telephone conversation. That telephone conversation occurred also on the 25th of March with my colleague, Ms Chapman, with present as well for that conversation with Mr Yates.
Okay. So, for clarity, did you know about the Lendlease theft of documents before my speech on the 24th of March?
No, we did not, Senator.
Had there been any disclosures at all before my speech?
No.
No,
had you
Senator.
had any communications from the Office of General Counsel, any senior people at KPMG in any way at any point of time about the matters that are now for discussion today as a result of the whistleblower's information to this committee?
No.
No.
Does it concern you, given that we have heard that there was a discussion just this morning on the 25th of May with Lendlease about a potential whistleblower matter, and can we catch up and talk about it? Does it concern you that Mr Yates didn't bother to call you?
Yes, it does, Senator.
What does that say about the culture of KPMG?
What I think it says is in relation to the individuals involved who were partners of KPMG, it's extremely serious conduct, and I'm disgusted by it. It's basic 101 stuff. So in terms of ethics principles, confidentiality of documents is 101. I had an instance myself when I was a junior lawyer. I was doing discovery of documents. In that discovery at my opponent's solicitor's residence or business, there were documents in there that were confidential. Every young lawyer and every young accountant in the country has it drummed into them to respect your client's confidentiality. And in that instance, what I did, you close the file, you immediately walk out, you speak up and you rectify it. What you don't do is take advantage of it.
We're going to hear a bit of speak up, but I think we've had a lot more cover up than speak up, I'm afraid. Mr Buchholz has got a couple of clarifying questions, a couple of points to make there.
Just
I think
to
they're
that point,
important.
to your disgust, and I take that, I hear it. In your opinion, the penalties that we have seen dealt to the some KPMG and not to others, have those penalties, in your opinion, been harsh enough?
In respect to which matters, Senator?
Some partners have been, or some have been demoted, some have lost their job, others stay. Yeah, there are partners that are still in place who had full knowledge of this. Are the remedies that are the self description of how these guys have tried to manage it, is it appropriate, or would you like to see things go further?
So our independent professional conduct committee is actively investigating these matters as we speak, and the folders that we have provided the Senate, thank you for the production notice which enabled us to provide those documents, indicates where we're at with the status of our investigation, and we will keep the committee informed.
Thank you. Can I just observe, and I think we'll do this a few times through the day, there are very good people in every industry, and I'm sure that there are good people within KPMG, but the reality is KPMG is a partnership. Every partner is joint and severally liable, and I hope to come to that very shortly. But let me just keep going So even if you're a good person, if these partners have done this, and now we know as a matter of fact that they have acted in profoundly unprofessional ways, unethical ways, at a leadership level, every other partner is therefore liable and attached to that behaviour. That's how a partnership operates. You don't get to be a good person and hang around with a bad person and not have any interaction. Those things, you're in an ecosystem where they're connected.
Several and joint liability, yes.
That's exactly what it means. You're all in it together, no matter how good you might be. If one of your partners does something wrong, you are attached to that failure. Is that correct?
That's broadly correct. Under the Partnership Acts, there are some defences for people who are partners who can make out the defence of absolutely no knowing involvement. But your principle is correct, Senator, and to the extent that a liability attaches to a firm, it attaches to all partners at that time.
Okay.
Just one tack on, if I could. We're concentrating on the misappropriation, the terrible stuff, the naughty stuff. In your investigations, will there be any consideration given to the whistleblower who actually came forward, and is there any duty of care to their mental health, their financial status, their state of mind?
Yeah, perhaps I can answer that, Senator, Mr Bulchos. I think it's really important, first of all, to recognise that chartered accounts is not part of the statutory whistleblower reporting framework under the Corporations Act, and that a whistleblower potentially, to preserve their whistleblower protections, must ensure that their disclosures are made to eligible recipients, and not disclosed outside of that reporting framework. We, obviously, having now become aware of these allegations, and particularly the really serious allegations around the misuse of confidential information and potentially broader ethical challenges around integrity, professional behaviour, potentially auditor independence, potentially a range of related matters.
That's some list, Mr.
It is a list. The Professional Conduct Committee will undertake its role as the independent investigator and will look at all of those allegations. Under the Corporations Act, the responsibility for the administration of the whistleblower protection provisions rests with ASIC, and the power to make findings about violations of the whistleblower protection provisions rests with the courts. The Professional Conduct Committee, as a professional disciplinary body, cannot make a finding about whether or not whistleblower protection laws have been violated. However, if such a finding is made by a court, it can act on those findings, or if there are admissions made, then it can act on the basis of those admissions and potentially make findings around professional behaviour, professional and other ethical provisions. I might just stop very briefly there, Chair, if I may. Our Disciplinary Tribunal Chair is here with us today. Ultimately, the Disciplinary Tribunal and the Professional Conduct Committee are entirely separate and distinct, and it would be very unfortunate if any of the matters that the PCC is currently investigating were to be derailed because of some suggestion or allegation that the tribunal is somehow compromised or Miss Grace Kelly needs to recuse herself because she is privy to some of these discussions and some of these pieces of information that would not otherwise be brought to her attention. So I would just be mindful that in our discussions today, I'm still canvassing what I would call the theoretical possibilities as opposed to the practical investigation outcomes.
Okay, can I just go back to some communications? Ms Van Alselen, you had a telephone meeting, is that correct?
Yes, correct.
With your General Counsel and Mr Andrew Yates, the then CEO, who provided information about the steps the firm had taken to determine whether whistleblower reports it had received from a former employee were substantiated. Was the person called a whistleblower in your conversations of the day?
So there was while Ainsley's looking for the note, on the 25th of March, Mr Yates asked for a call with Ainsley and myself, and during that particular call, we were given the assurance that the allegations had been thoroughly investigated and were all entirely unsubstantiated. It was acknowledged that there had been a number of investigations underway, and that at the core of the allegations were the allegations that there was a whistleblower who had been treated badly and that the firm had done nothing, and that there were client-related claims which law firms that had been engaged had found not to be substantiated.
Okay, so go. Yes, Senator Pocock, you've got the call.
That was the 25th of March.
So on that day, you're alerted to, yes, there's been a whistleblower who's been talking to us. They didn't, Mr Yates didn't tell you that he'd advised Lendlease about this a year before.
No.
He did advise you that they'd thoroughly investigated this matter through 2 legal companies. Do you know what those legal companies were? Did he tell you at the time?
That was not disclosed at the time.
Okay, so now it's come to light that that is Ashurst and Allens. Those were described to you as investigations or legal advice or external advice? Like how were they characterised in the conversation with you on that day, Ms Van Olsenen?
So, Senator, if I may, there was a holding statement issued by KPMG on that day that also informed our understanding, and they were described as investigations, and also that KPMG had contacted the clients named in the Senate. So that was on or about, that was the same day, the 25th of March.
Okay. Thank you. What documents did you ask for or receive from KPMG to verify those assertions?
At this stage, we were informed that there was no basis to the allegations and that they had been
And you just took Mr Yates' word for it?
No. Sorry. The Professional Conduct Committee team, the conduct team, were made aware of the Senate speech immediately, and they
That's a
commenced.
separate process. What I want to understand is you're on a phone call. Mr Yates is only talking to you because the speech I've made the night before. You open a conversation with him. What's going on, Andrew? I'm sure it's something like that. And he says, don't worry, it was a whistleblower matter and we've investigated it. There's nothing to see here.
So Mr Yates and KPMG are very well informed about their disclosure obligations in instances of wrongdoing or where there are
That's not what I'm asking you, Ms Van Olsenen. I'm trying to understand the tenor of the conversation, because if he told you whatever it is that made him later resign at the end of May and accept responsibility, I wonder what was going on when he had the first conversation with you. He had that knowledge at that point of time. He'd already known about the whistleblower for at least a year, in my view, longer. What did he say to you? And did you say, oh, great, Andrew, I'm so glad you sorted it out with Allens and Ashurst. No problem, we'll put it onto our disciplinary committee. Or did you say, this is pretty serious, show me the documents, show me your investigation. I don't want to be caught out on this. This is serious, Andrew. Did you ask him a question directly like that in that way?
So, Senator, as it pertains to a whistleblower matter, we are constrained in the information that we can
I'm not asking you about your internal processes. Mr Yates calls you, says, hey, we've got a problem. Did you say, what did you do? Show me the money. Or did you just go, OK, Andrew, that's fine. Thanks very much. Lovely chatting.
No, not at all, Senator. It was during the conversation we said this is extraordinary. These named individuals.
Certainly
named
is.
Individuals.
He named individuals.
No, that there were named individuals in the Senate. Those are allegations that Mr Yates knew.
I named the individuals.
Correct. That would need to be properly investigated, which is not an executive function but is a professional conduct committee function.
But he told you they'd already investigated it.
Irrelevant. The Professional Conduct Committee can commence an investigation on the basis of the information irrespective
but they
of where
need
it's found.
information, my point
Correct,
is.
and they
Ms
will.
Chapman, did you ask Mr Yates at any point of time to provide you with the documents on which he relied in asserting to you that there was nothing to see here?
I believe that the senior investigators within the conduct function wrote to KPMG on the 31st of March requesting all relevant information.
And did they receive it?
I believe they've received information.
Have they received the documents upon which Mr Yates relied when he sought to convince you that there was nothing to see? He referred to investigations. Have your responsible members of the CAN structure, have they received the reports from Ashurst and Allens on which Mr Yates' assertions that there's nothing to see here rests?
I don't believe so, Senator. Everything that
have they claimed
we
LPP?
Have received is in zip folder 1, which are the confidential documents. There was a letter, I believe, from KPMG to the Professional Conduct Committee outlining the steps they had taken in respect to the allegations, and they had individualised in an appendix a table in those 20 or so allegations.
Yep.
That is before the committee.
But to be clear,
everything we have, Senator, is before the committee.
Your disciplinary committee has asked for the reports.
He would have asked for all information
and has not received them. Have they made has KPMG made a legal and professional privilege secrecy claim to your entity, CANS?
That is, I'm not aware of that,
okay.
Senator.
Thank you very much. Please take it on notice. I'm going to go to Senator Pocock. Thank you.
Thank you, Chair. I just want to clarify something first up in relation to cheating on exams. We have 2 chapters before us and there's some confusion at times about which we're talking about. What do we call the first chapter? We call it the 2022, or do you want to put a year on it, where PAOBC in the US fined KPMG Australia $615,000 for multiple breaches of exam cheating. When was that?
So that's 2022, the PCMG.
So let's call that the 2022 cheating chapter.
Correct.
The latest chapter, which you are currently investigating, was in 2025.
2025.
And you are now pursuing...
Sorry, Senator, pertaining to matters in 2023 to 2024.
Matters 20. So what we've got, I mean, just for ordinary people out there who think exam cheating is a pretty bad idea and would discourage it in their children or themselves, we've got 2 rounds, one of which had a massive fine for multiple people, and 2 years later, even less, we have another round. What's wrong with our system where that happens? Just give me a brief assessment of your view.
So any type of academic integrity issue is extremely concerning. It's why we included it in our professional conduct review in 2022. We specifically put academic integrity in respect to our CA program. This was in relation to internal tests of KPMG, so open book type assessments, as I understand.
I'm going to ask you to be brief in your answer. Thank you.
Absolutely. So in that context, we take an active and interventionist approach, and when matters come to our attention in relation to academic integrity, in this case it came out of the quality practice review that the Professional Conduct Committee had ordered in relation specifically to academic integrity. And through that PCC QPR review, that was where we, i.e. the entity, were informed that there are a number of sanctions, internal sanctions, by KPMG to its employees in relation to AI.
So what's wrong, what's broken in the system that we have repetitive behaviour like this? Why is it reoccurring? What's wrong with the penalty? What's wrong with the consequences? What's wrong with our regulation that a large company like this, on the public record, fined once, comes back again?
I think the scale...
What are your reflections on what's wrong here, briefly?
Yeah, the scale's quite different. So the 2022 PCOB issue was about over 1,000 people.
Does the scale exonerate that it's smaller in the second round?
I think in this last round, I think the firm had been able to show that it had some detective controls and it was able to identify 50 or so people, or 60, I can't remember the exact number, who had used artificial intelligence in one of their internal
including
tests.
a senior partner.
Yeah, and obviously that's improper. So there were sanctions, and the firm put their consequences process into train. I think consequences are really important, and I think accountability is really important. One of the things we've been very focused on with all of the, not just the firms, but the membership as a whole, is accountability is both an internal and an external process. As members of an accounting organisation, members who are sanctioned by their firm for an integrity-related matter are required to self-disclose that to the PCC, and that is a separate part of the organisation. I think that's really important, and they do need to go through a process of owning up to what they've done. And for a member who, is a holds a statutory registration, they also need to understand that that has consequences in terms of a referral to ASIC or to another regulator.
I guess my point is, Ms Chapman, there may be consequences, but they are not deterring the behaviour from what we have seen. I want to move along.
Just before we move on to the next line of questioning, I'll come back to you. We've been around this roundabout once before with another set of letters from the alphabet, PwC, which saw the resignation of Mr Tom Seymour as the CEO. He went through all the processes that you're describing to us. He's not allowed to practice, he's suffered penalties, and they sound very serious when you put them in that way. In reality, having taken home millions and millions of dollars in even his last year as the CEO, what was the fine that your body imposed on the CEO of PwC who had to resign? How much did he pay?
It was in the order of about $25,000, I believe, and also costs, which was more than what the TPB issued, which was 0 fines. So we did more than any of the government regulators did in relation to this respect. We also...
So is there a problem there? Because Senator Pocock did ask you what's the problem, right? Is the scale of fines a problem? Because when somebody's taking home 3.2, 3.5, 4.7, 2.8, you know, they take home so much money. We've had Mr Burrows, the current CEO, forget 1.2 million that he's getting from the international part of his salary. When they earn that much money,
yes,
$25,000, which is life-changing to a single mother who hasn't got a roof over her head, is absolutely useless and nothing to these people. Is that a problem that needs redress, Ms Van Olselen?
Yes, it is, and it's an issue that the government can address. This was raised. We've provided our legal advice back in 2023 to this committee, showing that as a private membership body, we are not able to invoke punitive fines or penalties.
We know.
So we are limited
it's on
to
the record
scope that we have.
People have high expectations of what you can do, but there's very little that you
which
seem
is
able
why
to do.
I
want to go back to Senator Pocock.
That we asked the government to clarify
Ms Van Olselen, if you want to put more on the record,
I will go on.
This is within the government's purview.
If you want to put things on the record, please, you'll get the transcript, add them in. But I want to get to the senators.
Going further roadmap if I have.
Thank you.
I
want
going to Senator Pocock.
Van Olselen, I want to go to KPMG's behaviour over time and your engagement with KPMG. A whistleblower in the KPMG, and first let me clarify, on what date was the current KPMG whistleblower first in touch with Cairns?
So, Senator, we don't know whether that whistleblower has been in touch with us at all. We did have, as we indicated in our letter to you of the 2nd of May, I believe, we had an anonymous email sender in relation to a media report regarding artificial intelligence academic integrity issues at KPMG. We were already investigating that matter. There was no other details specified at that point. No allegations in respect to breach of confidentiality or in respect to audit independence has been raised with us with an anonymous sender or otherwise.
So could you provide documents about showing the receipt of the complaint, the first anonymous KPMG complaint, any internal assessment that you undertook in relation to that? That's a complaint you've received. How did you respond? Any decision to investigate or not investigate? Any consideration of disciplinary referral? I'll ask you to take that on notice. And I want to go on.
We have provided the response to that, Senator.
Have you?
In our letter of 5 June.
Great.
12 June, where we indicated that the summary of the anonymous email dated the 3rd of December, but due to the Part 9.4 AAA of the Corporations Act, we are unable to provide that particular email. It didn't constitute a complaint. There were no specifics in relation to it that we were able to pursue in any event. So
I want to go to another KPMG issue and look at some historic material here. Ms Chapman, if I can come to you. Professor Brendan Lyon met with Cairns representatives, including you, and raised concerns about KPMG conduct directly some time back. Is that correct?
Yes, it is. Mr Lyon met with me and another one of my Cairns colleagues in, I believe, August 2023 and did indicate that he'd had a pretty awful time when he was working at KPMG.
So those concerns included allegations related to senior KPMG leadership, including Mr Yates, Mr Lowe, Ms Capon, the new CEO as of today, Stanley Stavros, and the now global CEO, Gary Wingrove, among others. Is that correct?
I don't recall him mentioning any names other than Andrew Yates and
Could you check
Gary
your notes
Wingrove.
on that?
I don't believe I took notes of that meeting.
Okay.
I had another colleague with me. We were generally discussing some of Mr Lyon's concerns around the way the CAN's disciplinary process works and how it is important if a member or a person, a member of the public, wants to make a complaint, they can do so through to the PCC and provide all relevant information.
That meeting included allegations. CANS did not commence a disciplinary investigation into the broader KPMG executive leadership arising from those concerns. Is that correct?
I don't believe there was a specific investigation into allegations or what were media reporting around the behaviours of senior leaders at KPMG. No, that's correct.
So can you provide to us your meeting records of that meeting with Professor Lyon, also all internal assessments, processes and procedures that followed from that, any records on who decided the scope, pace and ultimate findings of the investigation, in short, all records showing your investigation of the Tahi matter? Ms Chapman, you told this committee in March this year that after 5 years your investigation of KPMG involvement in Tahi, in the whole Tahi affair, had concluded with no findings of any breach of ethics. Do you remember that?
I do.
That investigation related to a single member, is that correct?
Yes, that's correct.
Your investigation did not extend to all senior KPMG executives involved in the Tahi matter, is that correct?
No, that's correct, yes.
The New South Wales Auditor-General publicly criticised KPMG's conduct in relation to Tahi, is that correct?
My recollection is that the New South Wales Auditor-General, Ms Crawford, I believe, criticised the government agencies for leaving the negotiate or management of conflicts of interest to KPMG. That's correct.
The Public Accountability Committee in New South Wales made findings about KPMG's manifest conflicts and treatment of Mr Lyon, correct?
I didn't read that particular report.
That is okay. Those findings included criticism of conflicts and disclosure. Is that correct?
Again, I didn't read that particular report.
They included criticism of the handling of government information. Is that correct?
I'd have to check that report. I don't recall, Senator.
And they also include criticism of the quality and independence of KPMG's work for New South Wales Treasury. Is it also true the Secretary of Transport of New South Wales testified that KPMG's actions put public safety at risk in the rail system? Is that correct?
I don't recall that particular piece of evidence, but I do recall there being some quite different perspectives between Transport and Treasury at the time.
The Secretary of Transport's view is on the public record. CANS did not interview Professor Lyon as part of its 5-year investigation. Is that correct?
Senator, prior to the amendments...
I'm just asking yes or no.
They couldn't. So the bylaws required at the time allegations and investigations to be undertaken in, by reference to interviews with the complainant or a complainant or the member concerned. Post the bylaw amendments in 2023, the PCC has the ability now to request information from any member about a particular investigation and from third parties.
Sorry,
so it's a much broader set of investigation powers.
Sorry to interrupt you, but is it the case that prior to 2023 the PCC could not interview the complainant?
Oh yes, they could interview a complainant, but there was no complainant in that particular matter.
And why did you not interview Mr Lyon then, Professor Lyon?
He was not a complainant.
But he was part of the evidence base. Why did you not interview him?
I believe that, as I said at the time, he was neither a complainant nor a member, and therefore a person who could be asked to provide information.
CANS did not interview Mr Rod Staples, the former Secretary of Transport for New South Wales, as part of that investigation either. Is that correct? Yes or no?
I'm not aware of the details of the investigation file in particular. As I said, the PCC processes are a matter for it and its inquiries. The decisions that it undertakes are a matter for the PCC.
So Cairns didn't seek evidence from parties outside KPMG as part of that investigation. Is that correct?
I'm restricted in what I can say about the particular matter, but the PCC did make inquiries and received a range of information.
And did you include people from parties outside KPMG? This is important to us as a committee because we are trying to get to the bottom of a pattern of behaviour here, and your answers are very important to us. So can you confirm, did you seek information from parties outside KPMG in relation to that matter? Tahi.
Senator, as I said on the 20th of March, the matter that was the Tahi matter is subject to, was ultimately determined that there was no case to answer for the member involved. And on that basis, there's a limit to what I can say in this forum or in any forum about that particular matter. I'm happy to take it on notice and to come back to you with information
that would be
subject to the consent.
Last question.
I'm on a line here. I just want to finish it.
Well, can I just stop for a second and indicate that there are questions, and we will ask if you can stay a little longer to just proceed with those questions. That will delay our break before we take evidence from KPMG.
Thanks, Chair. I appreciate the accommodation.
Senator Pocock.
Why did Cairns not investigate Andrew Yates, Gary Wingrove, James Hunter and other senior leaders who were directly hands-on in the Tahi matter?
Senator, I believe none of those were engagement partners in the Tahi matter. However, the question you ask is one for the PCC, and I'm happy to take that on notice and bring that back to you.
Thank you. I've got further questions. Thank you, Chair.
Okay. You'll be able to put those on notice, Senator Pocock?
That will take me just a few minutes.
Okay. If you can think about cutting them shorter, I'm going to go to Ms Lawrence for a quick line of questions, and then I'll come to Senator Scarr, and then I'll come back to you.
Thank you.
Thank you very much. I too would just like to just pull back a little bit and just try to not look at each of the things we're focused on with relation to KPMG as events in isolation, but just to try to understand whether there's a broader pattern of system failure, culture failure and so on. So, Mrs Van Onselen, in 2021, when the KPMG board was considering Mr Andrew Yates for the CEO role, did Cairns have any active red flags or investigations into the audit division he led, specifically regarding the 2018 Star Casino risk reports? And as I understand, he was then the national managing partner for the audit through the 2018-2021 period, which oversaw the division responsible for Star Casino accommodating in the ignoring of money laundering red flags. So did you have any active red flags or investigations underway at that point?
I don't believe so, but I would need to take that on notice to check with our conduct team who has oversight of that.
And are you aware whether there was any probative review at the time of Star Casino's audit failures when they first occurred in 2018? And had there been, would Mr Yates have met the fit and proper threshold for membership, let alone becoming CEO of KPMG?
I'd have to take that on notice.
Thank you.
There's been no PCC findings or investigations in relation to that matter that I am aware of. So,
did Cairns initiate any investigations?
I'd have to take that on notice. That's 2018, did you say?
2021. Yeah.
So what we do, is, Senator, is we take an active and interventionist approach. So we take complaints from complainants, which can include government. We also review adverse court findings or adverse media, and will open and investigate those matters, as well as self-disclosures. So in that instance, I'm not personally aware of any particular adverse findings made in relation to those matters or self-disclosures. If they were, we would have taken it. We would have investigated. Right. But I'll just need to take that on notice.
Sure. And in 2024, you told the Chair, Senator O'Neill, that Cairns was monitoring the Platinum matter, where again there was the issue around the auditing by KPMG of the wrong company. Again, Mr Yates being the common denominator here.
Sorry, which company?
So for the Paladin.
Oh, Paladin.
Yeah. So just trying to understand there, given we're now dealing with a failure admitted by KPMG around a rigor deficit, Will Cairns now move to suspend KPMG's participation in professional standards scheme until a full independent audit of their culture is completed?
Cairns doesn't have the ability to ban a firm as a whole. Participation in the scheme is at the individual member level, and so there are a number of members at KPMG, all of whom are considered to be participants in the scheme. What we have got, and I'll pass to Ainsley to detail the approach we're taking in terms of assessing the firms and the audit divisions, in particular, compliance with confidentiality and other ethical standards, is a targeted review that's being conducted over the next quarter through to 30 September 2026. It is important to recognise that, as Ainsley has said, when there are matters that are raised either in the media or through court or regulator decisions, they are looked at. I do believe that the PCC looked at the Paladin matter and made inquiries, and it was confirmed that the engagement was in fact in line with the firm's representations, which was that it actually did a financial strength assessment on the entity that it had been directed to undertake.
So Cairns, just referring back to Senator Pocock's line of questioning, Cairns, as I understand it, failed to find professional misconduct in the Tahi matter, despite KPMG later admitting to complexities and mistakes. Does Cairns' definition of integrity allow for a partner to be pressured into changing a $10 billion budget report without it breaching your code of ethics?
Good question.
So, Ms Lawrence, or member, this is why in 2024, in our Going Further report, we urgently asked the government to clarify ASIC's jurisdiction to regulate audit firms and to
can I just ask,
legislation in the
but you have your
Corporations
own
Act
code of conduct. But
no, to clarify the enforceability of audit.
We'll speak to ASIC later this afternoon.
If you can cease for the moment. No, we're going to stop for a second.
At a firm
we're going to stop for a second, Ms Van Onselen. Do not speak for the moment. Okay. There is a direct question that was being asked by Ms Lawrence. She will ask you for further information if she wishes it. If you want to put further matters on the public record, you can do that after this inquiry, but do not speak over the senators and members.
Thank you.
And make sure that you answer the question that you're asked. Okay, can you restate your question, Ms Lawrence, and can you answer this question, Ms Van Onselen?
Thank you. Does Cairns' definition of integrity allow for a partner to be pressured into changing a $10 billion budget report without it being a breach of your code of ethics?
So, Ms Lawrence, if there was...
Yes or no? We don't have time for... You can add additional information, but yes or no?
If there's evidence base to find that with a judicial process or quasi-judicial process in terms of our conduct and disciplinary framework, then that would be a breach of integrity. At this stage, though, we have no evidence to substantiate what you're saying. But in relation to audit firms, which I think is the wider context of your question, that rests with ASIC. And that is why we have asked continuously for the Corporations Act to be amended so that ASIC can regulate firms. We are a private membership body with a contract with the individual, the member, and we can only activate complaints when they are received, of which the government is more than welcome to give us complaints, and we will review them and we will investigate them using natural justice processes, and we will provide an active and interventionist approach to those matters, which is why, combined, we have done more findings and sanctions than the TPB, the Tax Practitioners Board, and the Company Auditors Disciplinary Board.
So can I just, because we've got to throw back to some other questions, but if I can just
matters that come to our attention.
Come up at a very high level.
I've asked you, I'm reminding you not to speak over the senators and the members. We are short on time. Ms Lawrence, last question.
So still as a quasi-regulator, we have over a decade of red flags that have been well reported through the media that still enabled a person who was the head of an audit division responsible for these, be it Star Casino, be it Paladin, be it Tahi, and now Lendlease, to ascend to as CEOs. And throughout that entire decade, Cairns had no red flags that were, or initiation of investigations or self-reporting that enabled you to be able to demonstrate assurance that the leadership was acting with integrity throughout that period, and yet we've seen systemic failures across just those 4 examples, and yet CANS is completely comfortable that there's no change required within your own processes and accountability.
So we have information sharing powers with other regulators such as the TPB and ASIC. None of those were brought to our attention. If they were, we would have taken an interventionist approach and opened matters.
But you
and
do have powers of investigation under your own.
And investigated those.
Thanks very much.
Thank you.
I'm going to Senator Scarr.
Thank you, Chair. Kansas failed, hasn't it? I'm sitting here and I'm looking at a situation where we've seen what happened at PwC at the highest levels. We're not talking about junior practitioners. We're talking about managing partners, lead audit partners, people with great responsibilities as stewards of the profession, as keepers of the flame of that trust, which you spoke about, Ms Van Onselen. We had those awful revelations in relation to PwC, and now I'm sitting here looking at KPMG, and we've got Chief Executive Officer gone, Head of Audit gone, Chief Operating Officer demoted, sanctioned in their capacity as a Westpac auditor, lead audit partner for Lendlease removed from that audit, sanctioned, and the lead audit partner of Westpac sanctioned. Again, leaders of the profession. And I'm left here to reflect that Kansas failed. If you have senior members of the profession who are your members, senior members, bringing on the next generation, and these egregious breaches are occurring, and they're only disclosed because Senator O'Neill and this committee,
Years after the event,
took evidence from a whistleblower and used parliamentary privilege to put them in the public light. I'm putting it to you, Ms Van Onselen, that CANS has failed.
So CANS has done everything within its bylaw powers. In 2022, we went to our members and we reviewed those bylaws and had them strengthened. We increased fines by 5-fold. We introduced mandatory ethics training.
In 2022?
2022, and our members voted overwhelmingly.
So Ms Van Onselen, and what has happened? We're sitting here in 2026. Sorry, I'll finish my question. We're sitting here in 2026, and again, one of the top 4 firms. I don't know how many members you've got from KPMG as part of CANS. Chief Executive Officer gone, Head of Audit and Assurance gone, Chief Operating Officer demoted, Senior Audit Partners sanctioned, including on the Westpac audit, the lead partner in Westpac. It's failed, hasn't it, Ms Van Onselen?
I think the allegations are extremely concerning, and when we have a complaint...
Sorry, Ms Van Onselen, I'm sorry, Ms Van Onselen, I'm talking about the system, right? Because let me finish. You've been very vigorous in terms of offering comments whilst we've been asking questions. And I participated in this committee when we were looking at the audit and assurance profession. I disagreed with some of the recommendations of the committee in that respect.
You had reservations, but unanimous.
It was a unanimous report. I had some reservations.
Yep.
I'm now sitting here reflecting on the fact that even with your bylaw changes in 2022, the system's failed.
Well, Senator, what is extraordinary to me is that at the time these events apparently occurred, late 2023, we had a PJC inquiry into this very matter. We had a Senate inquiry into this very matter. We had PwC investigations underway in relation to somewhat similar issues. That, to me, suggests that it's broader than CANS and it's broader than any single entity.
Sorry, Ms Chapman, these are your members.
I agree.
These are your members.
Yes.
Your membership organisation. There should be a revolution in the streets. Every accountant who's doing the right thing who's a member of CANS. And I feel for them. And I want to get to the junior members. And Ms Van Onselen, you made some important points in your opening. But there should be a revolution in the streets. This has failed. Systemic failure in terms of regulating this important profession. Do you agree?
I don't agree that there's been systemic failure. What I do agree with is that this matter has come to light. There have been admissions made. So on the basis of the things that have come to light on the 24th of March, there have been admissions made and there are matters and investigations underway. as well as ASIC, as well as
Ms. Chapman, we're running out of time. I'll have a question to Ms. Van Onselen, but you gave us that great preamble about everything that was going on and how extraordinary it was that we're in this situation with KPMG after what everything happened with PwC, and then you say that you don't think there has been systemic failure because you're conducting investigation. It's not about the investigation, it's about the fact that there are past investigations, CEOs, managing partners all get paid out, they leave, whatever, the caravan moves on, the same thing happens. From my perspective, that's systemic failure. But I want to ask you, Ms Van Onselen, with respect to the younger members of the profession, and you made a point about your training as a young lawyer, and that training inculcation that when there's an inadvertent disclosure, you act, and you act immediately. What really troubles me about this is that, or one of the things, there are many things, you've got so many senior members of the profession. I mean, they're at the top of the totem pole. Yep. They should be the leaders. They are the leaders of the profession. Yep. And I read in documentation from KPMG when there was the intentional, it wasn't inadvertent, not like your situation, Ms Van Onselen, when you inadvertently saw a document. It was intentionally going out and cherry-picking a document from your client's confidential board papers to use it for another purpose, a collateral purpose. It was intentional, it wasn't inadvertent, and at the same time, I'm reading here that when Mr Rogers and Ms Laurie, apparently involved in another audit, were actually accessing this document inappropriately, there were other members of KPMG staff there, and presumably they were junior members. They were non-partners. They were looking for ethical guidance from seniors in the profession.
Well, they got guidance.
What hope do we have?
Was it ethical?
If you're getting such poor leadership to the new generation coming through the profession who are meant to be carrying forward that flame of trust in terms of audit responsibilities.
So, Senator, we saw from the Scarr report in relation to PwC what happens when profit is put over ethics. We saw that very clearly. You and I had a conversation back in October 23 about whistleblower protections for junior auditors and the
Correct.
urgent reforms that were required. I've been looking at this exchange that we had. It was almost identical to what we're looking at the moment, except perhaps not so junior, about why the ASIC Act and Corporations Act must urgently be... I'm answering Mr Scarr.
Do you endorse whistleblower reforms?
Yes, absolutely. That was in clause 5.4 of our Going Further roadmap, produced to this committee in 2024 and discussed in October 23.
And Ms Van Onselen, I remember that, and we did, and this committee has been passionate about protecting whistleblowers, and you recognise, but for the fact this whistleblower has done everything right from what I saw, and when we were initially contacted by this whistleblower, it had the quality of the disclosure just shone out to this committee. And so that decision was made collectively under the leadership of Senator O'Neill to make that disclosure, right? But this poor whistleblower, who's acting for them? Who's representing them? Where's their legal protection? Who's in their corner trying to navigate through this process? They're just left adrift, notwithstanding the fact that their disclosures have been materially in the public interest. Would you agree with that?
It's deeply disappointing. That's why urgent reforms are required, and we welcome Treasurer Molino's, or Assistant Treasurer Molino's recent announcement to review those whistleblower reforms that are required. This committee has done some great work. Your 2020 interim findings in relation to the improvement of audit quality, of which the 10 recommendations, 9 of which have not yet been implemented. We'd implore the government to implement those 9 reforms.
What about the 40 in the other report? I think that they're important as well.
There's many of those that that we are.
Can I just go to Senator? Thank you, Senator Scarr. Back to you, Senator Pocock, for a very short.
Yeah, I want to ask Ms Peterson some questions, but just before I do, you've belled the sin of PwC as greed trumping ethics in the use of confidential information to chase money. It is exactly the same sin we are now back here in relation to on KPMG. Ethics have fallen at the first hurdle where confidential information had the possibility of generating income. Do you agree with that?
I do agree. It's a basic principle of ethics to not breach your client confidentiality. It is 101.
But Cairns also, I'm with my colleague here, Cairns has failed to hold the profession, and it's the most senior levels of our profession, to a high standard of professional behaviour. You are asking the government to implement recommendations that are clearly on the public record through to very resource-intensive inquiries through this parliament. So let's not come back here again. But there are really significant questions here for you as the professional body. And I want to come to you, Ms Peterson. Cairns has had contact now through multiple whistleblowers to material issues across several areas of KPMG conduct. Exams, the Tahi matter, and now the current whistleblower in relation to confidential information. Cairns is responsible for maintaining those professional standards, including investigations, not just an obligation of your charter or bylaws, an obligation of your professional standards scheme, correct?
Correct.
Repeated failures by Cairns to act on credible misconduct allegations constitute a failure of professional oversight. Is that right?
No, I don't agree with that. I mean, we have over 140,000 members, and a large number of those members behave professionally, ethically and with integrity and very high professional standards.
And they must be out there today tearing their hair out watching this.
Because this is the leadership. This is the leaders of your profession.
And even the others, you told us they're not self-reporting. So how can you actually give us that assurance that they're all acting so ethically if the very senior people who are leading by example are not self-reporting?
I agree that the alleged misconduct would fall short of what we would expect as CANZ, but also all of our members. I mean, when you make a commitment to become a chartered accountant, ethics and ethical behaviour are one of the first commitments that you make, and they're the first training that you undertake. So our members expect us to...
chucked out the window as you start on the gravy train to make the money.
Can I just
I'm not finished.
Senator Pocock's question.
You use this phrase, fall short.
Yeah.
They have fallen short, as if there's some aspiration up here and we got to 90% of it. Why? And that is exactly the phrase that KPMG has used in much of its public statements. It refers to falls short. Can I suggest to you perhaps the better phrase would be egregious breach?
Or failure.
Would you accept that?
Senator, if you read in our transparency report that we published in December and provided to this committee in March, to answer your question, Ms Lawrence, the number of self-disclosures have rapidly increased over the last few years, which we are pleased by in terms of self-disclosing conduct or sanctions. But when we have evidence, Senator, we actively pursue it, and we do.
That wasn't my question. My question. Sorry, please don't speak over me, Ms Van Onselen, with respect. My question to Ms Peterson, what triggered me, was her use of that word "shortfall," which is exactly the same phrase that KPMG used. So I'm asking you, Ms Peterson, do you accept that perhaps a better phrase is alleged egregious breaches?
Well, we are deeply concerned and disappointed by these allegations.
The language gap is obvious. Go back to you, Senator Pocock.
Yeah, falling short.
Senator Pocock has the call.
Yeah,
and I agree.
Senator Pocock has the call.
Ms Peterson,
Senator Pocock has the call.
Ms Peterson, clearly Cairns is concerned about the fall short, a serious failure, well beyond falling short. Professor Lyon, I want to go back to him, is challenging your professional standards liability scheme in the Supreme Court in New South Wales as an individual and in the public interest. Are you aware of that case?
Yes, I am.
Are you aware that Professor Lyon is seeking a protective costs order given the public interest in the fitness and legality of your scheme's application to the Big Four? The argument here is the Big Four have a massive advantage through their participation in this scheme, which gives a massive and very cheap protection to a very large body of consultants. Ms Peterson, will Cairns be opposing Professor Lyon's protective cost order application, or do you admit that such an exam is clearly in the public interest?
I'll pass that response to my General Counsel, please.
Thank you. On behalf of the organisation, I can say that Cairns will be defending that application, and we don't agree with the tenor of the summons that has been filed, but we acknowledge the right of any individual to bring proceedings in a court, and we...
My question was, will you be opposing...
We will be opposing that
his use of
application.
Thank you. Thanks, Senator. Just if I can, to close off, I wanted to ask a question about APES 110. You're familiar with this weighty document? It's a critical document, isn't it, in terms of the professional standards, and it's the one to which every auditor has to comply.
It is absolutely, and through ASA 102, the independent standards within APES 110 are made statutorily binding on auditors in the conduct of an audit.
So for the non-lawyers, statutorily binding means exactly what, Ms Chapman?
It can be enforced by ASIC or another person under civil law.
If ASIC has oversight of that person?
Well, they have to be a registered, yes, as a registered company auditor or as a holder of a statutory registration, ASIC would certainly have that power.
Okay, and we are dealing with 3 disclosures from people who are of that status and involved with ASIC as well. But can I just draw your attention to how to use the code? There's a series of descriptions in here in the early pages up to page 7. It points out that there are parts in this document that are in bold type. I want to take you to R114.2, which is under subsection 114 in terms of confidentiality. It says, subject to paragraph Australia AUSTR 114.3, a member shall not, and there are 4 points there, shall not disclose confidential information acquired in the course of professional and business relationships.
It's very clear.
That is a breach of the code.
Correct.
Whether it has a material impact, whether the information is used or not used in some way, is entirely irrelevant. That code is breached the minute somebody has disclosed confidential information acquired in the course of professional and business relationships. Is that correct?
Correct, unless an exception applies or unless the client has consented.
Okay, so in the case of Lendlease, confidential information was acquired. The client didn't even know until my speech in the Senate. Is that a breach of standing order or R114.2 in the APES Code 110?
Again, working on the assumption that the PCC has to undergo a proper process to make that finding,
I'm just
I would
asking
say
you.
yes, absolutely. Absolutely.
B, the use of confidential information acquired in the course of professional and business relationships for the advantage of the member, the firm, the employing organisation or a third party. Members shall not do that either, shall they?
It's a very clear commandment.
Except we have seen that occurred. Members shall not use or disclose any confidential information either acquired or received in the course of a professional or business relationship after that relationship has ended.
Correct.
That has been breached.
I'm not sure if the relationship has ended. Again, that's a factual matrix, but this is entirely clear and entirely basic, as Ainsley has said. This is 101. Client confidentiality is at the heart of professional service provision. Client confidentiality is it's foundational. It is foundational to trust in audit and to trust in professional services. The client confidentiality provisions in APES 110, as you say, Senator, are really explicit and they are unambiguous. Where there is a right to use some professional experience, it's really clearly intended to apply not to specific client confidential information, but rather to an understanding of the sector. So, for example, if I take you through to 114.
I might just get you to put that on notice because we're well over time.
Okay,
finally, I want to ask, has Mr Yates self-disclosed to CANS?
I'm not at liberty to, as I said before, under our bylaws I can't tell you who has self-disclosed, but there is an investigation file on Mr Yates.
There is an investigation
file.
That's helpful. Mr McPherson, has he disclosed? You can't tell me. Is there an investigation file on Mr Julian McPherson?
Yes, there is.
Right. With regard to your evidence to me earlier in this session, Ms Van Olsen, you, when I asked you a question when you heard about the whistleblower matter for the first time, you said it was after my speech in the Senate on the 24th of March 2026. Can I ask you to have a really good think? Was there an occasion before that in a conversation with Mr Yates where he alluded to a whistleblower matter? Because you do see these people on a rather regular basis.
Yes, Senator, he suggested that in the text, I believe, of 14th of April.
Of which year?
Of 2026.
The 25th of March text.
Sorry, 25th of March text alluded to a whistleblower matter that he had referenced.
So let's get the dates right, because there's a lot of confusion here about who, not when. So the 25th of March, he alluded to what?
A whistleblower matter, or WB matter that he'd referred to last year.
Okay.
The only meeting
So hold on.
Yep, sure.
This year he tells you that he's referred to a whistleblower matter to you in 2025. Is that correct?
Correct, in a text, yes.
Okay. So when Mr Yates...
However, I have no notes of or record of any whistleblower matter being referred by Mr Yates to me in 2025 or otherwise. We had a meeting on, I believe, the 18th of December where the academic integrity artificial intelligence matters came up.
Not my matter. I'm trying to be really clear about the whistleblower. The whistleblower's active. You know, there's things happening in 23, 24. In 2025, Mr Yates says to you, oh, we've got a whistleblower matter going on. What was your response to that? You can't recall, is that correct?
Well, we had a telephone conversation with Mr Yates that day.
No, I'm talking about 2025.
There was no whistleblower matter that he raised with me, Senator, other than in relation to...
What's the last year reference then in that text?
So I have checked my records for 2025. The only meeting I had with him was in 18 December, individually as a KPMG person.
Why is he saying then the whistleblower matter that he discussed with you or he referred to, which occurred in 2025?
So in discussion with my colleague Vanessa Chapman after that phone call, we took it to be the anonymous sender of the email in early December in relation to artificial intelligence academic integrity matters, which was the only matter. It was also raised in your speech.
But you have two other items in your letter to us. Between July and November, a whistleblower approaches you. You believe that the 5th of March, looking at the same address of 2025, there's another attempt by the whistleblower. So let me be clear. July and November 2023, you get some information from a KPMG whistleblower who says, look, I think I've got some things I need to talk to you about. When the person does that, do they have to sign a contract with you that they will agree to your structures? Do they have to disclose their name?
No. So, Senator, I was corresponding with that person in 2023. The initial contact was to request some information about making a complaint under the bylaws on an anonymous or pseudonymous basis. And I explained that our bylaws don't allow for formal complaints to be initiated on an anonymous basis, and that's because a complainant has rights under our bylaws to see copies of all of the documents that a member might provide.
Right, so that's a frustration to the whistleblower, because they couldn't, as early as July 2023, the whistleblower was reaching out to CANS but cannot engage with you because of your current bylaws.
But we did say if there was any information that they wanted to provide on an anonymous basis and they felt that they had adequate protection to do so, that they could.
And we're going to come to protection in the course of the day, because this whistleblower has worked very, very hard to try and get protections and has been told no at every door. The first no I would put to you is because of your processes established for good reason, I'm sure, but in July 2023, that was the first approach by the whistleblower, who then approached you again in November 23 and again in March of 2025, same whistleblower.
The challenge, I think, Senator...
Sorry, I didn't answer to that question.
They didn't actually raise any specific issues.
No, they didn't, but they approached you and they sought information about whistleblowing, and they sought to provide you with information, some of which we expect is the matter that is now a public record and was discussed with Lendlease. The committee is running over time, and I will indicate that, you know, this is an initial hearing. We may have to call you back to consider further. I thank you very much for your attendance today, for your cooperation with the committee. The committee will now suspend for a short break and return with KPMG at, let's say, can we come back at 10 past or quarter past? Quarter past. Let's say Can we come back at 10 past or quarter past? Quarter past, 10:15. Thank you. I now welcome representatives from KPMG Australia and KPMG International, who I understand are now joining us by teleconference. Thank you for your attendance today. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you all. That's correct. Before I proceed, though, I just want to read some statements I put at the front of the day. I want to remind all witnesses that the giving of false or misleading evidence may be treated by the Senate as a contempt. And for ordinary people, that is, who watch television, a crime drama, the truth, the whole truth and nothing but the truth is the equivalent to not mislead the Senate is going to be very important in this inquiry. The committee also reminds all parties to this matter of the committee's commitment to Parliament's procedures for protection of witnesses. The committee emphasises that witnesses are protected by parliamentary privilege, making it unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee. Any such action taken against a witness may be treated by the Parliament as a contempt, and the committee will ensure that any such action is vigorously investigated and, if necessary, referred to the Senate as a potential contempt. So with those words and a very clear warning that the whistleblower's identity has been protected at every point, the whistleblower's identity must not be revealed inadvertently by anybody. So think very carefully about the language choices with regard to the whistleblower and be fully truthful in your responses to our questions today. For the Hansard record, would you please state your full names and the capacities in which you appear today?
Andrew Yates, the former Chief Executive of KPMG Australia.
Julian McPherson, the former National Managing Partner of Audit and Assurance, KPMG Australia.
And as we bring forward the other witnesses that have been called, we'll ask you to do the same thing. At the same time, can I thank you for providing a couple of opening statements that the committee has just received. If I can go straight to you, Mr. Yates. Could I ask you for your version of the events with regard to the whistleblower?
Yes, of course, Senator, and as you can appreciate, I've reflected on the events extensively, and it's a long series of events. So, in my mind, and this is the reflections that I've had in recent weeks, of course, I think across that passage of time, I felt at every point in time my team were conducting themselves in the right way. I felt that we were approaching this in the right way. I felt that the investigations were being conducted in the appropriate manner, and they escalated as we got more and more information. But on reflection, a lot of those things have not worked as I would have hoped they would have. You've quoted me many times, Senator, Chairman, and I've been quoted publicly many times about wanting to promote a speak-up culture in the firm. I certainly focused on that. I talked to the firm extensively about that. I was very proud of many things that happened in that respect. But in this case, we didn't get it right. I don't think we made the whistleblower feel comfortable through the process in terms of that whole concept of speaking up. As I've reflected on the things that led to me resigning, I think as the CEO, you are required to make the important consequential decisions. You make those based on the information you've got at any point in time, the advice you receive from inside and outside the firm, and of course your own experience and judgment. And as I thought back about this lengthy process, I felt that on balance those things had not gone right. And so as I think about the individual themselves. I feel that we could have made the process easier, and I also feel probably we could have made it a more humanistic approach.
Mr Yates, the whistleblower has suffered a horrendous personal, mental and career cost. And the phrase you use is he was not made comfortable, or he or she was not made comfortable. Do you think that is an appropriate description of the position that the whistleblower, who tried to do the right thing, going through your processes, going through KPMG's processes, going to the head of audit and assurance, and you're sitting here telling us, where we've had to, Senator O'Neill has had to give her speech on the parliamentary record to get any action on this, you're saying, on reflection, we could have made the whistleblower more comfortable. Do you think that's an appropriate description of the personal, mental, financial and career toll suffered by the whistleblower?
Senator, I'm deeply distressed to hear that that has been the impact on the individual, absolutely. And so that choice of words, it may not be adequate in terms of the context of the impact on the individual.
Sorry, Chair, to interrupt. I couldn't.
Sorry, but I'm very regretful that that has been the impact on the individual.
Thank you for your opening remarks, Mr Yates. And I do recall back in the 29th of May, you both quoted, Annie Yates said, "I have been committed to a speak-up culture in our firm. It's clear that in this case we have let ourselves down. And I take accountability with regard to you, Mr McPherson. Matters have arisen for which I am responsible and I take accountability." Do you take responsibility as well?
I do.
I want to refer to an article in the AFR by Edmund Tadros and Patrick Durkin. It's a recent one. "Cast the First Stone, Brambles Chair uses scripture to defend KPMG." Mr Yates and Mr McPherson, I imagine this article is not new to you. You're familiar with the statements. I think we can table the document for you.
Sorry, I'm familiar with the statements that the firm made before I left.
No, I'm referring to statements in defence of you by the Brambles Chair, who said that the KPMG's entire reputation shouldn't be tarnished because of bad apples, to carry the biblical allusions. Mr Yates, Mr McPherson, are you the bad apples?
In respect to that statement, Senator, I've not been reading the media for the last 3 weeks, if I can be honest, so I haven't
Well,
seen
we'll provide that to you. But, I mean, the argument that's being put is that, you two have been sacrificed, or you have stepped forward to take the blame.
Yep.
But everybody else at KPMG, they're all hunky-dory, they're all good, they're fine. You're the bad apples. The question is, are you the bad apples, or is the whole barrel rotten? What's going on, Mr Yates?
I don't see myself as a bad apple, Senator. I see someone as took accountability for things that went wrong, and nor do I see the firm to be full of bad apples. We're a large, complex organisation, and we're fallible.
Let's go to the complexity of the organisation. Could I table Section 12 of the New South Wales Partnership Act? And Mr Yates, there's a little part of it there that I would like you to read for me when it gets into your hands, and that is paragraph 1 of Section 12 of the New South Wales Partnership Act. And
sure,
I'll return to that very shortly. But what is your understanding about partnership structure and the responsibilities that your partners have alongside you, given that you have stepped down as a CEO and have admitted failure in your leadership? How much responsibility do your partners share in this with you, technically?
I don't know the answer to that, Senator. I think obviously...
Really?
Well, we're joint and several in terms of a partnership.
What does that mean? Okay, so don't play with me here, Mr Yates.
I'm not,
right?
Senator.
I don't know the answer to what a partnership means when you lead one of the biggest partnerships in the country, designed and organised in such a way to allow up to 1,000 partners, and you've come in here and said, we're not bad apples, and in addition to not being bad apples, everybody else at KPMG is pretty well clear. I'm putting to you a very different proposition.
Senator,
what does it mean to be a partner?
Senator, with respect, you asked me if I'm a bad apple. I don't believe, across my career of 36 years, I was a bad apple. Nor do I feel that KPMG is full of bad apples. I'm incredibly proud of the 9,000 people that work at KPMG, and it's been a big thing for me to resign and leave an organisation that I joined in 1989. The concept of a partnership is, we're in things together. And that has always been the way that partners have operated. But the technicality of your question, Senator, I think I'm not quite grasping.
Okay. Could I go to a document that I think does reveal something about the nature of my concerns about the way you're characterising your responsibility? And that is a document which is an extract from materials provided to this committee by the whistleblower. Could I ask for that extract to be given to Mr Yates? There's a pile of red folders with documentation in. It's missing?
Behind you.
No, there's a big folder with things to be tabled. It was here just before the break, pretty sure. No, that's not it. That's APES 110. So I might need to get my staff to come and find the two folders that they prepared that seem to have gone missing. No, that's not in the break. I'll get them to come back. Can I go perhaps to you, Senator Pocock, while I locate those documents?
Thank you. You just gave the answer, Mr Yates, that in a partnership we are in things together. Explain a little more about what that means in the context of the very serious, egregious uses and sharing of confidential information, the cheating on exams and the many issues that the whistleblower and whistleblowers have raised. How does that, you are in things together, how does that translate when things go wrong? You share responsibility is the suggestion I would make.
Well, Senator, I think the very fact that I have stood down and have resigned from the organisation means that despite the partnership being a concept where, you are partners, there are degrees of accountability within that. And I took that accountability. In terms of some of the matters you raised there, the vast majority of partners were not involved in any of those issues.
But the vast majority of... How many partners are there in KPMG at present?
There's about 680, Senator.
680.
Yes.
So you are not in a corporate structure where the CEO resigns and has responsibility. This precisely goes to the question about structure and responsibility. You're in a partnership with hundreds of partners, but it's a partnership where you jointly and severally have responsibility for decisions. Decisions have been made repetitively in relation to whistleblowing alone, which have been extremely damaging to the whistleblower and to accountability across our capital markets in terms of its implication for trust in audit. You share responsibility with your partners, do you not?
As a CEO, Senator, I take the bulk of the responsibility. The structure of our firm is that there is as you are aware, an appointed board which has independent members on that, and they appoint the CEO. And with that comes a degree of accountability and responsibility, which I think is more than other partners that sit within the firm.
So you're describing a structure which is much closer to a corporate entity. Is it time that partnerships like KPMG were covered by corporate law?
Senator, there is no doubt that partnerships of this size have moved from a governance point of view to try and be more reflective of what you'd expect to see in a corporate structure. That has been the way that, you can't have every decision, for example, in a partnership of our size being voted on by 680 partners. It's just impossible for that to take place. So over probably 20, 25 years, the way that our firm has started to make decisions and run itself, and this has been outlined in a number of public documents, has tried to be akin to the way that a corporate would seek to run and govern itself.
And isn't it time that your structure now reflected that reality?
I can't comment on that, Senator, because I know that's a topic that has been
Well, you're here as a witness, and we're asking, you've got how many years' experience?
Yes.
38?
Yes.
You are in a position where you are leading in a way that a corporate CEO does. You have taken the fall, and you are here post that experience.
Yes.
What are your reflections on structure? Please answer my question. Is the partnership structure now non-functioning in this circumstance? And we are here the second time around. PwC, now you.
Yeah, Senator. I think where I'm struggling to answer that question is I don't know the mechanism by which it can be done to move from a partnership to a corporate. I do think, personally, now that I've left the profession, that partnerships of this size, I think, bring some fantastic benefits in terms of the way that people work together, but they are challenging in terms of the management. Whether they should be moved to a corporate structure is genuinely, I think, something that the regulators and legislators
Have you done any modelling? Did you do any consideration before you resigned on changes in structure?
We did, Senator. We did that as part of the process.
Can you provide that on? I'll ask your successor to provide that.
If I could be clear, Senator, just on what I'm referring to there.
Yeah.
We looked at, as we were going through the process with you and Senator O'Neill 2 or 3 years ago, we did look at, well, what structure do we have now? What are the alternatives that might be possible? What would a mechanism look like to get from one to the other? That was the extent of the modelling.
So here we are, and you've appeared before us in the PwC matter.
Yeah.
At the time the PwC events were unfolding, you appeared before us.
Yes.
And you did not give us any information. You were not forthcoming about matters which were clearly known to you at the time that affected the ethics within KPMG. Why did you not signal to us any of those events which clearly parallel what was underway in PwC?
Senator, my recollection there is that last time I appeared before this committee was that committee was February 2024. We had a long conversation at various times about the way we treated behavioural issues in the firm, how we reported those. In terms of the specific questions that we're here to discuss today, I'd have to go back and check the record, Senator.
Did you have any
I'm not
knowledge
sure.
at that moment of any whistleblower? Clearly, I believe you did, but did you, please inform me, at that time have matters underway in relation to allegations of unethical behaviour within KPMG?
Senator, we've had a whistleblowing policy and
I'm not asking about your policy.
No, I'm getting to the point that I'm trying to answer, because I'm trying to distinguish, I'm trying to understand your question, whether you're asking about specifically the issue that is being discussed today or more general.
Okay, it's more general. I'm asking about the question, did you have knowledge of allegations by whistleblowers within KPMG of unethical behaviour when you appeared before the Senate?
Senator, I genuinely can't recall what I was aware of, given I appeared in the middle of 2023 and I think the last time was February 2024. I was aware, and I think we discussed it in the committee sessions, of issues that we would deal with in the firm around behaviour, around ethical behaviour, and I was aware, of course, in general, of issues that we were dealing with. I cannot remember those specifics.
Did you sit there, Mr Yates, and think, PwC are in the spotlight today, but I've got matters in my backpack that I should be bringing forward that are of similar nature?
Senator, my recollection of that period of time was there are many things that I had to answer on behalf of KPMG. I don't think that I came into any of those sessions not willing to talk about the issues that you were putting to me at the time.
Let's come to that. But we heard in the session just before about PwC. PwC's primary sin, and there were multiple sins, but the primary sin was to use information provided confidentially in pursuit of economic benefit, so that the business model of PwC trumped ethics at the first hurdle. That is exactly the same issue in KPMG, is it not? Do you agree?
Senator, there has been inappropriate sharing of information. The firm has conceded
I'm
that.
asking whether ethics were trumped at the first hurdle in pursuit of revenue.
I don't believe that is the way the firm operated, Senator.
In this example, how is that not what happened?
It's a very long and complex situation, and there's many parts to
I think for the average
winning.
Australian, and there are some in the room, it's not that complicated. Information was accessed which may potentially have assisted a winning of further audit of business for KPMG. That's a simple proposition. Most Australians will understand that. That is what was happening here, is it not?
Senator, I think what was happening here was perhaps some misunderstanding around what was KPMG IP as a general point. In respect of the Lendlease matter, I think that was an inappropriate sharing of confidential.
Sorry, what was KPMG IP?
The sharing of KPMG documents.
This was sharing of other, not your documents.
No, I'm saying, but some of the issue was sharing of KPMG documents. The sharing of the client document was inappropriate, and that has been made clear.
And that is proof point, is it not, that these were senior people who leapt over any ethical consideration in pursuit of information that would assist revenue in KPMG. Is that the case? Just yes or no?
Senator, I think it's more complicated than that, and I think those individuals made serious errors of judgment. They have taken accountability. They've self-reported themselves for those issues.
Do you agree with the perception that what you have done here, what your firm has done here, is exactly the same as PwC in concept? That is, pursuit of revenue where ethics have failed. That was PwC's misdemeanour. One of its misdemeanours. It is clearly one of yours. I've asked you, do you agree, yes or no, with that statement?
I can see that would be the perception, Senator, which is, I think, what you asked then, yes.
Thank you. I want to go to...
Before we jump off that, can I take the call back to follow on, and
Sure.
I'll come back to you.
Thank you.
Mr Yates, the Secretary will provide you now with the statements that I was seeking from the Partnership Act, if you can provide that. So most Australians happily don't need to know what joint and several liability is. It's a pretty technical term for most people, but for you it's core business, I would put it to you, and that you should know exactly what your partners are doing. Could I just ask you to read into the record item 12.1 to start with?
Yes, Senator. So section 12 is titled Liability for Wrongs, Joint and Several, and clause 1, every partner in a firm other than an incorporated limited partnership is liable jointly with the partners, co-partners, and also severally for everything for which the firm, while the partner is a partner therein, becomes liable under either of the two last preceding sections.
Okay, in your own words, what does that mean? This is the law from New South Wales, because partnerships are governed at state level. This is the law. What does that mean for you as the CEO? Which is a term more akin to corporate entity. You're the big partner. You're the senior partner. Is that correct?
I was the CEO, Senator, yes.
Yeah. What does that mean in terms of the partnership, though? You're the top dog partner. Is that right?
I always am conscious of not getting into semantics, Senator. But
we do need to get into semantics, because there's a whole lot of semantics that are being claimed in your documents that are kind of important. So. People don't understand what goes on in these places, Mr Yates. We're here for the Australian people.
I understand that.
But there's a whole lot of partners. Are you the boss of the partners?
Yes, the naming convention within KPMG is the senior partner in our world is the chairman. I'm the CEO.
Okay, that's fine. So you are the senior partner, the one with ultimate responsibility.
Yeah.
What does what you just read to me mean in terms of all of the partners?
That we are liable for things together as a partnership. That's the essence of a partnership.
Everyone gets to share in the profits, and everyone gets to share in the pain.
The profits are shared relative to, tenure and so forth of partners, but it's not perfectly equal, Senator.
Yeah, but you don't miss out. If you're a partner, you get a share of the profits. That's how it works, isn't it?
Correct.
Right. So all of these.
You get more audit jobs.
Yes. So everyone who's a partner. And that's a distinction from other people who work in other capacities in the organisation. Everyone who's a partner is responsible for what is being discussed here today. They cannot separate themselves because by law they have to adhere to what's just been read into the record by you yourself as the senior partner who calls yourself, according to convention, the CEO. Exactly.
I just need, Senator, I am no longer within the firm, and I do think this is a question that it would be appropriate for someone for the firm to respond to, because I
You've only been out a few weeks, Mr. Yates. Have you forgotten what your responsibilities as CEO were?
No, Senator, but you're taking.
I think you're capable of answering the question, Mr. Yates.
Senator, you're taking me into an act here, Parliament. I just think it's appropriate that if the questions are being asked there that have a legal element to them, I think it would be appropriate that someone from the firm was also responding to that.
Well, I'll put questions to them as I see fit, and if you wish to add further information to the committee, I invite you to do that on notice. Can I go to you, Mr. McPherson? We're having just discussed the absolute connection between the partners. You were a very senior partner before you stepped down in the period after my speech to the Parliament. Mr. McPherson, in your partnership relationship with Mr. Yates as the senior partner for KPMG, how much information do you need to share to fulfil your responsibilities as a partner?
In the context of my day-to-day role, Senator?
How does it work?
Well, I am a member of the I was a member of the National Executive Committee, which contains representatives of the senior partners that look after the various divisions of KPMG and the business enablement partners, and we have discussions in that context around the operations of the firm, the strategy of the firm, and any other matters pertaining to the running of the business.
Okay. It's pretty hard to communicate with. How many partners were there when you left your role, Mr. McPherson?
I refer to Mr. Yates's answer. I don't want to mislead you. I don't know the answer to that.
It's in the order of 700 people by public
that would be
report.
right.
I think it's 680.
Yeah. 680. Okay. So it's pretty impossible to do the task that you've just described as your role for 680 people who are joint and severally liable with you. That is one of the big problems that we're facing here, isn't it?
Well, the way that we structure the firm, Senator, is we have divisions, and I was the National Managing Partner of the Audit and Assurance Division, with around about 100 partners that are ultimately part of my division. So each of the divisional NMPs will be responsible, obviously, for cascading information or directing the partners around, strategy and
can I add something?
Yep, sure.
Just to explain how that we would communicate to the whole group. So Martin and I, when I was with the firm...
Mr. Shepherd, the CEO of the board?
Mr. Shepherd, the Chairman of the board.
Chairman of the board,
Sorry, Senator. Yep, Mr. Shepherd. He and I would do a quarterly road trip around Australia as well, where we would communicate directly with all the partners. That was how we managed to do that.
So trying to communicate with all the partners is a challenge. You undertook that in that method that you've just discussed, but backwards and forwards there's communication going on all of the time. Mr. McPherson, how would you describe your communication with Mr. Yates, given the significant role you have with regard to audit? Okay, not the consultancy arm. Audit, the bit that is so fundamental to the proper functioning of the markets and investment decisions being made every day by ordinary Australians and trustees acting on their behalf. Characterise your communication with Mr. Yates for me.
So I would have set regular meetings with Mr. Yates, which would either be fortnightly or monthly, depending on the cadence of where we're up to in the year. I'd also participate, obviously, regularly in the National Executive Committee meetings, which, if they're not weekly, they're at least fortnightly, and I would speak to Mr. Yates on an ad hoc basis as necessary, depending on whatever issues of the day are at hand.
Can I add something to that, Chairman? Because the way I would characterise that is we have a structured way of interacting with each other where we meet regularly, but with each of the direct reports, when I was a CEO, we'd speak, sometimes daily on different issues. So there's many, many different ways that communication took place.
That's the cadence that Mr. McPherson was referring to. Okay, so given that, I would like to put in front of you a document that I know was provided to you, Mr. McPherson. Could I ask for this to be given to colleagues and also to Mr. Yates and Mr. McPherson? Thank you. This is one section, part 10 of a larger document provided to this committee by the Whistleblower, and it is a document that was provided to you as a letter form, of which this is a part, Mr. McPherson.
Thanks.
On the 30th of May 2024. Now, the letter's long and quite extraordinary. I've only selected one part of it. Mr. McPherson, could I ask you to it's only one paragraph, but it's a pretty long one, it's an important one. Could I ask you to read into the Hansard record and put on the public record, this is the whistleblower's version of observations around ethics, integrity and culture, which you received on the 30th of May 2024 in what the whistleblower provided as a disclosure document to you. Mr McPherson, could you read this, please?
Would you like me to read the whole piece?
Yes, please.
So it's titled Ethics, Integrity and Culture. In my role, I have a deep understanding of what is going on within the audit practice. I work with multiple partners, identifying and pursuing new business opportunities, and I work with multiple partners on the commercial operations of our business, i.e. setting of fees, negotiations and process improvements. Through this, I have seen a number of actions taken by individuals that are quite clearly not up to the ethical standards of KPMG or the isolated incidents.
Or the expectations?
Sorry, I missed a line. Apologies. Let me just reread that sentence for you. Through this, I have seen a number of actions taken by individuals that are quite clearly not up to the ethical standards of KPMG or the expectations of regulators, governments or the public at large. These are not isolated incidents, but instead endemic within the organisation, whereby profit and revenue growth is placed above everything else, including integrity, people, well-being and fundamentally doing the right thing. Some of these incidents involving current KPMG partners and ex-KPMG partners I have personally witnessed. Others I have seen evidence of and have led to significant commercial outcomes for KPMG, but raise serious questions about what lengths the business is prepared to go to achieve growth and profit. As a consequence of witnessing some of these actions, and in some cases questioning them, I have faced further marginalisation and retaliation as a consequence of what, in my view, was acting with integrity and raising genuine concerns that I have over things like conduct, well-being of team members and matters of ethics and integrity. Again, I have spoken with you at length about some of these and of certain individuals' insecurities and retaliatory natures, and as discussed, as a consequence of raising some of these concerns, I have been retaliated against. We discussed this in our meeting on the 4th of April 2024. You have commented to me on several occasions that there is a culture of retaliation, and even went so far as to warn me about this on Saturday the 28th of October 2023. The lack of speak-up culture, the culture of fear, retribution and revenue growth at all costs is not acceptable. Whilst I regret the role that I have played in this to date, I have learnt that personal prospects, promotion and income should not warrant turning a blind eye and not speaking up louder sooner. I can no longer stand by and watch this happen, and absolutely feel that I have done the right thing when raising some of these concerns. It is KPMG's toxic culture and its thirst for improved partner remuneration at all costs that have resulted in them not being listened to or acted upon. It appears to me that certain partners at KPMG and some retired partners have forgotten that they ultimately serve the public interest and those of shareholders, and they have not conducted themselves properly when involved in large ASX-listed audits contracts. In my opinion, it is unacceptable to be retaliated against for calling some of these actions and behaviours out, but is instead an obligation of all KPMG employees around the world.
You must have had a visceral response to that when you received it, Mr McPherson. Can you recall the 30th of May 2024?
I don't recollect my exact feelings, but I'm sure I would have felt surprise and shock at receiving reading that paragraph.
And on receipt of that paragraph, Mr McPherson, we've just heard about your cascading flow of information. We've just heard about your daily, if necessary, interactions with the senior partner, Mr Andrew Yates. Did you bring this matter as written to the attention of Mr Yates?
Well, can I just provide some context to the...
Could you answer that question first?
So I don't actually recollect when I spoke to Mr Yates about the matter. Can I talk about my initial response, Senator? Because I think it's important to give that
I guess
context.
I want to say, if that letter arrived, what
most Australians would go, it would be, oh, this is like way beyond the pale. We've got an emergency here. I need to ring every bell. I need to make sure that everybody is aware that this is a big problem. And the first person that you would go to in that circumstance would normally be whom?
Well, for context, the email or this disclosure was made as part of a very lengthy email.
Yes, I know. I've read the whole thing.
We've got it.
We know the context
no,
of
I was
this
just explaining the context as to how I reacted and what I did, just to provide the committee with information around that.
Who did you talk to about it, Mr McPherson, and when?
So I spoke to our office, representatives of our Office of General Counsel and our P&I or HR division, because I recognised that there was serious allegations raised, but also as part of
so let me be clear, because lots of people don't understand what Office of General Counsel means. So the first thing you're telling me, correct me if I'm wrong, the first thing you did was you went to the lawyers who manage KPMG for you, for the expertise of your Office of General Counsel. Is that the first thing you did?
The first thing I did was speak to our HR team and then the lawyers.
Okay. And the HR stands for Human Resources, which is a managing your staff entity within KPMG. Is that a fair description of what HR does?
Just for clarification, at KPMG we call HR People and Inclusion. I'm
sure that's very comforting to the whistleblower. So, but I thank you for the correction, because we do want to be accurate about this. But I'm a little shocked that the first person you went to was Human Resources, which is often, people know, a way of managing people with a problem out. Okay, so my first thing is, God, you looked at this and you went, oh, this guy's a problem. When I'm looking at this going, our culture's a problem, right? That's how I'm reading quite differently.
Senator, my reaction wasn't this guy is a problem. My reaction was that this disclosure that was made was part of a very lengthy email which contained a number of issues which have been raised around workplace matters, as well as the ethical considerations, which I took very seriously.
Okay, great. So we've got it so far that you've gone to HR, you've gone to legal. When did you go to the senior partner responsible for KPMG Australia?
I don't recollect when I spoke to Mr Yates about it, because
let's go to Mr Yates. So you've heard this. What's your response to hearing it again today? I'm assuming you have heard it at another point of time.
Oh, Senator, look, as a general point, part of the reason I resigned from the firm, Senator, is that these things we didn't get right. So
but when did you resign, Mr Yates? Let's get the date for that on the record.
I think it was the 27th of, where are we now? 27th of May. I think it was the Wednesday of that week.
I think it might have been the Friday when we're actually having the ASIC hearing, so it's probably the 29th of May. You may have been engaged
That's not when I resigned. I resigned 2 days earlier, Senator.
Okay, so it became public on the 29th, but it...
Yeah.
Right, okay. So the 27th of May...
And in fact, verbally, I don't want to get into the...
I want to get the years
dates,
right.
But verbally on the Tuesday and then in writing on the Wednesday. So that was how I did that.
Okay. So the 27th of May 2026...
My recollection of this period of time, Senator, was that the way that this was... And the way that these issues would come to me, as I said earlier, was either through the normal sequence of meetings that we have or through general, daily interactions.
So was this normal?
There's nothing normal about this, Senator.
Okay, so it didn't come through the normal channels?
What I'm trying to say is that my recollection of this period of time is that these issues were presented to me in the context of the employment matters.
We know that you're focusing on the employment matters. I'm focusing on the ethics, integrity and culture, because that is the part that we are interested in.
I understand that. And the best of my recollection is...
Date.
Through that period of time, up until the date of the document that was discovered on the 21st of November, I think, is the case, that this was in my mind, the way that I would talk to the team about this was about the employment elements of the challenge, and I could see that it was escalating from an anxiety point of view over that period of time.
So let's just go to the 30th of May, the day on which you received this, Mr McPherson. What day did you go to HR and legal? The same day or that week?
My recollection is that I read the email in the evening and I spoke to the P&I and OGC team the following day.
And when did you speak to Mr Yates?
I don't recollect when I spoke to Mr Yates about this issue.
Did you speak to him at all about this issue?
I'm sure I did. I just don't recollect the exact date.
Okay, so can you, I won't hold you to this, and if you can go back and check your notes and find the accurate date, that'd be great. But was it a day? Was it 2 days? Was it a week? Was it a month? Was it half a year? How long before you showed this to Mr Yates?
I don't recollect. It wasn't immediately because, as I said before, the context in which I read the email and responded to the email.
You said it was a HR issue. Okay, we understand that. But I want to know.
Yes.
I want to know from both you and Mr Yates, without qualification, how long after you got what you just read into the record did it take you to get to the door of your senior partner, entitled the CEO, and tell him these are serious matters of ethics, integrity and culture? You need to be aware of this.
I understand. I honestly don't recollect the date of that, Senator. I don't want to mislead you. I do not recollect when I had that conversation.
Days, weeks or months?
I don't recollect.
Very interesting. What was your salary as you departed, Mr McPherson?
Sorry, can you repeat the question?
What was your salary as you've departed KPMG per annum?
It would have been, well, the salary hasn't yet been determined because the determination will come following the year-end assessment process, and obviously I've stepped down from my role. So
let's just go for last year, which is a clear number.
I can't remember the precise number, but it would have been in the range of about $1.7, $1.8 million.
Okay.
In total?
In total, yeah.
And that includes your partnership draws?
Yeah, that's the total of my remuneration.
So that's a pretty high pay to do a very important job. I think if you were fulfilling that, you would have got to Mr Yates pretty quickly. Mr Yates, help your partner out here. When did you get this document that's just been read into Hansard? When did you receive that?
Senator, I don't recall receiving it in that context.
Have you read it? Or is today the first time you're hearing this, Mr Yates?
It's not the first time I'm hearing it, Senator.
Okay, when did you receive this?
I cannot recollect that, Senator. What I recall of that period of time, to the best of my recollection,
which is May and June 2024. This is the 30th of May disclosure.
Right through June. Sorry, right through 2024. Was that the way that I was hearing this issue from different members of my team was focused more on the employment matters.
We've got a HR problem. This wasn't the priority for Mr McPherson to give to you.
I can't comment on that, Senator, but my reflections of the time and the way the information was coming to me was in that context.
All right, I've just got a short line to finish here and then I'm going to share the call and come back again. But can I just go to what happened next? So this is the whistleblower's account. You know, I think the whistle's well and truly blown. Let's be clear, the whistleblower struggles to this day, well, until actually your resignation, where there's a description of that person as a whistleblower, to be entitled protections as a whistleblower. They fight and fight and fight on, I think it's 20 to 22 occasions to try and give evidence to back up this initial disclosure of the 30th of May 2024. And every time they show up saying, I want the protection of being a whistleblower under the Corporations Act, they get this fuzz response. We can't help you, it's not with our policy, blah, blah. It goes on and on and on and on. But this was the initial disclosure. What happens after this? Now, you can't recall, Mr McPherson, if you spoke to Mr Yates. Mr Yates can't recall when he received it. But I can tell you from your documents that you provided to the committee that either your HR department or your Office of General Counsel directed a search of the computer of the whistleblower. Do you know what date you gave that action was undertaken by your team at KPMG?
It was my understanding was sometime either in late October, maybe I think it was November.
I'm sorry, that's not what your document says. So your document that describes what happened was after this disclosure on the 30th of May, there was a search of the whistleblower's computer IT system on the 30th of May and into June of 2024, immediately. Immediately, no doubt about it. That's in your document. Then there was further searches undertaken on the 21st and the 26th of November 2024. Does that accord with your
Senator,
memory?
just to clarify, the search which occurred in May happened before I received the email from the individual. It did not happen afterwards.
So the search date in your document is the 30th of May and June. The document you received, the disclosure that you've just read paragraph 10 of, was received on the 30th of May. So you might need to check your memory on that, because that's what your own documents tendered to the Senate say.
Yeah, but Senator, my understanding is that search happened earlier in the day. It happened before I received the email.
Same day?
Yeah, the search occurred.
Okay, so the sequence matters to you for some reason. I'm not quite sure, but it's happening on the same day. So if we can leave that for the moment.
Sorry, just on that.
Yeah, how about we go to a question from one of the colleagues. I'll go to Ms Lawrence for one quick one and then I'll come across the table. Okay. Thank you. Ms Lawrence.
So can I just get clarification as to who specifically authorised the IT department to covertly access the whistleblower's laptop? And was it intended to verify the allegations, or was it to identify a source of leak or to silence him?
The search which occurred early in the day on the 30th of May was around, I think, with my best recollection was that it was authorised by me, and it was in the context of us being concerned that the individual might be seeking other employment, and we were concerned about whether information from KPMG might have been shared outside of the organisation.
Concerned about your own information, but not Lendlease's.
Sorry, colleagues. I know that there's outrage here, but let's just get everything on the record.
Just gobsmacking.
Yep. Continue, please, Ms.
Sorry,
Lawrence.
yes.
Thank you for your answers.
So you've clarified that you authorised it, and appreciate there were a number of times that you covertly searched his laptop. So on each of those occasions, did you authorise each of those occasions, and was the purpose changed? So initially you're saying the first one was to see whether he was applying for a job and potentially using KPMG's information, but the subsequent ones, was it what was the purpose?
Just to clarify, I wasn't searching to see whether he was applying for another job. I was searching to see whether there was KPMG information which was being taken outside of the KPMG organisation, which no one is authorised to do.
And used in a different context.
Yeah. No, that's understood. And the subsequent one?
And the subsequent searches, I can't recollect who authorised the searches, but those are in the context of trying to understand and investigate the allegations which have been raised by the individual.
Okay, can I just ask for the Secretariat to provide the document confidential KPMG? This is a document from you to the committee. Can I ask you to provide this?
So just to follow up to just why that's delivered, was the board aware that you had authorised the surveillance, and did they make any intent to intervene in that process?
Sorry, do you mind repeating the question? Sorry.
Was the board aware that you had authorised the surveillance of his laptop, and did they make any intervention or express any concerns around duty of care in your action to do so?
Not as far as I'm aware.
So the board wasn't aware? And we'll ask the questions of them too, but had you advised the board, or Mr Yates, did you advise the board that this person at this time, who wasn't declared a whistleblower by your own definition, but that you were surveilling his equipment? So the board wasn't aware that you were doing that?
I didn't advise the board.
And Mr Yates, you didn't?
I wasn't aware.
Could I take you to the document that's in front of you now, point 10? The title of this is your document to this committee.
Yep.
Where you call it a statement of facts. I call it KPMG's version of reality. Negotiation of deed of release and separation in November. So this is what's going on in November 2024 for the context. It says from 22 November to 28 November, without prejudice, discussions and communications occurred between the former employee and KPMG relating to a deed of release. The deed of release was signed on the 29th of November 2024, and we'll return to that later in the day. And then it follows by point 11, the 21 and 26 November allegation documents. Could you read 11.1, 11.2 and 11.3 into the record, please, Mr Yates?
Yep, certainly. So 11.1. On 21 and 26 November 2024, 2 documents prepared by the former employee were identified by KPMG's IT team's search of KPMG devices at the instruction of the OGC.
Which is your in-house lawyers? Yep.
In brackets, the 21 and 26 November 2024 allegation documents, close brackets. Those documents contain further detail of allegations that had not, at that point, previously been raised or disclosed in that level of detail by the former employee. 11.2. The 21 and 26 November 2024 allegation documents set out allegations relating to various issues including exam cheating, the practice of power mapping, breach of confidentiality and issues related to KPMG's participation in several audit tender processes.
And at 11.3.
Oh, sorry. OGC provided a copy of the 21 and 26 November 24 allegation documents to the KPMG CEO, copied to a KPMG employee and senior partners in the audit and assurance and P&I teams.
So you received documents from inside the whistleblower's laptop or computer on the 21st or shortly after the 21st and the 26th of November in that period of time. It says here, Mr Yates, that you received them, KPMG CEO, right?
Yes, I did.
Okay. So on receipt of those documents, which we have also seen, how did you communicate this to your 680 partners? Because it's pretty serious, isn't it?
Well, Senator, one of the challenges I found through this entire process was attempting to treat the individual as a whistleblower to protect their anonymity, their identity, and so the issue itself was contained to a very small number of senior partners involved in the process.
Okay, so I hadn't
seen this, Senator, as something that I should communicate to 680 partners for all the reasons that you have warned me about at the start.
Rule that out. They're not going to the partners, but there's a group of people at the top who know about this stuff after you get the document.
Yes.
Okay. Did you then think, I better alert ASIC to this?
Not at that point, Senator, because for a few reasons. What I needed to do, which I did, my recollection of this period of time, I was on leave the week before. I took a phone call from OGC, from James and Lee's, alerting me to this document. I came back to the office on the Monday and our initial investigation commenced on that day. The allegations were, even on that point, were still general in nature.
Yep. But remember, you've got the 30th of May communication to Mr McPherson.
As I said, I had been looking at this issue.
Yeah, exactly.
Understanding
So
this
it's
issue
not all new to you
issue.
at that point of
so
time.
It's for me.
So you already know. You know from 30th of May, you've searched the documents in the whistleblower's folders. You found stuff. It's escalating pretty quickly, but you're still not reporting anything to CANS. You're not reporting anything to ASIC, and you're clearly not advising your partners that you've got a big problem, and nobody is aware of the item 10 in the declaration that was made.
And they're negotiating a deed of release, putting all the pressure on the whistleblower to negotiate a deed of release that's going to compromise her financial future.
So
I will very happily put some context around that, Senator. But in terms of your question, as I said again, Senator, I did not feel that this was an issue at this point in time that I should share with 680 partners. Yep. I'll come to the regulators in a second.
Yeah, and that's part of the partnership problem, right? Okay, because if you had an executive that was just responsible, you could contain it to them and it would just be the executive. But the structure that you have means everybody's responsible for everything that you do jointly with you.
I didn't share this with my entire executive for the very reason that you warned us about at the start of this session. We did not want to breach the identity of this individual. And Senator, I felt that by doing that all the way through this, that underpinned some of my communication. And it got to the point of when I did start to talk to people outside the organisation, I found that I had to do that in a way that was quite general because I didn't want to reveal the nature of the identity.
So when did you start, sharing this information? Like, did you have a conversation? I mean, how often do you see the head of Lendlease? You operate in the same building. Do you ever run into, Mr Lombardo casually? Did you ever say, oh, and by the way, we've got this whistleblower matter that we're looking into?
No, and I think it's on the public record and in letters that have been submitted to this committee. I spoke to Mr Lombardo in May.
Of which year?
2025, so last year.
Yep. So a year after the disclosure.
Senator, this issue, from my perspective,
was a HR matter.
The way it was talked to...
We know that that's what you think.
The way that it was talked to me...
It's very clear in the documents you provided to us. We think of it as something different, though.
And Senator, in hindsight, as do I. But...
Well, OK, that's good. So on the journey, 2024,
yes.
30th of May, you've got the document, you've got more documents on at the end of November, you've got all of 24, 25 we're into now. Who are you telling? Do you go to Dexus and let them know?
I can only explain, Senator, how
Sorry, just answer this question. Did you go to Dexus any time in 2025, which is a year after you've been advised?
Yep.
Did you go to Dexus at any time in 2025 and say, we've got a whistleblower who's raised matters about you? And I've seen the documents. I've got the documents.
Yeah, no, I can't recall. I was just focused on Lendlease there. Sorry, Senator.
Well, there's a long list. So if you can't remember Dexus, can you remember Lendlease?
I do remember Lendlease.
When did you talk to them?
I think it was May 2025.
Okay.
The challenge...
So what about Westpac?
I'd need to take that on notice.
What about
Optus?
What about Optus? Yeah, because that looks like that's a red hot one.
Yes, and I didn't speak to Optus. Can I give you how I found this evolving during that time of period?
Well, we have got limited time, so please, yes, I'll give you a couple of minutes to explain, and then we'll go to questions from Senator Scarr and Senator Pocock.
Thank you.
I do need some opportunity, Senator.
Yes, absolutely. You've got 2 minutes.
How I felt about this.
I'm less interested in how you felt, Mr Yates. I want the facts. We need the facts.
Sure.
Because there's a structural problem here we are seeking to address.
I understand that.
And I want to be very clear. I wish you no ill, Mr Yates.
I understand that.
And I hope that you're getting support because this is a challenging time.
Thank you.
But we need the truth.
Yes, Senator.
And we don't need context to explain it away. We need to understand why decisions we find egregious and inexplicable happened in one of the largest audit companies in this country. So that's what I want to hear.
Well, I'll start again by saying, Senator, I've taken accountability for the things that didn't go right.
So explain where it went off the rails.
So in this, I'm trying to get to this period of time.
Off you go.
Senator.
You've got 2 minutes.
Thank you. So I received this document, and
please put some dates in.
The 21 and 26 documents. So I think I received them on the Monday, which was the 25th, physically. And that was the day that I asked for an investigation to commence. These allegations at the time were quite general in their nature. Yes, they read egregiously, and that I have no dispute with that. But we needed to find evidence that I could actually point to really support what was going on here. I felt that by that May time, I had enough that I could go and talk to people about. And that was when I went to, had that conversation with Mr Lombardo to say that we had an allegation. The particular allegation I focused on was the one where physical documents had been removed from Lendlease, brought into KPMG and circulated. That was and I found that an incredibly egregious allegation. I said to Mr Lombardo at the time that I had found no evidence to that point to indicate that that had occurred. And it was through subsequent months, and I genuinely can't recall when various conversations took place. I spoke to Lendlease at a second time to say that...
Just on that first conversation, sorry. Did you refer to that person as a whistleblower or a person with a workplace grievance?
Certainly not the latter, because I was talking about a very serious... I can't in all
so we heard this morning that
the
reference was as a whistleblower, but you weren't providing those protections to that individual as a whistleblower.
I suspect, Senator,
That's okay.
Lawrence, that I did refer to him as a whistleblower because that was how we were seeking to treat the individual.
But you weren't offering the whistleblower protections to that individual to then be able to provide you with the evidence you needed to be satisfied that there was, in fact, a case here to be looked at.
I need to refer that to some of my team that are sitting...
Oh, we'll ask everyone,
I know you are. I know you will. So I'm just trying to not say the wrong thing because they are more equipped to give you the best answer.
So Mr Lendlease, Mr Lombardo at Lendlease, you're having a conversation with him in 2025 saying, we've got a whistleblower, we're concerned about an allegation about physical documents being shipped out of your entity, your company, to KPMG, which is a breach of APES 110, professional standing. I'm very concerned about this. And then what do you promise to do?
Senator, I told... we're investigating the allegation to the point of me leaving the firm.
Well, no, not in 2024. We've got a long time before that happens.
Of course.
Right, 2024, you're going, we've got a problem. You said you initiated an investigation to commence on the 25th. Who did you give that task to? Who did you allocate to do the investigation?
Sorry, threw some dates at me there. That would have been James McClellan, our Deputy General Counsel.
So you go to your in-house lawyers to do the first
that was
investigation.
The first point.
Okay.
And Senator, I feel, and I'll reflect on this whole process, and as I've said, at the time, I felt we were escalating our investigation processes appropriately, starting internal, which was not unusual, moving to an external review of that, and ultimately to a complete investigation by a third party. In my mind at the time, that was an appropriate escalation as more information came to pass.
Okay.
I reflected on that, as I've said, and had my time again, that might have been done differently. As a consequence, I resigned from the firm.
Thank you. Do you have a list of everyone who was spoken to as part of the investigation into the allegation the documents were stored in a locker?
I don't... I'm still unaware...
Did you ever receive a list?
I'm still unaware, Senator, of documents stored in a locker. As I left the firm, I've still yet to be shown what documents were stored in a locker.
Well, yes, that seems to be constantly restated, but there were people in a room, Mr Yates, can I put it to you, who observed things, and without an investigator, just by being here, listening up to people who are trying to speak up, we are getting information about people who could provide some evidence about what happened. Now, you don't have a list of who was spoken to about the allegation that I presented in the Senate, that the documents belonging to Lendlease were stored in a locker by Ms Hoggett and Mr Rogers. You don't know anything about that?
Senator, I have not had evidence to prove that that occurred.
Okay.
I think what we have talked about...
Can I ask you then, who is Mr Lawrence Newell?
He is a member of the audit team. I'm not...
Which audit team?
Senator, I'm not on that. Not
Mr
close
McPherson,
that,
can
so
you
I
assist
need to
us?
share that.
I'm not sure which audit team he's part of, to be honest.
But he is a partner and he's part of an audit team?
He is not a partner.
Oh, he's not a partner?
No.
Okay. Mr McPherson, do you have a list of everyone who was spoken to about the allegation documents from Lendlease were stored in a locker at KPMG?
No, I do not. I did not participate
Do you have
in
a
the
list?
investigation.
Do you have...
Senator, just one of the team can provide a list of the individuals that were spoken to as part of the investigation of the 21 and 26 November documents. I don't specifically have a list of people who were spoken to about storing things in a locker.
But you just said how important this was. This is so serious that you've spoken to the
I've never
CEO.
had it. I'm trying to just be clear on what we, to my knowledge, at the point of me leaving the firm, had been identified. And it had not been identified to me at that point in time that things had been physically taken and stored in lockers. If there is evidence to support that, then the firm will need to look at that. What we found, and has been shared, was that documents were put on screen inappropriately, and I think that has been...
Well, that's one part. That's the documents on screen
yes.
that the Deputy Chair asked questions about. This is other documents stored in a locker, supposedly by Mr Hoggett and Mr Rogers, who've both been sanctioned by KPMG for matters that we have no visibility of, because you're still claiming legal, well, not you anymore, but the new CEO replacing you and the team, the leadership team, are claiming legal professional privilege and frustrating the Australian Senate and the members of this committee from answering these sorts of questions so that we can see for ourselves.
And Lendlease.
And yes, making sure Lendlease can't see it either.
I just need to continue to make the point, Senator, because it's very important, and maybe facts have changed since I've left. I don't know. But no one was sanctioned for stealing documents and putting them in a locker.
Okay. I'll have a question later. Let's go to Senator Scarr first and then Senator Pocock.
Thank you.
Mr Yates, you resigned. I accept that. But do you accept the proposition you only resigned after Senator O'Neill gave her speech in the Senate, which was after the whistleblower, having exhausted all other avenues, turned to this committee, turned to the Australian Parliament to try and address this matter? Do you accept that?
It's very regretful that the individual had to get to this point, absolutely.
So, but for the fact that the whistleblower actually came to this committee and Senator O'Neill gave that speech, it's true, isn't it? You'd still be CEO.
Well, probably, Senator, but what happened in that period of time made it clear to me that decisions and judgments and processes that I had put in place had let the firm down, and so that only became clear to me as more and more evidence came to light, and it shouldn't have come to light that late. And
but Mr Yates, it shouldn't have just depended upon you. You've got an Officer General Counsel, you've got independent directors, you've got a chair of the board, you've got senior audit partners. It wasn't just you, was it? It was a failure of the leadership team.
Senator, these things over such a long period of time are never one person. But at the end of the day, as the CEO, I took accountability for that. And the timing of that was when I became aware that more evidence was being found to support something that we probably could have found earlier. And I took the accountability for that.
The timing of that, just to be clear, was after the whistleblower, having exhausted all other avenues, turned to this committee, turned to the Australian Parliament for assistance, and Senator O'Neill gave a speech on the Senate record. But for that fact, I think you've acknowledged you'd still be CEO.
Well, let me just add something to that. In my mind, we never stopped investigating this series of issues. I've said before, it escalated through many different ways. The Allens investigation didn't conclude, and we made that clear in our statements publicly after the Senator stood up in the Senate that the investigation was ongoing. Yes, it happened after Senator O'Neill made her statement, but the investigation was ongoing, and that ongoing investigation brought to light evidence that there was a third issue, which I understand subsequent to me leaving has become public.
What's the third issue, Mr Yates?
It's the Optus Telstra issue, I believe, Senator.
Was that the critical one that helped you determine you needed to step aside?
That was the day, Senator, I realised that there was things here that could have been found earlier. And Senator, I need to.
Just let him finish this and come to you. Yep.
When I joined this firm in 1989, Senator,
yep.
it's I don't mean to appeal to anyone's...
You've got a deep emotional connection to
I do.
it, and you've got a lot of pride in what you've done, and 100%. I'm sure it hasn't been all bad, but
and I do.
This is pretty bad.
Senator, this is not how I had wanted to leave KPMG.
Okay,
but it was that evidence and recognition that there was evidence to support some of the whistleblower allegations that, had I have overseen things differently, we could have found earlier. And it was that day that I realised that I felt I needed to take accountability for that.
So let me put it to you this way, that what you knew about Lendlease, what you knew about Westpac from inside the documents that were in the whistleblower's laptop, what you knew about Dexus, what you knew about Macquarie, none of that was sufficient. They're all Australian-based companies. But when you found out about Optus Singtel, which is a Singaporean-based company, then it became a problem. Let me put that to you for your response, Mr. Yates.
Yeah, absolutely. That's not the way that I'd characterise how I thought through that. So
you can see why I'm thinking that, though.
No, I understand why you're saying that,
It took
Senator.
a lot to sink the boat. Have you read that book? Who sank the boat?
No, Senator.
A bit more, a bit more, a bit more. Who sinks the boat?
Okay.
It took Singapore to get involved before you went, hey, I better get out of here.
That's not true, Senator.
Right. Tell me what's wrong about what I just said.
As I said up front, as the CEO, you base your decisions on the information in front of you.
You had the information in the laptop, Mr Yates. You had the letter to Mr McPherson from the 30th of May 2024.
I'm going to respond, Senator, to your assertion that these other things didn't lead me to resign. The body of evidence that was presented to me at the time was that those allegations had not been substantiated. So I wouldn't resign over things that hadn't been substantiated.
Okay, and the substantiation, you've
as the
already
passage of time went on,
yep.
and they became substantiated.
There was the Office of General Counsel. That was the first bit you've mentioned that. What are the other sources of verification that you went to?
There's all the various reviews that were done, Senator, and I'll leave it at that level.
Are they investigations or are they legal advice? Because when I read your document...
Are they independent?
I cannot,
it's
for
all
the
the
life of me.
It's all the evidence in everything that was... You know, we were on this for almost 2 years.
Were they investigations or were they legal advice or were they something else?
Senator, I sit outside the firm now, so I need to be...
But this is on your watch. While you were there,
yes,
this was going on. You were engaging Allens. You were engaging Ashurst in your name.
I understand.
And they're characterised in your documents to us
yes.
in a range of different language options. Sometimes they're an investigation.
Yep.
Sometimes they're legal advice. Sometimes...
I'd put it to you that it's all of the information that you've referred to. So I had all the information...
If only we could see it. But
Senator,
legal professional privilege is still being claimed over these fundamentally important documents upon which you seem to have made your decisions to do nothing.
Okay, as we both know, you'll need to address that question.
Mr Yates, how could it possibly have been appropriate to pressure the whistleblower to sign a deed of release to terminate their employment with the firm in circumstances where, on your own testimony, you've received, through the searches conducted by the firm without the whistleblower's knowledge,
no knowledge,
when you located documents on the whistleblower's laptop on the 21st of November and I think the 25th of November, how could it be possibly appropriate to then pressure the whistleblower to enter into a deed of release holding issues, and I'll come to you, Mr McPherson, around potentially withholding employment references? How could it possibly be appropriate to apply that pressure on a whistleblower as opposed to saying, we want to protect you, we don't want to put you under this commercial pressure, we want to look after you, we're going to give you time, we're going to give you independent legal advice, we're going to make sure that we look after you because we want to get to the bottom of this?
You're going to need to give me a minute or two,
sure,
Senator, to give you a longer story, because I don't believe that we pressured the individual to sign that deed. This series of issues had been, from my perspective, going on for months. And I could see the anxiety in both the people on my team and their staff who are involved in this, and clearly on the side of the whistleblower, getting higher and higher. I felt there needed to be some mechanism to put to release that pressure and allow parties to move forward. That is not an unusual thing in modern business. My recollection is that process had been going on through Julian, and there was an agreement reached sometime earlier for a separation, but we then received a very distressing phone call from the whistleblower suggesting they'd gone for employment, and someone from KPMG had given either a reference formally or informally that had led to that individual not attaining the job that they'd been going for. And the sort of negotiation process ceased at that point.
Are you aware at one point in negotiations around the deed of release, the whistleblower, by their evidence to this committee, was actually threatened with not being provided a reference unless they proceeded with the deed of release in the terms that were provided on that day?
And they are being gaslit here.
I'm not aware of that. Can I continue where I was in that story?
Keep going.
Only because at that point, and I think, Senator, to the best of my recollection, it was October-ish, that negotiation fell apart. Again, from my recollection, the whistleblower then requested to deal with one individual in one of our teams to recommence a negotiation. And so by the time we got to the point, Senator, of signing that deed ultimately, in my mind it wasn't a pressure. It had been a process that had been going on for some time to get to a point where both parties would separate. And we made a commitment to the individual that we would investigate allegations they'd made.
Mr. Yates, the whistleblower was told unless he signed the deed, the whistleblower would be terminated by a date in early December. How is that not pressure?
Without reference.
Without having the ability to get a reference.
I'm not aware that was a statement made.
Mr. McPherson, what's your knowledge in relation to this matter? Was that pressure put on the whistleblower?
I have absolutely no recollection. I'm sure I did not say or make any representation about not providing a reference to the individual.
Was any representation made that unless you sign this deed of release, we'll proceed to terminate you by a date in early December or some other date?
I don't recall that it was a definitive decision that he would be terminated.
You don't, so we'll just stop there. I do not recall it was a definitive decision that he be terminated. That doesn't give me confidence that you didn't apply pressure on the whistleblower to sign a deed of release, and if they didn't sign that deed of release, they'd lose that opportunity with presumably catastrophic financial consequences for themselves and their family.
Senator, can I just provide a bit of context? I was not involved in the conversation around the final deed of separation with the individual. I was not involved in those.
You were head of audit, Mr. McPherson. This was your person. You had responsibility to this person.
But I was necessarily removed because of it would not have been appropriate for me to be involved in the investigations around the individual. I did not lead those investigations, and I did not lead the discussions around the final deed of separation with the individual. I was not involved in that discussion, and I did not make those representations.
Mr. McPherson, this person confided in you. In the excerpt that was provided by the chair, I quote from that excerpt, which is now on the record of the Australian Parliament. This is to you. Again, I have spoken with you at length about some of these and of certain individuals' insecurities and retaliatory natures. And as discussed, as a consequence of raising some of these concerns, I have been retaliated against. We discussed this in our meeting on 4 April 2024. You have commented to me on several occasions that there is a culture of retaliation, and even went so far as to warn me about this on Saturday, 28 October 2023. Is that information correct?
Senator, that information was provided in the communication on the 30th of May, along with a whole range...
Is that information I just read to you correct?
I spoke to the individual and I said I did not...
Is that
information correct?
To add further information.
I just want to make sure I'm answering the right question.
Well,
I've given you the quote.
Is that information just read into the record? Is that correct? That is the question.
I do not believe that there was conversations around retaliation in April and October with the individual.
Okay.
That's
not your recollection.
Had the individual spoken with you at length about a number of the concerns the individual had with respect to the culture of the audit division of which you were head?
I do not recollect those conversations. When I received this information...
Mr McPherson, can I put it to you? I find that extraordinarily difficult to believe. Either it seems to me you would recollect having conversations that go to the heart of the culture of the audit division of which you led. You would either recollect those conversations, or you'd say definitely it wasn't raised with me. If it was, I would have done X, Y, Z. Are you seriously saying you don't remember?
I don't recall having those conversations. I don't think those conversations took place. Can I provide some context to this communication? Because I think it is important, because I did take these allegations seriously, and in my response to the individual, which followed, right at the very front of the first response that I went back to the individual, I said to him, I recognise these are serious allegations, they need to be investigated, and please provide us with the information, the detail to be able to do that. And I provided him with the way that he could raise those allegations. I thanked him for his courage in speaking up.
Sorry, Mr McPherson, you provided him with a way in which he could raise those allegations. But the way in which he raised the allegations was, I would like to provide this whistleblower disclosure to KPMG. I was hired by KPMG Service Company, which is governed by the Corporations Act. I would like to provide these whistleblower protected disclosure to KPMG in accordance with the Corporations Act. So I'm protected against retaliation, and I'm protected in circumstances where the whistleblower, he or she, has put on the record that they were concerned about retaliation. And are you aware KPMG's response was, we will not give you advice as to whether or not the protected disclosure falls within the Corporations Act or it doesn't?
Senator, I wasn't involved in that advice, but what I can tell you is...
Sorry, Mr McPherson, you were head of audit. Yeah. This is one of your people.
And you're a
partner. This is one of your people in one of the most egregious situations, and you're telling me you weren't aware of that basic fundamental issue. Notwithstanding that fact, you say to this committee that I told them there was a pathway in which they could report. But you're not disclosing this committee the obstacles put in the whistleblower's way when they sought to use that pathway, namely that they were not given recognition of being a whistleblower under the Corporations Act.
But Senator, in every communication, I think, with the individual, I encouraged him to put forward his detailed complaints so they could be properly investigated. And the reason why
yes, we know. But every time you said that, the whistleblower says, am I protected under the whistleblower laws? And got a blank or a no or we can't give you advice?
Was it even offered, Mr Yates? Was it even offered independent legal advice? Was it even offered in the context of these egregious claims for which KPMG, the whole leadership of KPMG, is paying for now? Wasn't offered independent legal advice in circumstances where KPMG's engaged Ashurst, Allens and goodness knows who offshore?
In honesty, you need to, Chair, I don't believe it was, but I could be wrong there. I would take us back right to where this started, and I know you challenged the wording I used at the time, Senator. I accept that. We could have made this a much easier process for this individual. I acknowledge that. We can, as I said, you challenged my wording earlier, and I accept that. That was part of the reason I took accountability. Okay. I've talked about a speak-up culture. It failed in this case.
I've acknowledged your resignation. Can you tell me the circumstances of your severance from KPMG? To what extent do you continue to receive pension or remuneration from KPMG? To what extent, and this question is directed to both of you, to what extent have you received a termination payment? To what extent are you being provided with your legal expenses, independent legal expenses, in terms of engaging with different investigations? To what extent have you signed non-disparagement clauses, or has KPMG signed non-disparagement clauses? And on the record, I ask for copies of all contracts, arrangements and deeds which have been entered into by each of you with KPMG. But what can you tell us today?
Yeah, sure, Senator. I mean, my separation from the firm has been very consistent with a normal separation of a partner from the organisation. We don't have any ongoing retirement arrangements. I think we made that clear last time we talked to you. We don't. I have no ongoing remuneration from KPMG. I'm separated. I signed a deed with KPMG. I've agreed with the firm that I'm happy to share the detail of that deed, which was confidential, but I'm happy to share that.
So what's in the deed?
Yeah, I'll tell you, Senator. So around my remuneration, there's to walk through that with you, because it does go to the way the board thought about my exit. So, as you'd appreciate, as the CEO, a large proportion of my remuneration is incentive-based. The vast majority of that for the year has been withheld. And so when you see the public disclosure of my remuneration in the impact report that the firm will put out, I think in August, you'll see that my remuneration this year is about, I don't know the exact numbers, is about $1 million less than last year.
What was it last year?
It was $3.2 million last year. So you will see, as I said, Senator, I don't know the exact number.
No, that's okay.
It'll be roughly $1 million less, and that was the judgment the board took to, accountability, Senator. That's what it's about. I've been in this room many times. I think I've taken accountability here. So that was the annual salary impact. Amounts have been withheld.
What do you mean by withheld?
They haven't been given to me.
But are they...
My contract had incentives that were subject to things that would become evident in the future.
Right.
And if those things became evident in the future in compliance with what they were, I might be granted those amounts. Those amounts have been withheld.
So sometime in the... well, have they been terminated? So you've
no, that's a fair point. So they've been withheld so that they could be paid in the future.
So they could be paid in the future?
They could be paid, yeah.
So what are these amounts that could be paid in the future?
The one there was $300,000 that could be paid.
And what's that attributable to?
And there's one from last year which is about the same amount of money.
Oh, so another $300,000. So
Senator, I'm trying to be pretty
No, I know,
here.
but you use that word withheld, and with respect, I'm trying to get to the nub of what withheld means. So there are two amounts of $300,000 that are dependent upon some milestone being achieved in the future? Or?
Yeah, it was subject to a framework that the firm put in place when I signed my contract.
Okay, and were there any non-disparagement clauses in this deed?
I don't. It's a standard deed I signed. I'm not sure we have non-disparagement clauses in there because of the number of partners that you would have to sign non-disparagement. That's a question you'd have to ask one of the lawyers behind.
Well, let me ask you, what else was in the deed?
It was a standard deed around. It's a fairly simple document, as you'll see,
Maybe
Senator, when you get it.
To us, because I'm just thinking about most people that I know who work. They've never seen a deed of separation. They've never signed one. They don't know what they look like, and they're certainly not talking about $300,000 potentially coming down the line, or $1 million cut off their pay. It's a very, very different experience for most Australians.
I understand
so can you make it clear and accessible to ordinary Australians? Because what we're seeing here is a reveal of what's going on in these massive consultancy firms that are trading off the trust that's supposed to be embedded in audit. It's the audit that is the big star, and everybody else gets a job because audit's being done in a trustworthy, accountable way, fulfilling statutory requirements, doing the job right, keeping the economy nice and clean and clear to everybody. People don't get it. You need to make it plain for ordinary Australians to understand.
I'm trying, Senator. What I asked to be in the deed was access to documents to move forward, access to insurance that comes normally when you leave an organisation. Outside that,
independent legal advice with respect to handling inquiries from regulators.
Yes.
So KPMG is giving you the benefit of independent legal advice, which KPMG is paying for.
I haven't had it to this point, Senator. But
is KPMG giving you a right to call upon KPMG to pay for independent legal advice as you go through the whatever processes?
I believe so, yes.
They are?
Yes.
They're
paying for your independent legal advice, but there was no independent legal advice paid for for the whistleblower, was there?
Senator, I say again.
No.
You know where I'm going with.
I know the answer.
Yes.
So Mr McPherson, can you go through the arrangements in your deed?
So I resign my position as National Managing Partner, but I am a partner still of the firm, and I will resign from the firm. I'm just going through an orderly transition of my responsibilities, so I haven't signed any deed. I haven't reached an arrangement with our new interim CEO around any separation agreements, but I would say that I'm not expecting anything outside the ordinary course as a partner leaving the firm.
Thank you.
I haven't finished, Senator, because I don't want to be for information to come out later and be accused of withholding information.
Yeah, the whole truth and nothing but the truth. That one, yep.
I hear you, Senator. So far I've walked you through the impact on my remuneration this year. Those two amounts. The rest of my separation there was nothing unusual about it. There was nothing additional to what I would receive or any departing partner would receive who has the tenure in the firm that I have. But they're big amounts. And so the way that our retirement benefit works is that every year part of your annual profit goes into pay for retiring, partners that retire. So I've been doing that for 25 years. So under our partnership agreement, my retirement payment was $2.4 million, and I then received a notice period of $1.7 million. That's the extent of my financial arrangements. They were subject to a deed of confidentiality, but I felt it was appropriate to share those with you today.
Well, the confidentiality obligation doesn't prevent this committee. So the 2.4 was your retirement benefit, which is the accumulation of what was set aside.
Well, it's not direct. It doesn't directly work that way, but that's in theory how it works.
And the 1.7 was
notice period.
So you were paid as if, instead of having resigned, you were paid as if you'd been terminated.
Not at all, Senator. I mean,
I don't understand why you paid a notice period when you've resigned.
That's in our partnership agreement, and many.
So does the 1.7 make up for the $1 billion that they took off your salary, plus a little bit?
Senator, this has been very costly.
Yeah, I understand that, but answer that question for me.
No,
does the 1.7 you just referred to there?
No.
Does that make up for the $1 million that they took off?
So you've got
the board took its judgment, exercised its judgment around my salary for this year and withheld amounts.
So put the numbers on notice for us so we can see clearly what went on.
Yeah.
Yep, thanks.
So, but
Senator Pocock.
I think I've given those numbers
2.4,
fairly
1.7 and 2.2.
Which is around about $7 million.
That's not a fair way to characterise the Senator, because I got a salary for 2026, and that's not a separation payment. So my salary for 2026, when that's disclosed, will be about 2.2 million. I think it's unfair to put that with a retirement amount.
Can I suggest you put it on notice? We've asked for a copy of the deed, but I'll give you the opportunity to put on notice in your terms how you would like to characterise it, so the Senate has the benefit.
I'm very happy to do that, and I've been very open and transparent, but I think it's very unfair.
We would hate
very
to have
unfair
to
to characterise my salary for this year
more money
in align with the others.
So time-wise, can I just
thank you? I've got a few lines of questioning. I know time is short. Two of the big four firms have the dubious honour of having united the Australian Parliament across all political divides around the failure to be honest and to act appropriately. What do you say to the Australian community about the fact that two of the four big four are appearing to be accountable to us? And the numbers here are huge. Your revenue last year, as I recollect, just looking very quickly, is around about 2.3 billion. Last year, 2.3 billion.
Correct.
And your revenue with government at present, Commonwealth government only, is in the realm of 297 contracts, $653 million of public money. What do you say to the Australian people and the confidence and trust that they now feel deeply suspicious about giving any of the big four?
Well, Senator, I leave the profession feeling that the big four accounting firms are incredibly important, strong, good firms. And I feel that they are organisations that create careers for young people, that they build careers for people, that they're all focused on delivering great client service, they're all focused on serving the public good, but they're big and they make mistakes. That's how I characterise it, Senator.
So Mr Yates, I'm just gobsmacked at that response. The average wage out there for median wage in Australia is about $74,000. Lots of people watching this, having just heard that conversation about the millions of dollars that senior people, not just you've 680-odd partners. The average partnership pay is well over $1 million, I think.
No, it's not, Senator.
Can you correct me? Give me your average then of your partnership pay.
I think, Senator, last year it was $710,000 was the disclosed average.
10 times at least, many times.
Many
times over. What the average Australian does is sweating it out there in a hospital, retail. They're looking at the numbers in this building and looking at the resources their parliament is putting into this and scratching their heads. And they really are deeply concerned, I believe. I'm very concerned about the narrative you're offering here, Mr Yates, which is we've done something wrong and I'm taking the fall. That is not good enough in my assessment. I understand you have taken a fall, absolutely. But this is a partnership of shared responsibility. So my question to you is, who else in KPMG should be resigning in a shared responsibility environment of a partnership. If you can tell me who you think should be moving out of there.
Senator, I've left the firm. I've got no view on who else should resign.
Do you believe the chair of KPMG should resign?
I don't think so, Chair, no.
Why not?
Because I think the firm needs strong leadership. I think...
Well, we do too.
Well, that's obvious.
Yeah. I think it needs continuity.
We're a bit concerned that perhaps that's not there.
Sure. I think it needs continuity of that leadership. And I think Martin has been an outstanding chairman and professional for over, what's probably 35 years.
We certainly need good leadership, but I think continuity of leadership of the kind that we are witnessing here is very unsatisfactory and it needs to change. I want to go to a document. I want to go to the language that KPMG uses about dealing with its very serious, egregious errors. In your letter to us, I think it was your letter to us, you use the language of having fallen short. That is an incredible minimisation of what has occurred here in a multi-billion-dollar operation with so many millions of dollars of public money.
Would you mind confirming the date of that letter, Senator?
I can certainly go and look at that. I thought it was the 29th of May.
I'm just conscious that there's things that I haven't seen.
You talked about...
There's things that I haven't seen because I haven't been in the firm.
Oh, well, I understand. Yeah, I thought this was... it may have been signed since, but what we actually have here is a systemic and dishonest set of language, I believe, which is saying to the Australian people, don't worry, it's small, it's a few people. When we look at your language, for example, around the access to a computer, to get at confidential information with a view to financial gain from it, the way KPMG, under your leadership, described that was inappropriate, informal. A language was used by someone who made that computer available while they went off and had lunch.
Yeah.
They invited people to look at that computer and access confidential information, which they should not have been accessing. And the way KPMG characterised that dishonest act was to call it an inappropriate, informal remark. That is an invitation to cheat, to make money. Why does KPMG use language like fallen short, inappropriate remark, when these issues are so significant? They are minimising and they are dishonest language.
Senator, the intent at any point in time was not to use dishonest or minimise language. The way that we responded in respect to the issues was based on the body of evidence that was in front of us at the time about what had happened. And in respect of the matter that you're referring to there, the way that the evidence was presented to me on that matter was that was made in jest.
Doesn't matter what the tone was, the language was. Do you agree that you're opening your computer and indicating to others in the room, there's important information here, take a look? I could say it with a sense of humour, it's the same message.
I had no evidence.
This is critical because you talk about responsibility and accountability. The message is, have a look and it'll be helpful to you.
Senator, I have no evidence that the actual event occurred, other than a comment being made. And you know, I know you will talk about that being semantics, but you're asking me why we used the language we used. We used the language we used because that was the way that the evidence that we had in front of us characterised what had happened. I'm not saying... I would not endorse for one moment someone doing what is purported to have been said. Not at all.
Do you think that didn't happen, Mr Yates?
On all the evidence that I've seen, that didn't happen. But
sorry?
On the evidence of what I have had available to me to be seen, the comment was made, that's been said. I've got no evidence to support the fact that that actually occurred.
So you do concede that an invitation was made to the room to access the computer with confidential information?
I concede a comment was made.
Yes, and how do you view that? As an inappropriate, informal, jestful remark? That is an ethical breach.
Well, Senator, it's a comment.
How can you disagree with that statement, Mr Yates?
It's a comment. We have a lot of people in our firm, Senator, making comments all day. Some are made in jest, some are made inappropriately. I'm not condoning the concept of what was done there for one moment. The way that it was presented to me was that had been said as a joke, and that was the reason we used our language.
But it's your response right now to me that really undermines people's confidence, that you see what we can all see. We've all been in workplaces. We know the power of that kind of statement to a colleague. And your failure to see it in that way is really a problem for me.
Well, Senator, I'll say it again.
I've got a last question.
I've resigned on the basis of things we didn't get right. And the way that I've responded to you here is simply the way that, at the time, the information was presented to me.
Mr Yates, have you seen a copy of a document prepared by KPMG on the 30th of April? It's not in the public realm, but I hope it will be before long. A summary of factual findings from various investigations and reviews into the former employee's allegations.
I have, Senator, yeah.
This is a document which prepares 28 different allegations from KPMG's point of view that were... Sorry, 38. Thank you for the correction.
Yep.
38 allegations
Yep.
by the single whistleblower, which KPMG then replies to. And on all 38 of those allegations, KPMG, and I quote, has not been able to substantiate the allegation. So you give yourselves a clean bill of health on all 38 of these allegations and provide nothing but short sentences to let yourselves off the hook. And I want to go to one of them, of which I have, and so do others on this panel, have some knowledge of. The allegation was made by the whistleblower, number 9, that the former employee alleges that KPMG's CEO, that's you, misled Parliament regarding power mapping within KPMG. Now, many Australians have seen the video of that exchange. It was an exchange between you and I. You had provided information to a question on notice saying you did not do power mapping, and then we provided evidence of power mapping, very explicit. Names of people redacted, their position, the way in which they were useful to you, whereabouts in the organisation. That's a power map. But on that question in this document, and I'd like to quote, the allegation, this is KPMG's assessment of the allegation is not substantiated. The KPMG CEO acknowledges he made an error in the written response to a question on notice regarding power mapping. Through a series of written communications and in-person appearances subsequent to that initial response, he sought to clarify KPMG's approach to these matters with the Senate inquiry, culminating in a final response to a question on notice on 18th of December 2023. So you have decided, internal to KPMG, and I understand without any reference to the evidence of the whistleblower, you exonerate yourself and clearly let yourself off the hook on having misled the Parliament. That is an exoneration of words that are merely mouthed. They offer no evidence. We have no documentation behind them, and you say there is nothing to answer for. And yet the whistleblower thought so, and lots of people who've seen the evidence in the video know there was. This is an example, is it not, of you using language to let the firm off the hook in a clear case of misleading the Senate.
Senator, I'm reminded daily of our engagement around power mapping, and if I had my time again, I'd certainly have approached that differently. As I said at the time, and I think it goes some way to explain your question there, I never sought to mislead the Senate at that time. I really don't want to go back down that whole path again.
I bet you don't.
Because
I remember writing the Quan, and that's why I called it 15 different names and explained what it does, so that there'd be no way for you to misunderstand
Senator,
what you were being asked.
Ingrained in my memory, believe me.
That was the Quan.
And still won't agree today that you misled the Parliament. You're
Senator,
using your language to deny something which we have the facts before us.
Senator, I really am reluctant to get into naming convention. We relationship map, we do relationship plans, let's call them power maps. So I really don't want to go down that path again.
Well, you said you didn't. That's the point. You misled the Parliament.
Senator, at the time, I certainly had no intent to mislead the Parliament, and I think we got to the point of agreeing that we relationship map, we account plans, all the things that others would call power maps that we do, and I made that acknowledgement.
And on reflection, do you believe you did mislead the parliament?
I don't think I misled the parliament. I think I made a mistake in a written question on notice, Senator. And I recall I answered 270-ish questions in that process. If I had my time again, I would answer that written one differently. But I did not intend to mislead the parliament.
Thank you, Chair.
Time here. Yep. Can I indicate that we are due to go to the independent members of the board at 12:30. We will not get to that. We have called witnesses that we do want to ask questions of. So can I indicate that we'll run a little late? Perhaps the lunch will fall back to 1:30, 1:45, depending on how questioning proceeds, and we'll make adjustments to the program from there going forward. There are two final questions, I believe, from the Deputy Chair and from Ms Lawrence. Ms Lawrence can go first.
Yes, I'm just want to pull back just for a minute. When we were discussing this with CANS as well, just trying to understand the extent to which there is a pattern or a systemic failures. We highlighted, for example, the Star Casino failings of identifying red flags with, for money laundering, which you were the head of the National Audit at the time. We spoke about.
Sorry, Senator, you need to explain that. I don't follow that example, I'm afraid.
So I'm trying to understand, whether there's a pattern here of systemic failures,
I don't know
of
what
incompetence.
The Casino red flags reference was about. I'm sorry.
So at the time, as I understand it, from 2018 to 2021, you were the head of the National Audit at the time?
I was.
Yes, and I'm just talking to the failures that we've identified through the court hearing of the Star Casino versus Beckier, with respect to a number of issues relating to the board and the executive, but also the failure to identify the red flags for potential money laundering.
But you're not tying us into those.
For KPMG as the auditor. Then we had the Paladin case, thank you.
Paladin, yeah.
Then we had the Tahir, and now looking at Lendlease. Are you either the unluckiest person to manage the audit and then subsequently the CEO, or is there something else that you can explain as to how there wasn't any sort of change in the process that you've overseen to prevent these recurring patterns happening under your leadership? These recurring failures.
They're all very different situations, Senator.
But you are the common denominator across them all.
I'll have to take the Star Casino point on notice. I really don't know what you're referring to there. I've spent many times in this House talking about the Tahi matter and where we got that wrong. Mm-hmm. And that would be a very different situation to whatever the Star City Casino situation was. And what was the third one? Sorry, Senator, the Paladin matter. That was a
Paladin, the conflicts of interest.
I can't recall the detail of the Paladin matter.
So is it a theme of incompetence, or is it intention behind the way the conduct of the firm is done? I
can't tie all those three
but
things
together. But these are major failures.
Well, I'll say again, I can't tie all those together as being failures of ours. I'd need to take it away and look at that.
But there has been a situation, though, that those who have led those various divisions, be it with audit or yourself now as CEO, until very recently, where obviously you've fallen on your sword, but until that point, and perhaps if the Senator hadn't ever made that statement in the Parliament, I think as Senator Scarr has also said, you would perhaps still be CEO today. So being able to move from one scandal to the next, a failure to the next, how do we as the public, how does my constituents understand the extent to which there is a quality of audit, that there is accountability, there is self-referral? What message can you give that now that you've departed there will be change at what change can you advise needs to happen even within KPMG, as your departing gift to the board and to the executive to do things differently?
Look, Senator, I am sure that the new leadership team will look at many, many things and make many, many changes, and I would expect them to do that. I don't know what they're going to be. In terms of those situations you've tied together there, I'm genuinely struggling to tie those together as a thematic. What I would say...
I think KPMG was the auditor
in each of those circumstances, Mr Yates, that is the thing that
We weren't
ties
the
them
auditor of Tahi. The
together.
Tahi wasn't an audit matter, Senator. Paladin, I can't recall the detail. And we weren't the audit of Star City. So I'm finding it hard to answer, Senator. I'm very happy just to take that away and work out how to thread those together. But I'm struggling to thread those together as KPMG issues. Yeah,
so we'll get a question on notice for you on that one.
I can't see a pattern there that I can thread together.
To Mr McPherson, the reclassification of a whistleblower's disclosure as a workplace grievance obviously effectively strips the individual of statutory protections. I just want to understand, was this authorisation by you an intention to reclassify it as a standard HR procedure, or was it a legal strategy? Because I imagine, well, I would think that had that person been provided with the legal protections from the outset, their computers, for example, would not have been able to be surveilled covertly, that there would be a raft of other protections in terms of the evidence that person could have provided. So was it an intentional act that you did? And further to that, did you or are you aware of anyone else within KPMG also doing covert surveillance on Brendan Lyons?
So, Ms Lawrence, there was no strategy or intent to try and characterise the issue as one thing or another, or characterise the individual as one thing or another. My absolute best intent from the very first correspondence I got was to engage with the individual, to do everything I could to address the workplace matters which were raised, but also to address the serious allegations which the individual raised in May. And in my very first correspondence back to the individual, I acknowledged the seriousness of the allegations. I thanked him for his courage in speaking up, and I encouraged him to report the matters, the detail of the matters, the evidence around the matters, so that they could be investigated. And I encouraged him to do that to someone outside our division, initially to the P&I team, and then on multiple times referred him to the International Whistleblower Hotline. And my genuine intent was to try and have the individual feel that they could provide information through that source so that it could be properly investigated outside of my division.
So
I do acknowledge...
Just as a tangent to that, so this morning we heard from Mr Lombardo testify that he was told by Mr Yates in 2025 that there was no issue, and only to admit this year that the data had in fact been used.
Could I just qualify that?
Yeah.
I said to Mr Lombardo that there was no evidence to support the allegation at that point in time.
Okay.
Time? 24, 25
April
or 26?
25. As Ms Lawrence is quite rightly using the right date, I just wanted to confirm the way I characterised what I said, that was all. Please.
Right. So with not then following up with the information so Lendlease had full disclosure, did that in effect mean that Lendlease was not in a position to be able to then report a criminal breach because they weren't given the facts?
Well, Ms Lawrence, for my part in it, I encouraged the whistleblower to provide information, detailed information, so the allegations could be investigated, and I took that very seriously from the start. And then once the process started, the first investigation started, I was not part of that investigation.
Right.
That's entirely appropriate because it would have been a conflict of interest for me to be part of it. So the investigation proceeded, and then, outside of my division, and decisions were made about communications with clients. I would like to say, though, I do acknowledge that with the benefit of hindsight, I should have handled things differently in terms of this issue, and that's why I have resigned from my role. I take this very seriously. I acknowledge the...
But I appreciate that, but I'm trying to understand whether there's system things like would a Brendan Lyon or another whistleblower, or are there people currently on the books in KPMG who have workplace grievances who are fighting the same fight that this current whistleblower had fought to get that statutory protection? Like, how many other workplace grievances are being investigated? And I'll put that to the later members so they can just take that on notice as something I'll come back to. But then just to finish, just to confirm, under the Crimes Act, is it your understanding that unauthorised retention and use of confidential information for commercial gain can meet the threshold for theft or fraud?
I'm honestly not in a position to answer that question because I'm not a lawyer. I'd be operating outside my area of expertise. I apologise. I'm not trying to deflect the question. I just genuinely don't know the answer to that.
Thanks, Chair.
Thank you very much, Mr Yates and Mr McPherson, for attending today and for the nature of the interaction and your answers to our questions. There probably will be some questions on notice, and you've undertaken to provide us with further information. If you could do that by, what was the date, Secretary? Too many bits of paper here. I think it's in July, but that'll be advised to you. So I can ask you if you wouldn't mind now just stepping back. We'll suspend briefly. Oh, sorry.
Yeah.
Sorry, before I let you go.
Quickly,
Last one.
Very quickly. My interest is mostly around the well-being of the whistleblower. I think today we have heard, and thank you for your appearance, I think we have heard a genuine remorse from both of your evidence. I think there has been a degree of cooperation. Some of my colleagues may have wanted more, but the show hasn't finished yet. You have indicated that upon reflection you would have done things differently, Mr Yates, and similar from Mr McPherson. The whistleblower, from my mind, has acted at all stages integrous, courageous, with patience, with great patience, honesty and persistency. In light of, we touched on severance pays, exit pays, or deeds of release, and potentially yours. I'd ask you both as gentlemen exiting the business to reflect on the impact of what this situation has had on KPMG, particular to your client list, and what the potential fallout of that may look on your balance sheet, the reputational damage as a result of this. And I would just ask, it was, to use an analogy, one of your clients mentioned, bad apples. I'll say bruised. And from bruised apple, you can still make strudel. There is an opportunity to revisit the deed of release with the whistleblower. And upon reflection of everything that you have brought today, if you were doing that deed of release for him in a month's time, would the figure still be the same? I very much doubt it. Can I ask and appeal to your sense of generosity, particular, Ms McPherson, because you're still in the organisation, to revisit the deed of release for what is a truly remarkable person that has brought all of this evidence to light.
Thank you.
Mr McPherson?
I hear everything you say, and obviously I am, sorry for my part in causing distress to the whistleblower, and that's part of the reason for my resignation. And look, I am no longer the National Managing Partner of Audit and Assurance, so I don't have the authority to undertake your request, but I'll take that on notice and discuss that with the executive team. And I would like to take the opportunity again to apologise to the whistleblower. I would like to take the opportunity to apologise to our clients and to all of our KPMG people and partners who do great work each day. And I apologise for the harm that I've caused them.
And I'd add to that, to Julian's statement, exactly. And as a human, feel for any impact that this has had on the whistleblower.
Gentlemen, I needed to put that on the record because I fear that when I ask the questions to the next witnesses, they will say, that didn't happen on my watch. I can assure you we're going to be having that conversation. Thank you.
Can I draw your attention to the document to which Senator Pocock referred, which went through the refutal and rebuttal of every claim by the whistleblower, which is not your current position. And I want to ask you, you signed that document, Mr Yates.
the cover letter came from both you and Mr Shepherd. Now, as we sit here today, we're about to call Mr Shepherd forward. Do you still stand by what's called KPMG's statement of facts provided to this committee, or do you step away from that as an inaccurate record now?
I absolutely stand behind that as the facts at the time it was signed.
Right, so something happened between you sending that to us and your resignation.
That's why I resigned, Senator.
Right, well, if you can shed any light on the critical moment of change, please take that on notice.
I did do that earlier, and it was the evidence that emerged on what's become the third issue, which
the
said to me
Sintel Optus issue.
Which said to you what? Said to you what, if I may ask, Mr Yates? What did it say to you?
It said to me, Senator, that there was evidence here that supported the allegations that had I led things differently, could have come to light earlier and been solved earlier and saved a lot of the anguish that you've referred to there, Mr Buckholt. So that was it, Senator. That was the moment, and it was that third issue. But I absolutely stand behind the signing of the letter on the date that I signed it with Mr Shepherd.
Chair, it's very important we place on the record, I think, that this list of 38 allegations was the list that KPMG manufactured from documents which they'd obtained from the whistleblower's IT address at KPMG and put together in this list of 38 statements. It was not a list prepared by the whistleblower, and it was not a list prepared by the whistleblower, certainly with the benefit of independent legal advice. It was something that was constructed by KPMG. Sorry, I just want to...
I think that's important, and it's not supported by any reports to which it gives great weight for us to assess or judge in any way the validity of the claims that you state as facts. We state are completely at odds with what's been told by the whistleblower. And while KPMG continues to claim legal professional privilege over the reports of Ashurst and Allens, we have no way to observe. So can I thank you once again, and I will this time, sorry to have missed out, I ask you to step aside, please stay in the room if you can, and I'll call forward further witnesses from KPMG, namely Mr Shepherd, Ms Mortell, Ms Hoggett, Mr Rogers, Ms Bell, Ms Capon and Mr McClelland and Ms Hisgrove. If we could fit you all there, that would be good. If not, please be ready to come forward should you be asked to answer questions. Why don't they know? They have to come back. Yeah. Okay. Where are we? Could I ask you to state your name and the capacity in which you appear?
Suzanne Bell, Audit Partner Australia, KPMG.
Paul Rogers, KPMG Australia, Real Estate Audit and Assurance Partner.
Carmel Mortell, Deputy Chair, KPMG Australia.
Martin Shepherd, Chairman, KPMG Australia.
Dorothy Hisgrove, National Managing Partner for People and Inclusion.
Eileen Hoggett, Partner, KPMG.
Louise Capon, KPMG Australia General Counsel.
James McClelland, Deputy General Counsel.
Thank you very much. And I just seek to remind you of the comments that I made in the opening statement that I reiterated to the outgoing CEO and Mr McClelland. I remind all witnesses that the giving of false or misleading evidence may be treated by the Senate as a contempt, and that equates with telling the truth, the whole truth and nothing but the truth in Senate language. The committee also reminds all parties that this matter of the committee's commitment to the Parliament's procedures for the protection of witnesses, emphasising that witnesses are protected by parliamentary privilege, making it unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee. Any such action taken against a witness may be treated by the Parliament as contempt, and the committee will ensure that any such action is vigorously investigated and, if necessary, referred to the Senate as a potential contempt. So we're looking for some clarity to assist us in addressing systemic issues that appear manifest through the experiences that have just been traversed with this, your former CEO and former head of... I've got to get the right name. And the former National Managing Partner of Audit and Assurance. Thank you. Okay, thank you for your opening statement too, which the committee has. If I can go to Mr Shepherd. The committee has your document of the 30th of April, which is the summary of events relating to the whistleblower. Is that the best document that we have in terms of the details? Is that the best document we can have?
So, Senator, I'm not sure exactly what you've got because information's come to you from different avenues.
This is from you, the document from you.
Oh, from me? Yes. Look,
signed off by you and Mr Yates on the 30th of April to this committee.
Thank you, Senator.
Yeah.
So that document is, in my view, a sort of a holistic document summarising the matters that we've been considering.
Okay, and you were here in the room and you heard Mr Senator Scarr's characterisation of that document, which I think the committee very much concurs with that this is a document that is your construction of a range of issues raised over a period of time. And if I can put it in this way, as we come to the end of the document, there are some signals that there's a bit of attention to some of the most egregious ethical failures involving, on the record now, Lendlease.
Yes.
And potentially others of your clients as well.
Yes, Senator.
Do you stand by everything in that document? Because, Mr Shepherd, your CEO, your head partner, has stepped away because things that were asserted in there are no longer accurate.
Sorry, can you just repeat that last bit? Things that were
Do you
in
stand
there?
by the document?
Yes, I do, Senator. And I'd really like to give some context. I mean, I think in considering where we are, and I did in my opening remarks want to make a sincere apology. I mean, that's been made by Mr Yates and Mr Macpherson, but to the whistleblower, to our clients, I do want to sincerely apologise, and also to our people. But I think in that context, it's really important that we have a holistic view of the concerns of the whistleblower, and that document, Senator, was an attempt to do that. And if I summarise it, and we can talk about the individual elements, but if I summarise it from my perspective, it was important to bring together all that we knew inside the firm that the whistleblower was concerned about. And those things fall into some broad buckets that you'll be aware of. I mean, there were matters in there that were raised around conduct, things of, management of confidential information, which you've talked about. There were issues in there which have been discussed just previously around workplace grievances. There was another category, I think, within there that talked to relationships that we have with our clients, and then perhaps the other, from memory, the other sort of bucket of items that the whistleblower was alive to and was raising related to perhaps issues that have been discussed in this chamber before, like AI, the use of AI in exams and those sorts of things, Senator. So that document was our best attempt to summarise what we knew about the things that the whistleblower was concerned about.
Having read it, the sections that deal with your clients and compromising the quality of audit and the integrity of audit and the observation of documents that shouldn't be seen and the use of those for purportedly gain for KPMG didn't feature significantly at all in your response, and they are certainly the matters the committee is very interested in. If I can go to the 29th of May, when Mr Yates and Mr Macpherson resigned, we have you saying in a letter to us received at 9:51 that day during our ASIC Oversight inquiry that KPMG, and I quote now, treatment of a whistleblower and investigation into their allegations fell short of the firm's expectations, those of the whistleblower and the broader community. what are the elements then in the 30th of April document by which you still stand where KPMG fell short?
Well, Senator, I was pivotal to that release, so I'm accountable for the words in it, Senator. And if I reflect on those two components that you mentioned, there is no doubt in my mind that our management of this issue from start to end was extraordinarily difficult for the whistleblower, and I think you've illuminated that this morning in a number of dimensions. I think there's an element in the early part of the journey that's been described this morning. There was perhaps conflating of workplace issues with things that were much more serious that were trying to be surfaced. I think
if I can put it to you that there is every effort in the document, and again I'm seeing today in the evidence we're receiving from you, to try and minimise this as a workplace issue. Let's just carve that bit out, right? I don't think CEOs and everybody who's sitting at this table get this heavily involved in a workplace issue. So let's just call it for what it is. It's not a workplace issue. Let's stop talking about that. Done.
Sure.
Okay? Let's go to the real stuff that goes to the quality of audit.
Yes,
that's the bit we're really, really interested in. The governance of people who are auditing, the reporting lines for people who are auditing, the role of ASIC, the role of CANS, the role of your disciplinary committees, the speak-up culture, the opportunity for whistleblowers. That's the stuff that I'm interested in, and that's the committee's responsibility. We're not here to solve an individual problem, and we're certainly not here to talk about a workplace issue, although that is predominantly what's in that document, right? Yeah. So let's just carve that off completely. Let's not go back there again, because I think it's to apologise to the whistleblower and then try and trounce their reputation further by calling them a workplace issue is just beyond the pale. So let's go to an answer to this question, because I've given you a chance to put some context. What are the elements of the 30th of April document that you still, and Mr Yates still says is an accurate document? What are the bits where you fell short, using your own language? Identify those for us, please.
Senator, thank you, and I will be guided by you about what I talk about, and I apologise if I mention the workplace grievances piece, so I won't go there again. Look, just, in relation to the document that we put to you, I think the things that are very, very important is, KPMG is an organisation which
Mr. Shepherd,
I believe stands for.
I can hear a large context coming here. I'm going to your document provided by you on the 30th of April that sought to assure us, without providing us any evidence to back it up, that there's nothing to see here, right? But within a month, the CEO resigns because you fell short. Let's go to the document, Mr Shepherd.
Sure,
Show me the bit in the document.
Sure. So in the
where did you fall short?
In the document, Senator, there was raised the Lendlease matter. That was included in that document. And as Mr Yates said to you, the emergence of the Optus Telstra matter was the third issue. So there was the Lendlease matter, there was the inappropriate remark, and then the Optus Lendlease matter arose. And, that was the catalyst, I think, for, the much more serious accountability and escalation of where we found ourselves, Senator.
Okay.
So the important parts of that are actually...
We haven't got Optus so much in that document. We've got the Lendlease.
That document predated that, Senator.
So let's just step that out then, okay?
Sure.
Because for mine, and I'm pretty confident in saying for all of my colleagues here, frankly, what was in the documents from the whistleblower, what you found and was shared with your CEO in the search of the whistleblower's IT system, was enough for all sorts of fireworks to be going off. But you said you didn't see it that way. And you gave us a document that said, oh, look, it was bad, but we've checked it out, it's all fine. And then something truly explosive, by your definition, which must be truly extraordinary, changes everything with regard to Optus Singtel. What happened there?
Well, Senator, as as has been said earlier, this has been an investigation which has gone on for some time.
No.
And
we'll come to the investigation. I want to know what happened. How did you find out about the bit that's not in the document you gave us about the Optus seeing talk me through the days in which you found out about that, who told you, what you found out, and what you then did.
Sure. So, Senator, I would have come to know about that matter from the board subcommittee that's been overseeing the investigation of these matters since the issues became known to the board. I was not part of that subcommittee because I had a self-declared and agreed by the board conflict, so I was not a participant in that process. I didn't engage or commission any of the work that was done by that committee, including the work done by Allens. So as issues have emerged, as a member and the chair of the board, I would have come to know about those issues through that avenue. And the Optus Telstra matter emerged very recently.
What is the Optus Telstra matter in shorthand?
Well, it's the flowing of information in relation to one client from one team that serves one client to another team. So information moving through an ethical divider that shouldn't have moved through that divider. And it is important to give a bit of colour to that information that moved between the dividers. So,
hard to put colour on a wall that doesn't exist, Mr Shepherd.
I beg your pardon?
It's hard to put colour on a wall that doesn't exist. Talked about an ethical wall. It apparently didn't exist.
Had a door. Freeze of access.
Well, you paint a picture of it. I'm trying to give you an explanation as to what to characterise the documents. So, the information that
one part.
The information that was passed, well, both documents actually were KPMG documents, but embedded within those KPMG documents was information in relation to a company that was unredacted. So if you could imagine a document that was a KPMG document that was explaining something, it had a screenshot in it that had some information in it. So it might be lines of a ledger or something like that.
About which company?
And then in this case it was information about Optus, and that screenshot, the information was unredacted.
And it was shown to
And it went to a team. It went to another team.
It was shown to another team?
It was shared with another team, yes, Senator.
And the other team was what?
Was the team that was pursuing the audit of Telstra, Senator.
So people understand insider trading, even if they don't play the stock exchange or whatever. They know from movies that it's a bad thing, you don't do it. This is kind of shorthand insider information sharing, where there should be absolutely no way that would occur.
Senator, the retention of confidential information within KPMG is paramount to our licence to operate.
Was it paramount for Lendlease or just for Optus Singtel?
Well, I think the three instances that we've been talking about today are all really, really important, and they all go to the treatment and the handling of confidential information. So I'm agreeing with you. That's pivotal to our brand permission and trust, and that's why I think these matters are so serious and why we're treating them so.
Okay,
I do think though, just to finish,
sorry,
I beg your pardon.
All those people, and you haven't named them, you haven't named the teams beyond the business that they were working on, have they all now self-reported to CANS?
So my understanding is the people in relation to the Lendlease matter have reported to CANS.
Yes,
but that's
not
not the serious
to the one you were describing that resulted in the CEO standing
My
down.
understanding is we've been in dialogue with the regulators.
So they haven't reported something.
I'm not actually certain.
Did you direct them
to
self-report?
So the way this works, and I think this is important, when these issues arise, there's a consequences framework which is applied, and then when the sanctions are...
If the senator declares something in the Senate, otherwise no one would be knowing anything about this.
No, I don't think that's quite right. But then when the sanctions are applied, the individual is asked to self-report, and if appropriate, we would report to ASIC, our regulator, at the same time.
But you haven't done any of the above yet?
Well, I don't know the answer to that question for the reasons that I explained, because I'm not actually on the subcommittee of the board.
Can someone else confirm that? Because we heard from Cairns this morning only 3 people have.
I'm happy to take the question. So we did receive the final report into the investigation of Optus and Telstra, sharing of client information on Sunday.
By whom? Report by whom?
It was received by our investigators.
Okay, who's that?
It's Allens.
Okay, and that's the company, that's the legal company that you use quite frequently. Is that correct?
They're one of the legal companies that we use quite frequently, yes.
And how many reports have they done on the whistleblower matter already?
It's been ongoing, and this is the second report that they've issued in regards to it.
Regards to it? Which is it? What's it?
The allegations that they've been investigating.
Okay. Which ones are they?
So if you recall, and you probably have it on record, the 19th of August email that the whistleblower sent to us, which is what he characterises as the full summary of the allegations. They have been the subject of what the subcommittee of the board has asked the external investigators to investigate. And so that investigation is continuing, and they're going through each of the matters in quite a level of rigour. And so the Optus Telstra matter was completed by that investigator, and we received the report Sunday, just
And these are all the reports that you're refusing to give to this committee?
They're the subject of legal professional privilege, that's correct.
And given the trust deficit that you're operating in now, your response to us is, just trust us. We've read the reports that we've paid for. Sometimes we call them investigations, sometimes we call them reports, but they generally seem to exonerate everybody all the time.
Senator, can I respond to that question?
Yeah, because it's a big problem for us, Mr. Shepherd.
It is a serious problem. It is, Senator, and I wrote to you, and I've been the person in the exchange with you around the provision of documents.
It's your right to waive it. It's got nothing to do with the legal companies.
Please do let me step through this, and we will likely disagree on this. I mean, I have. Over the last couple of weeks, I have agonised. This has probably been amongst the most difficult decisions I've made in my executive career around how to make sure that I fulfil 2 obligations.
Well, I can tell you haven't fulfilled ours, Mr. Shepherd.
I understand that, Senator. I understand that. And so, I've got a deep respect for the Parliament and for the Senate. I absolutely do.
I'm glad you verbal that, but that your actions belie a different disposition.
And then I also have, on the other hand, a range of competing really important tensions, and they are these. When investigations are undertaken, they are very often conducted under professional privilege, and the reason for that is so people can give to those investigations.
Yes, we understand.
Which you understand. In addition to that, in this
we receive documents of that kind all the time, Mr. Shepherd.
I'm pleased about that.
Well, you should know. I want to make this very clear to you. We receive documents of that kind all the time. We have documents in our possession today from people who have been here earlier today. They've asked to be confidential. We've looked at them and we have agreed to that.
Yes.
You have not had the courtesy or the respect for the law of this country and this committee's request on behalf of the Australian people
Senator,
to show us the evidence on which you keep absolving yourself. That is your choice, and you have put both Allens and Ashurst in a very difficult position seeking to support the work of the Parliament.
Yes,
you've told them, don't give them anything. That's what you've said to them. You kept legal professional privilege.
Yes, I have.
It's outrageous.
And you've also said you've got a commitment to transparency, Mr. Shepherd. So on one hand, you're invoking legal professional privilege, which is the client's privilege. Former General Counsel, former Senior Associate Allens, it's the client's legal professional privilege. And you constructed this investigation from day one to take advantage of the processes and principles of legal professional privilege. So please, Mr. Shepherd, do you understand how we find it hard to tolerate when in your opening statement you say you've got a commitment to transparency and then you're hiding, you are reserving legal professional privilege. And Ms Mortel, this is not something that's amorphous. This is your legal professional privilege, the way you constructed this investigation, using legal professional privilege, and you're hiding behind legal professional privilege whilst at the same time claiming to be transparent. Do you understand how we might find that quite risible?
Of course, Senator, and I did preface by saying we may not agree on this matter, but I did want to get to the attempts that I've gone to try and make sure that I can meet the needs of both stakeholders. Now, you know, that summary document. Who are
the both stakeholders?
Well, we have individuals that are the subject to investigation, which can be criminal investigation.
Yes, we receive documents about that all the time too, Mr Shepherd. Let me assure you, we know how to deal with documents over which legal professional privilege might be sought, and we deal with them all the time, and we deal with them in confidence. There's so much we've got here that never goes out to the public. The committee makes those decisions very judiciously.
Yes, Senator.
You have insulted us by not providing them and continuing to claim legal professional privilege and asserting that your document to us, which now you say is incomplete, is factual. We have nothing to verify you, and frankly, Mr Shepherd, we just don't trust you anymore.
Senator, I understand your frustration. A summary document, a commitment to come before a closed session of this hearing, and I know you jumped on that, but that was in addition to...
That's because you don't get to direct the will of the Senate, Mr Shepherd.
Of course I don't, Senator. I completely
respect that. You had a good go.
And then, as I said, so there's a few layers to this. There's the responsibility I have in relation to those that are subject to investigation. I have the obligation to the Senate to provide the very best information I can, and you'll know that our independent directors have provided a body of information. We've provided a body of information, but there are certain reports which you have sought, which are the subject of professional privilege, which we're seeking to preserve.
Which are critical.
But you've made the decision, and you structured the investigations to take advantage of legal professional privilege, and you didn't even give the whistleblower the benefit of independent legal advice. We've just heard from your former CEO. We've got another partner on the way out. They're getting independent legal advice. What do you think, Mr Shepherd? I want to put this question to you. What do you think that Mr Pierre Kleinveld, Mr William Peet, Mr James Marwick, Mr Reinhard Girdler, doyens of the accounting profession, whose names give you KPMG's names, Kleinveld, Peet, Marwick, Girdler, what do you think they would think about the situation KPMG, the firm that bears its name, is in today? Here you are before this Parliament trying to defend these egregious breaches of integrity in circumstances where a whistleblower who tried to do the right thing, from day one tried to do the right thing and was frustrated at every obstacle. What do you think Mr Kleinveld, Mr Peet, Mr Marwick and Mr Girdler would say to the senior leadership of KPMG in Australia today?
Senator, I've been at KPMG for a very long time. Kleinveld, Peet, Marwick, Girdler means something to me. You know, I would hope that, you know, and they would expect of me to turn up every day and do my very best, and that's what I do, Senator. In relation to the whistleblower and their legal advice, you know, as I've said, I am deeply apologetic to the whistleblower, and I am. It is extraordinarily uncomfortable to sit here knowing the frustration we've caused the whistleblower, particularly around the way that the whistleblower protections have been presented to him, and I do apologise for that.
But, Mr Shepherd, your words on a piece of paper doesn't feed the whistleblower and his family, doesn't pay the mortgage, doesn't restore their professional career, does it? It's just words. Is that correct?
Senator, I totally agree. I mean, words on a piece of paper don't mean much, actions do. And, you know, we're here, you know, if I think about who's here today, you know, everyone that was asked is here willingly, and we are here to open your questions as openly, as transparently as we can.
Who was in the whistleblower's corner? You've got Allens, engaged by KPMG, Ashurst engaged by KPMG.
Yes.
You've got eminent internal counsel and deputy counsel, chief operating officers, head of audit and assurance. Who was in the whistleblowers? The International Council. Who was in the whistleblowers corner?
Senator, I do think, and if you look at end to end where we find ourselves, I do think.
Sorry, Mr. Shepherd, you say if you look at end to end where we find ourselves, it's as if a taxi dropped you off at the wrong address.
Senator,
this is where you took yourselves as a group, as a collective group. You didn't bind yourself there. You made decisions which led to this destination. Do you accept that?
Senator, in the 29 May announcement, we absolutely acknowledged that we've made mistakes and we apologise to the whistleblower, acknowledging exactly the point you've made. The point I was trying to make is that I genuinely believe that there are people on this journey that genuinely cared for the whistleblower. And Mr McPherson, that was just here before you, I've worked with him, and I know that the interactions that he would have had and those email communications he referred to in terms of his interactions with the whistleblower bore no malice and actually were respectful of the whistleblower.
So why is it then, Mr Shepherd, that the whistleblower, having tried their hardest to use your internal processes, raising issues with senior partners in your firm, raising issues with our friends from KPMG International, had nowhere else to turn but this committee and had to rely upon this committee and, to a credit, Senator O'Neill to give a speech on the floor of the Senate in order for this to come to light? If all those people were concerned about the welfare of the whistleblower and making sure they were taken care of, why was it that action only occurred? Why was it that your CEO only resigned, your COO had to stand down from that position, sanctioning of the Westpac lead auditor, other resignations pending? Why is it that that had to occur on the floor of the Australian Senate before action was taken, if you did such a great job of looking after the whistleblower and being empathetic to the needs of one of your staff?
Well, Senator, I never once said that we did a great job of dealing with the whistleblower. And look, I absolutely accept that we didn't act with the level of urgency that we should have. There's no doubt about that. And that we are, to this day, not able to engage with the whistleblower and to have created an environment where they could engage with us.
That's not their fault. That's not their fault.
Of course it's not.
And I'm sick and tired, and I think all the committee members are sick and tired of the way the KPMG has persistently characterised this. And can I tell you what I thought of your document of 29 April? I don't know who prepared it, but this is the document full of this phrase, not substantiated. You describe your document as a detailed submission, giving us a comprehensive understanding of the issues. I found it self-serving, selective and strategically weighted to try and make this an employee issue, quite to the contrary of what we expected as a Senate. So please don't insult our intelligence and don't continue to try and cast this in a way that's contrary to the whistleblower, who I believe, and I agree with my dear friend Deputy Chair, acted courageously, heroically, acted the way that your founders, Mr Kleinfeld, Mr Peet, Mr Marwick, Mr Girdler, would have expected. They would have embraced him, I would have hoped, and said, thank you for trying to save the culture of my firm. And instead you continue and refer to this rubbish that you tender to this committee, which is self-serving and selectively strategically tries to minimise the cultural and integrity issues.
Senator Scarr, we'll leave that as a comment.
Sorry,
you can respond on notice, but I'm going to go to Mr Buchholz now, and then I will come to you, Senator Pocock.
Thank you.
Thank you, and thank you for your contribution. Mr Shepherd, I wish to give you every opportunity to do your best. In your comments, you shared with us that you want to do your best. In line with, I think you know where my line of questioning is going. It is this committee's intention to ask you, as head of KPMG, to revisit the deed of release for the whistleblower to an amount that shows the genuine remorse that is worthy of the egregious unfoldings that this committee has uncovered. Mr Shepherd, do you have an appetite to assist the committee in that request?
Senator, I have had a desire to engage with the whistleblower in good faith. I have corresponded with him in very recent times.
Can you answer the question, please, Mr Shepherd?
You said you would. You said in earlier correspondence that you would communicate with our committee in good faith and are using privilege to withhold evidence. So please forgive me if, when you suggest that KPMG wants to operate in good faith, that I take that with the precedence of which you've showed this committee.
Look, I'd make this point. I mean, to any individual which we've caused harm, it is incumbent upon us in terms of our values and our purpose as an organisation to engage. And to your request with the whistleblower, to the extent the whistleblower's been caused harm, and I totally accept the way that you've described that, of course we'll engage.
Yep, thank you. Engage in a way that reflects the severity of the situation that has been uncovered. I think at the time the negotiation primarily happened, there may have been a culture of there's nothing to see here. Could I also ask one other thing of KPMG, that in negotiating that resettlement, that you offer the same legal counsel, independent legal counsel that you have to others, to the whistleblower, in this instance, to assist the whistleblower in, because clearly there's a history of starting a communication with KPMG and it being shut down because of one reason or the other, that we can't get whistleblower status. So give me a commitment that you'll look after the legal fees and a firm of their choice, independent, so that this can progress. Show me that you can do your best.
Mr Buckholz, I do want to make the point at this juncture around our offer of support to the whistleblower in relation to legal matters. We tried, and I deeply regret.
We've got the record, Mr Shepherd. We're not talking about the record. You're happy to stand by your document. We consider it inadequate. So let's not prosecute the history.
Senator, I was talking about the offer that we'd made to provide a legal firm to the whistleblower through this process. So I think what you're asking for is not incompatible with the approach that we've taken.
Thank you, sir.
Going forward, though, do you make that commitment if it's the desire
it's the
of the
same
whistleblower?
We've had all the way along.
And do you take on board Mr Buchholz's request for a reconsideration of the separation, the deed of separation, and the financial recompense?
Well, as I've said, Senator, and I'll say it again, I mean, I think it is consistent with our values and our purpose that if we have wronged someone and we have hurt someone, that we need to engage in good faith in that process, and that's the commitment I've made.
Do you accept that you wronged this person?
Well, we've been clear about that. I mean, we regret the way that we've handled the whistleblower, the frustration that we've caused. I thought that was clear.
It's more than frustration, Mr Shepherd. It's more than frustration. I'm sorry. Do you appreciate the impact this has had on the whistleblower?
Of course, Senator.
Can I ask whether KPMG acknowledges the disclosure of the 30th of May 2024 as a protected disclosure under Part 9.4 AAA of the Corporations Act 2001 and under the Tax Administration Act 1955?
So, Senator, I'm going to defer to help here, but I'll make this point before I do. Under KPMG's policy, we have a whistleblower policy.
I've read it, and I have serious questions about you implementing it. My question is not about your policy. I want an answer to that question, which I know has been sought. A response has been sought by the whistleblower on many occasions.
Yes.
Right? You're talking to us about making good.
Yes.
Answer the question.
So, Senator, I'm going to ask for some legal help here, but I'll make this point. It is incumbent upon us not to make a promise that isn't right. And as you know, there's complexity in the whistleblower legislation.
We've heard your arguments.
We would love it to apply carte blanche to partnerships, and we've actually sought that. I think in all challenges around this, that would have made it much easier. And I think that may be something that you've raised previously as well.
This person is not a partner and they were employed under a service agreement. Wasn't that correct?
Well, employed by a service company.
Yep. And what does that do?
Well, I would have thought service companies governed by the Corporations Act. But I understand the complication with respect to the partnerships. But the point Senator O'Neill is making, and again, this comes back to how KPMG has presented it, and which has caused me dismay, that you are not giving, in my view, and tell me if I'm wrong, are you giving appropriate recognition to the fact that, as I understand it, KPMG has not acknowledged to the whistleblower that they are a whistleblower with the benefit of protections under the Corporations Act and have the benefit of the protections and provisions of the Corporations Act? Has that recognition been given to the whistleblower at any stage in a context where, when they raise these concerns with the head of audit, they raise concerns about retaliatory action when they raised issues of concern in terms of their employment? Has the whistleblower been recognised as a whistleblower by KPMG under the Corporations Act with all of the protections of the Corporations Act?
Senator.
Ms Capon.
Senator, thank you. The KPMG has recognised the whistleblower as a whistleblower under our policy.
So you have not recognised the whistleblower as a whistleblower with the protections under the Corporations Act, yes or no?
No, we haven't, Senator, because
you have not.
There are challenges with the law applying to us, and if the law was changed so it's clear for partnerships, we absolutely would. But we cannot give assurances.
But Ms Capon, I understand the law, I understand how it works, and I've been an advocate for reform in this area, and I agree with you, Mr Shepherd. If anything comes out of this, hopefully there's reform. But please, do you recognise that you have, I put it to you, that you have inappropriately on a number of occasions in the material provided to the Senate said, we asked the whistleblower countless times to provide information. They didn't provide further information. So our hands were tied. The allegations are non-substantiated. But when you raise that point, you don't raise the key point that at no time when the whistleblower asked whether or not they would be given the protections under the Corporations Act, you refused to recognise that they are a whistleblower under the Corporations Act. Is that correct?
Senator, what we have tried to do is emulate for the firm the protections that exist under the legislation in our policy and afford those protections to that individual through our policy.
How's that gone? Yeah. Not so well, I would put.
That's why we're here.
One comment from Mr Withholds, and then we're going to you, Senator Pocock.
Mr Shepherd, just before I close off and hand over back to the chair for other committee members, as I close off, because the request has come as a request from the committee, I just want to flag that the committee will expect to have oversight of the negotiations so that KPMG does not circle the wagons on an LPP process that excludes us from having a line of sight to what that new negotiation, that new value dollar amount potentially looks like. I just want to make
I don't know that we can compel you, but we would seek transparency.
Can I take that on notice? I'm not quite sure how that tripartite arrangement works.
But we're seeking transparency.
But transparency.
No, thank you. I understand that.
And I'm appealing to your sense of generosity and your genuine intent to do your very best.
I understand.
Good, sir.
Thanks.
Senator Pocock. Thank you.
Thank you. I want to just go to this document that you prepared, which, without consultation with the whistleblower, the 38 allegations that you have carved out of your experience and for which you exonerate yourself for every single one of them. How are we to take this document seriously, particularly in the way, in the opening years of this event, you characterise this whistleblower as a disgruntled employee bringing a complaint, a grievance to the table, and you create that flavour at the beginning of that document and you characterise the whistleblower in that way all the way through. Now, anyone watching this with any experience of being a whistleblower on any matter in the workplace will be very, very familiar with that device, because that is a classic employer strategy around serious and trivial questions of internal complaint. How do you defend that when this is not an employment matter, it is a whistleblower matter, as we have heard from your own legal counsel and from earlier evidence today?
Yeah. So, Senator, look, that document lists out, as you can see, if you put aside the tone, which I have a different perspective, there was no intent in the preparation of that document to apportion anything to the whistleblower other than to reveal the matters that the whistleblower was concerned about.
Mr Shepherd, you must think we are really stupid, because I'm looking at this and you begin by talking, it's just words after words after words about this whistleblower, and they're repeated. It's absolutely clear that you do not give any credibility and you undermine them in the opening pages of this document about the way in which they attempted to bring forward their concerns. You characterise them all the way through as someone who's unhappy about where they're employed, that they want to work from a location that you no longer approve of. There's a whole lot of issues in there which characterise that employee in that way, which are incredibly unfair, and they colour your response. You have not treated this person as a serious whistleblower for years.
Senator, we don't have our chief executive, we don't have our head of audit. We have a range of regulatory issues that we are dealing with. You'll know that through finance, we're working with them around our government contracts. I mean, I think there is absolutely a recognition that the matters, the confidentiality matters that have arisen and are reflected in that document are deadly serious, Senator.
And do you see your sins in the same character as those by PwC, the misuse of confidential information to win work?
Senator, I think there are some differences, but I think the commonality is they're both matters around confidentiality. And as I said earlier, I think for our firm, for the four firms, confidentiality, and for lawyers and bankers as well. I mean, confidentiality is just fundamental to our licence to operate.
So we have a
So in that respect, yes, they relate to confidentiality.
In pursuit of income, if I may say.
Senator, if I can just reflect on that for a moment. I mean, to the best of my knowledge and belief as the chair, recognising that I haven't been deeply into the investigations, but to the best of my knowledge and belief, no information has moved from one client to another. So we are talking about information that is moving within KPMG in these three instances, or two instances, and then the other comment. So it makes it no less serious because we have to get this right in terms of confidential information. It is really important that confidential information stays within teams, and that we've got wrong, Senator.
You've got it wrong repetitively, and your mistreatment of whistleblower is now, of this single whistleblower, and I want to come to your historical record,
Senator Pocock,
is very serious.
I'm going to give you a call to continue, but I just want to indicate that at 1:15 we will need to go to the independent board members because we've got an overseas element to manage there, and that KPMG will be returning later in the afternoon to continue the line of questioning. So at 1:15 we will suspend briefly to get our independent directors in for half an hour before we break for lunch at 1:45.
Thank you, Chair. We are looking at a 2 out of 4 fail rate in the Big Four on managing your critical function, which is to keep key information confidential, and it's fallen in both firms because of pursuit of revenue. Do you agree with that statement?
Senator, I don't. I don't. I think these issues emerged in our pursuit, in the part of our business that pursues new work. I totally accept that. In terms of the Optus Telstra matter, which we talked about, I think that that shows, it shows non-compliance with what we require of our people. It shows carelessness.
Do you deny that those acts, which are massive failures, were not connected to the possibility of winning revenue, Mr Shepherd? Because that is an implausible attempt to...
Senator, I think what we've said is, as part of our, part of the work that we're going to do from here, we have to get to the bottom...
You're not answering my question, Mr Shepherd.
Culturally, whether the proposition that you put forward is right or not.
It really troubles me
I don't think it is
that
right,
you won't answer my question. It really troubles me, I have to say. Because people know what has happened here. They recognise it. They know what would happen to them in their workplace if they did something which resulted in their personal benefit and they used confidential information, they'd be out on their ear. They might get a warning, they'd never get a second chance. And here you are, you won't even admit to the reality of pursuing income and revenue possibilities through the use of clients' confidential information.
Well,
I'm looking for a straightforward admission.
Well, I think you put that proposition to me. I don't think that these instances reflect the pursuit of income.
Did they reflect a failing of adherence to the fundamental requirements of APES 110? Because a breach is a breach is a breach.
It's an ethical failure.
Without materiality.
A breach of confidentiality is something that's set out in APES 110, and
Yes.
it requires, if there's a breach of APES 110, self-reporting to CANS.
It does.
And Mr Shepherd, are we not looking at a repetitive pattern of behaviour? We have a third instance here which has led to your CEO leaving. It is a pattern of behaviour, is it not? Do you agree?
I think it's 3 instances, Senator. I mean, I think the accountability that you've seen...
It's a big barrel of
It's a
680,
pattern of
but there's
behaviour.
3 rotten apples.
Let me go to another pattern of behaviour. But
We're a 10,000-person firm. You know...
Yeah, I don't hold everybody to account, but 680 partners jointly severally liable.
Thank you, Senator. That's the point I'm making.
680 of you are, though, right?
The point I'm making is
it's a pretty
exactly
big
the
barrel,
point you're
Mr
making.
Shepherd.
And these were not people at the bottom of your 10,000 workforce. These are your leaders, Mr Shepherd.
Yes, Senator.
They are the leaders of these key functions in your organisation, and it is a pattern of behaviour which you refuse to concede. I think punters out there know what they're looking at. Will you undertake to match the severance payment that you've made to Mr Yates to your whistleblower, or to at least match any previous payments to whistleblowers to this current whistleblower?
I can't make that commitment in the...
Will you consider that?
Look, I mean, I don't even know what that amount would be, but I can tell you that...
What's he worth, Mr Shepherd?
Well, I'm not going to answer that question here. I can't, of course.
Are you going to get Allens or Ashurst to do it on LPP and then prevent us from finding out?
I think, Senator...
Because that's the pattern we're seeing.
Senator, I think the question's been asked and answered of me in relation to engaging with...
I understand you're familiar with the Tahi matter, is that correct?
Well, only vaguely, but...
Was it raised with you by an independent board member last year?
I'm not sure, Senator.
What did you do? You have had the Tahi matter raised with you. You are familiar with it. What did you undertake to do in response to a board member raising that matter to you? Did you take any action?
I'm not sure of the of who raised it with me and in what context, Senator.
Do you concede or see any pattern here where there have been repetitive issues of whistleblower treatment within KPMG that have really been incredibly damaging to the whistleblowers, and where the whistleblowers have not been treated appropriately? I'm speaking of Professor Brendan Lyons in the earlier case, and of course the current whistleblower.
Well, look, I can speak to the current whistleblower matter. I can't speak with any authority to the Brendan Lyon matter, Senator.
Did you find that Mr Yates acted improperly alone? What of other members, for example, Ms Bell, Ms Capon, Ms Hisgrove, Mr McClellan or others who were directly hands-on and are at this table today in this matter? What is their responsibility, and what action are you taking in relation to others?
Well, I think the collective action is the collective culpability is clear, and that's the whole firm's position for which we've apologised. I think there's accountability being taken through the CEO and through Julian, and then obviously there's the process in and around those that breached our confidentiality standards, Senator.
So the Australian public this morning
have... We can just go to who's here. There are people at the table who have reported.
That's correct.
To Chartered Accountants. So could you identify yourselves and say what it is that you reported? Start with Ms Hoggett.
Yes, I can confirm that I've done self-reporting to CANS and that I'm currently subject to an ASIC investigation regarding that matter, and so I'm limited in what detail I can provide you around that self-reporting and that matter.
With regard to the matter, there are a couple now that are on the public record, and there's a fair bit of public information. Ms Hoggett, what matter does your issue relate to?
In terms of a client?
Yes.
Yes, Lendlease.
So, Ms Hoggett, there are two main assertions there with regard to your behaviour in the public place. One of them is the sharing of confidential information that I understand was on a screen. Is that correct?
Senator, I am under ASIC investigation, as I think you are aware. Through that process, I have been provided very strict confidentiality protocols that I must adhere to. And so providing any information here today compromises the important work that I think ASIC are doing around that matter.
Okay, yet you continue to provide advice and operate as an auditor. Is that correct?
I remain a registered company auditor.
You remain a partner?
That's correct.
You remain a registered company auditor? And which accounts are you working on now, Ms Hoggett?
My signing responsibilities at 30 June this year. I don't have current signing responsibilities.
So you're on what they call gardening leave, is that correct?
No, I would not say that at all.
Okay, so what are you doing for the pay that you get?
I will do whatever. I stood aside. I went to the interim CEO and the chair once the investigation from ASIC commenced and said that I thought it was appropriate, it was good governance for me to stand aside from my COO responsibilities during that period of time, which was accepted. I will do whatever our interim CEO directs and asks me to do. I'm willing and able to serve the firm as directed.
Chair, can I just come back and catch something before we break? Does anyone else want to say anything about self-report or investigation before we...
Mr Rogers.
Yeah, I've self-reported as well, consistent with Ms Hoggett, the same reasons.
Same reasons.
Exactly
same company?
Same company.
I want to come back to you, Mr Shepherd, in our last few minutes. The question of conflict of interest is of really significant concern to this committee. And I want to go to your own behaviour and your own relationships. Did Peter Nash, a member of the board of Westpac, stay at your place during the Westpac audit tender?
Peter Nash definitely stayed at my house, Senator. Peter's a very long-standing friend of mine. But I don't believe that any probity requirements were breached in relation to that.
But it was during the preparation of the audit tender. I'm asking you that fact.
Well, I think I'd make this point, Senator. There were two things that...
It's a simple question, actually, Mr Shepherd. My time is short. Yes or no?
The answer's quite simple as well. I had two things in my mind. One was that I understood that Mr Nash was recused from the audit selection process.
Did that prove to be accurate?
I can't answer that.
And was it during the audit period?
I can't answer that question, but that was my understanding. And secondarily, I understood...
I believe that's been corrected on the public record now.
As I said, I can't...
Was it during the period of the audit tender?
Secondarily, it was my understanding and belief at that point that the decision had been made.
So your understanding may be different from the facts. What are the facts on this?
Well, I can only speak to my understanding, Senator.
So is it to your knowledge now, knowing what you know now, was a tender document under preparation when Mr Nash was in your house?
No, the process had been complete. The decision had been made.
What information did you exchange with him before and during around the tender process?
I mean, I'd have to take that on notice, but very little, if none, I should think.
Thank you. If you would take that on notice. Did you exchange information...
Can I just clarify, are you sort of seeking emails or texts? Or...
Yes, and records of conversation or memories of conversation.
Sure, thank you.
We are looking for a reassurance around conflicts of interest that are very real, that are on the public record.
Senator, I take conflicts of interest and probity very seriously, so I'll do that. I'll respond on notice. Thank you.
Did you exchange information with Michelle Hinchcliffe from Macquarie before or during that audit tender process?
I think my recollection is I met with Michelle Hinchcliffe. Not in relation to Macquarie. And this is probably a couple of years ago, and it was in the context of BHP. I was the lead advisory partner for BHP, and I met with her in that context.
So on the same basis as you've earlier undertaken to provide evidence of anything that you were discussed or exchanges around the tender? Thank you.
Ms. Hinchcliffe, yep.
Thank you. And is there any other information that has been inappropriately accessed within the firm?
I mean, I can't answer that categorically, Senator.
So let me ask you, have you asked, have you put out a call, has there been a leadership invitation to come forward since these 3 matters have surfaced?
Look, I don't think so, Senator, but I know what has happened is there's been activity to make sure that people are reminded of their obligations around confidentiality. There's been the push out of a rerun of training. So
we know how effective the training is.
Senator, there has been work done to make sure that we preserve confidentiality.
I have to say that the record on training around ethics in the Big Four leaves a lot to be desired. We have repetitive examples of failure. And so the whole regulatory regime is clearly up and necessary for discussion, but so are the cultures of leadership in these organisations. And do you support, if I may ask, Mr Shepherd, a significant look at the re-regulation and regulation of whistleblowers and, more broadly, the structures of the Big Four, given what this parliament is dealing with for the second time?
Yes, Senator. I think I answered that. I answered that earlier when I do think, and we have been advocates for whistleblower legislation applying to large partnerships, so that's a definite yes. In relation to partnerships, likewise, our firm has been a proponent of having a single regulator. It is incredibly difficult for us to run our firms as they're currently operated. We respond to a very broad range of regulators, and I think you and others have raised the ambiguity and the challenges with that. We would welcome a single regulator, and I would draw the committee's attention to professional partnerships around the world. Many of which are now structured in the context of what they call LLPs, limited liability partnerships, which are governed and regulated by the equivalent of ASIC. And we would welcome that here, Senator.
And is it not also the case, is there not a really clear case that we need stronger penalties when misdemeanours occur? A $25,000 fine for PwC would not have touched the sides of the income of partners or of the firm.
Look, I'm not an expert on regulatory regimes and penalties.
You know where it hurts and what it hurts.
I'm just not, but I mean, maybe that's something that needs to be considered as part of that regulatory environment, Senator.
Thank you, Chair, and thanks for your answers.
Ms Bell, what is your role?
I'm an audit partner the majority of the time, and I also sit on the audit executive, and part of my responsibilities is to look after audit growth.
Audit?
Growth.
Growth. So you're part of the growth team.
I am.
That potentially stood to gain from having a look at the documents that were shared from the Lendlease cash.
Well, I'm not aware of that incident.
Okay, you need to read more, Ms Bell. Could I ask if you were at the same address on the occasion that Mr Nash stayed with Mr Shepherd?
I was.
And how do you manage conflicts of interest, seeing as part of your job is to go out and bid for work? Were you after the Westpac audit at that point of time?
I was not part of the pursuit team, but the firm was engaged in pursuing that engagement.
And do you see any conflict of interest about this profoundly intimate connection of people across corporate Australia and your own leadership team? How do you manage those conflicts of interest?
Or perceptions of conflict.
Or do you not consider them conflicts of interest?
Well, I can only speak to my role, which is I look after the pipeline of pursuits. I work with the engagement partners in terms of allocating the respective audit partners to the pursuits that we intend to participate in the tenders of. And I also allocate to those specific tenders the members of my team, which can be the pursuit directors, the designers and other support people. And I also participate in the debriefs of all pursuits, regardless of whether we win or
like you're
lost.
a job hunter, basically, for KPMG in terms of ordinary people, what they might understand. You go out and you try and win more work for KPMG.
No, I don't. No, I don't.
What do you do?
The majority of my time is as an audit partner, and then I allocate people to the respective tenders that then go out and pursue them.
Right. So have you had to make any declarations, Ms Bell?
No, I have not.
Have you made any declarations of conflicts of interest or perceived conflicts of interest regarding Mr Nash and Mr Shepherd?
No, I have not.
So
the board.
Senator, I have, in the interests of transparency. You know, I mean, it's not that uncommon for people to, people in relationships to share a workplace. Clearly, Suzanne's my partner. I just reflect on how I've thought about that relationship and conflicts. When I rejoined the firm in 2018, I declared our relationship, even though it was well known. That was something that we thought about. My role was as an executive at the firm level. I wasn't working in the audit division. There was clear separation, and in my time as an executive, I recused myself from anything to do with performance or performance outcomes, the things that you would expect when a conflict is declared.
There might be more questions about that. My main concern was about the Peter Nash matter. However, we can come back to that. We are past the time that we said we'd go to the independent directors. We will now suspend briefly to get them on the line, and we will have you back here for further questions later in the day. Thank you. So. And I think that you've been sitting here throughout most of the day, so you've heard me state the expectations of the committee in terms of open and transparent response to questions, please, and the protection of the whistleblower, about which you know a lot more than most, and we're counting on you for that. One of the challenges that we face is that KPMG have claimed legal professional privilege over a number of documents that would have been that we would have been privy to if they had exceeded and given us the opportunity to look at them. Have you had a chance to look at the documents that we are not able to see today, the reports from Ashurst and Allens? Could I ask you each to respond? Mr Baird.
No, I haven't seen those.
Mr Abid.
Yes, I have.
Yes, I have.
And Ms Hemstreach?
Yes.
You have seen them? Okay. So,
yes.
Mr Baird, you're in a very different position from the others with regard to be able to see what went on. You sit with us in that regard. Could I ask you for your view about this claim of legal professional privilege and how it impacts on you as an independent director?
Yeah, you can see in the correspondence from us.
The only correspondence that we've received from KPMG that we requested, actually,
was
from the board papers that
right.
you have. Yeah, that's all we got.
That I had. Yeah. Yeah. No. Look, on the matter of privilege, Senator, the position's pretty clear. I don't think it should apply.
Thank you very much, Mr Abid.
It's obviously you're putting us in a very difficult position.
You're independent. That's what you're there for, to be
exactly,
brave and robust and maintain proper standards as directors.
If you're asking for my personal view, I think that some of the reports should have been released. I think reports that involved client confidentiality should absolutely have been kept as privileged. Anything that involved client information, client names, the investigations that involved people who are under other investigations, such as ASIC, I think is reasonable to have kept that as privileged. But I think some of the other documents around the investigation and indeed some of the legal advice around the treatment of the whistleblower, I actually don't see, and I'm not a lawyer, so I don't see the concern, but obviously the legal professionals who are dealing with this matter had a different view to me. And so I have to refer to their professional advice on why it matters legally. So I don't have a legal opinion of whether it should or shouldn't.
Because you're not a lawyer, are you, Mr Abid?
That's right, I'm not, yes. So it's a
But
personal opinion, but that's
as a citizen
different.
of the country, the Parliament has responsibilities to you as a citizen if you weren't involved with this.
Yes.
And clearly there's some very serious matters here that are structural, systemic, and matter for the proper functioning of the markets that affect every Australian. I'm not persuaded that keeping these documents from the view of the committee, which we offer to receive confidentially, is a smart strategy or an authentically or an authentic response to declarations of "we are sorry about what we did" that we've heard here today.
Well, let me tell you, Senator, I'm not here to persuade you on that. That's not my role. That was not a decision that any of us were involved in terms of taking or withholding legal privilege. That's not a decision that came to the subcommittee of this investigation at all. So I'm not here to persuade you of KPMG's position on that. That's a question for the leadership team.
Thank you. Ms Akupants.
My position on this is that we should have provided you with the documents that you've requested. I think it's been very difficult for the independent board members. You've requested certain information from us that we haven't been able to provide, and I think we indicated to the committee that we made an inquiry of KPMG as to advise us on their position in respect to this.
And Ms Hemstretch.
My apologies, Senator. I'm just
a long way away.
Used to the mute. Yes, and I'm just getting used to the mute and unmute capability on this platform. I think if you had... Sorry, I'll back up. My position on this is that you should have been provided with everything that you needed to conduct the inquiry.
We have considerable difficulty in doing our job in terms of scrutiny, while KPMG continues to assert privilege and does not give Allens or Ashurst the capacity to provide us the documents of the work that they have undertaken. The documents that we do have provided to us, could you explain how you persuaded whoever it was to get this much at least before us, even though it's been provided in confidence? Have they told you what they've given us? Mr Baird.
No. I mean, we've got... I mean, the documents that involve me, you know, I know that they've gone in and obviously I've provided all of those, but in terms of the actual documents they provided, I've just seen the ones that are relevant to me.
Okay. Mr Abid?
We certainly saw the summary that you're talking about that you discussed at quite length with Mr Shepherd that listed the allegations. After that was prepared, I think I genuinely do believe in what Mr Shepherd said, which was around it was done with the intent of trying to help with the committee of where we were at in the investigations across those allegations.
I guess I'm more interested in the fact that you have seen, three of you have seen these documents that are variously claimed to be reports, investigations and legal advice. We don't know for sure, because we've got to try and read between the lines, how many of them there are and what they do, because the assertions that they exonerate KPMG don't flow. That doesn't hold water anymore after the resignation of the CEO.
Could I answer the question this way? And I think this might... do I think that report that was the summary report is a fair and correct reflection of the much longer detailed legal investigation? Yes, I do think it was a good summary of it. I don't think there was necessarily... well, I don't think there was anything that was incorrect in that summary at the time of writing that report. So, as you've heard many times from people this morning, the investigation that has been coming to this subcommittee has been ongoing and is ongoing, and so that report was as at a point in time.
Yep.
And I think the investigators have continued to do their work, continued to find more evidence which has led to other conclusions, and I suspect probably in the near term there will be an update to that report.
Can I go to, you're a new member of the board that
yes,
you've come on, so I want to go to the ones who've been around for a long time. So, Mr Baird, you were on this board, but you removed yourself. There's been quite a bit of public commentary around that. I just want to give you the opportunity to put on the record the reason or reasons for your decision to step away from your role as an independent director at KPMG.
and I made a statement, Senator, as you've seen, and so it's simple. The firm was in the midst of what was called a clustering arrangement. So around the world, they're bringing various KPMG practices together, with a central board. And in the Asia Pacific, there were going to be 4 countries that were going to be part of that. I had other roles. Chair of Cricket Australia, CEO McKinnon, the 2 roles I was in. The additional workload that came with that meant that I was going to be unable to participate, which was from the 1st of September. So a cluster vote went through and I made the decision not to. But as you'll see in my letter, I was also unhappy with the progress on the whistleblower claims, and my request was that, pursuing the external investigation had been secured before I resigned, and that was important to me. And then the second part was I was very happy to participate in the committee, the whistleblower committee, post my resignation to help, because I felt that what I had seen was that there wasn't the urgency. We hadn't had the transparency I think we should have in the process, and I think the whistleblower deserved to have those claims properly assessed. And I made that comment in my last board meeting as well.
And the whistleblower came to you having gone through the first phase of making the declaration, and we read paragraph 10 from that, which was egregious. Can you recall if and when you saw that document?
So the initial contact was the end of 24. That's where I was contacted. It wasn't claims. You had claims, but it wasn't the details of those.
Yeah. And were they not provided to you by the leadership team at the time so that you could see the fullness of what the whistleblower was claiming? There
were some discussions around what some of the concerns was. But
there were some discussions, but did you get copies of the documents that KPMG leadership had taken from the IT system that were the whistleblowers?
Yeah, so my understanding of that was in April. That came in April. So initially it was presented as obviously a complex, HR case. We had some correspondence about that. There were some claims, but there was a view that there were nothing serious. It was kind of the intent that was given, and we then got an email just before Christmas saying that the matter had been resolved. An NDA had been signed, and we didn't hear anything until the end of April. End of April, that changed. We no longer were in a position that we thought this was just some complex HR matter. We wanted to understand.
And that's the reason that what triggered that action in April?
Yeah, no, it was an email that was provided from the whistleblower. That's correct.
So, having been frustrated at every turn, and on separation being promised an investigation and a chance to participate in that, nothing was happening. So, thinking, well, there's independent board members, and this is one of the things that KPMG has heralded, that it's got a fantastic governance structure, that you're sitting there as independent board members. The whistleblower pursues the next level, which is to come to you.
Yeah.
And at any point after that action of the whistleblower was taken, were you provided with the documents that were provided to the CEO after the raid on the whistleblower's computer? Were you given those?
I obviously can't tell you everything we're given, but we were given some information, yes. It was presented as this is information that we found. these may well be the substance of the claims, and that was, you know, in April.
And did those documents that you have seen, that we haven't seen, but perhaps Ashurst and Allens have seen,
sure,
did they refer to Telstra, Optus, Dexus, Lendlease?
Yes, there were companies mentioned, and that was part. So having seen that, the request, and all the independent directors were of this. Well, one, we wanted an external investigation. Two, we wanted clients contacted. I mean, if they've been raised here, have clients been contacted? And I believe they were. You know, in shortly after that in May. I think I have to check the dates, but yes, we asked for that. We also asked that if there's anything found, then there should be consequences, and a cultural review was.
Did you see the letters that you were advised were sent, or the communications that were undertaken following your request with those large Australian companies and also Optus Singtel from Singapore? Did you see the documents that were sent, or?
No, we just had a report back that the discussions were had.
Okay, so the CEO's rung and told them something. But at this stage, you figured out it's much more than a HR matter. It's a serious whistleblower matter about failures under APES 110.
Yeah, we viewed it very much at that point as a whistleblower claim, yes.
Now, we have a document here, and this is not to cast aspersions on your independence, but it surprises me somewhat that amongst the documents, and I'm not going to table this, but I am going to read from it. It's a document you should be familiar with. It's an email from Mr Shepherd, and it's to you as the members of the board, with the exclusion of you, Mr Abid. You must not yet have been engaged in the task. It's copied also to Louise Capon, and it says, "Dear Jane, Mike and Paddy, I have been advised that a current employee may reach out to you individually to raise concerns that they have. By way of background, this person was an employee in the role of a director with KPMG in the audit pursuits and retention team in 2022, is working for KPMG Australia, and this construct, among other matters, have been the subject of discussions over an extended period. Beyond his own circumstances, whistleblower has verbally raised concerns about KPMG's cultures and behaviours, but not formally. May I please ask that you contact Louise Capon should you be contacted. As always, please call me should you need to, and I can connect you with any support needed." Now, I'm struggling to read that letter and get the sense of the nature of your independence, because it seems way too close for the chair of the board, who has told us here that he kept his hands off completely, to be writing to you saying, "Heads up, you're going to get something from a potential whistleblower," and then say, "And as soon as you do, contact Louise Capon and let our Office of General Counsel know." That does not strike me as independent. So I'm interested in your response, and I'll go again to you, Mr Baird.
Look, I'm not going to defend that email. You know, that was received. That was back in the end of 2024, and obviously it was something that we responded to when the information came. We said in the discussion it was presented, and I understand with the context of hindsight, you know, how you can get to that position, but the context as it was presented was that this is an HR matter that's complex, and yes, some claims. The presentation from management was that we don't think there's any substance to what's been raised. Now, were we too trusting in that position? Clearly, we were. That trust stayed until you got to April. And
when the whistleblower contacted you?
Yes.
2025, the whistleblower contacted you and you went, "Hey up, what's going on
That's
here?"
That's right, because the last we'd heard that the matter had been settled, so we got confirmation.
And they left on all good terms, everything's fine.
Well, that's what we're told.
Right.
And then you know, so you can imagine when we then get the response, how we felt. And I can assure you, Senator, every independent director was determined to act on behalf of the whistleblower. We were no longer in a position that we were trusting. We wanted action. And yes, it still took time. And I'm not going to sort of try and defend that either, but I can tell you that there was actions to tell clients to get an external investigation, to get to the bottom of this and to ensure that the whistleblower was heard. That was our passion and determination.
Did you see the terms of engagement of what you're calling an investigation that is variously called a legal advice or report?
Is this post my resignation? I think that's post my... So I didn't appoint the external. That was being done.
So you saw none of that?
No.
Okay. I might come to you if I can in a minute, Ms Hemstridge, but before I let you go, Mr Baird, in terms of your independence, how offensive, how inappropriate is that email that I've just read to you from the chair of the board of KPMG Australia?
Yeah, I understand. That's not appropriate. I think that what I would say is that the construct of the board, it's obviously not a corporation, it's a partnership. The power we have the opportunity to advise. Management and board have the choice to act, but none of us would use that as an excuse. We operated as if we were directors, trying to get to the bottom of a matter that we should get to the bottom of.
Independently?
Independently, yeah. and we certainly took that.
So, can I ask Ms Hemstridge, were you offended by this letter, or did you think that was okay? From Martin Shepherd to you, directing you to go to the General Counsel, who had already been up to her neck in the separation agreement with the whistleblower who had come to you when everything else had failed.
At the time, I was, excuse me, I've got a cold. At the time that I received that email, I was not offended. I probably should have been. But I did as I was requested, and when I heard from the whistleblower, I contacted Louise Capon. And I was informed that an investigation was being carried out into the whistleblower's concerns.
And did you see the terms of engagement of that investigation and who was undertaking it, Ms Hemstridge?
I did not see the terms, and I was given to understand that Ashurst were undertaking it.
Okay. And do you consider that perhaps you should have been a bit more suspicious about what the terms of the inquiry were, given the new insights you had post the communication from the whistleblower with you in April?
With hindsight, yes.
Do you have a view, Ms Akopiance, and what did you do in response to that email from Mr Shepherd?
So the first part, could you just clarify the first part of the question?
Well, let's just go to Mr Shepherd, wrote this letter to you. Were you offended?
I should have been offended, but I also knew that if I was contacted, I was actually going to contact and have had conversations with the chair about different issues. So I didn't read that as that was necessarily the action that I was going to take. I think the first time I became aware more fully of this, because there are a series of emails that I was not copied on, was in April. And that is when I first received knowledge about the investigations and about the matters. And as Mike Baird has said, that is when we started to take serious action about the issues.
So there's communications that state things like that an external investigation has been commenced and it's being overseen by the independent directors. Do you think that is an accurate indication of your role? Did you determine what Ashurst looked at? Did you oversee the investigation, and was it external or was it
Senator, can I just confirm, is that in the statement that KPMG has provided, or is that in
No.
Oh, okay.
Yeah, that's in materials that have been provided to the committee that we are not going to table, but, indicate the way in which things are being characterised.
Yeah, and I'm sorry, could I ask the date of that? Just only because there are different...
25th of November.
2024?
So you're having trouble, Ms Akio-Pants, because it's hard to keep track of the investigations, isn't it?
It is, and also...
Are there 1, 2, 3, 4 or 5?
Yeah.
Are they investigations? Are they external? Are they internal? Are they legal advice? Are they what? So what are we talking about?
Well, exactly. And so in November 2024, I'm not aware of an investigation, I don't think.
Okay. So an external investigation overseen by the independent directors. Did you ever oversee an investigation? I'll start with you, Mr Baird.
No, I think what's being portrayed there, I wouldn't put that description on it, was that the Ashurst were looking at the claims, or KPMG were looking at the claims, sorry, and I mean that's all we knew. So that's the only thing we do. There was nothing that came back to us, as I said, until we got to April. So that wouldn't be a fair description, if that's the timing.
Yeah, look, there is so much
Just
more
on that
that we need to ask you. We're going to have to break because we are going to lunch. I'll give you the last question before we go to the lunch break.
Yeah, I just was going to ask Mr Baird on the back of that. Yeah, what do you, in your own words, what do you think an independent investigation should have looked like? Yeah,
it's a good question, Sarah. I mean, it's like a complete independent external view of all facts and matters, including interviewing the whistleblower, interviewing staff.
So you would appoint a legal firm as an independent director? Would you have that scope?
Look, I mean, I think...
is there a panel that you can choose from, or...?
No, I mean, in one of the discussions that I had, I mean, it doesn't matter the firm. Yes, I think a legal firm could do it, but, I understand the perception of potential conflicts and others, but the Ashurst discussion, I had discussions around Ashurst, was the whistleblower had already said that he had no confidence in Ashurst. So how could we appoint them, on that basis? So,
but you didn't get to appoint.
No.
The independent directors did not get to appoint. Those decisions were made by Mr Shepherd and Mr Yates and others with them as the leaders.
Yes.
The last question I'll go to Senator Scarr. Senator Pocock.
Thank you. So if I were to understand correctly, no independent inquiry and no real oversight by independent board members of an investigation. Have we understood that correctly? Thank you. You're nodding. I'm going to take that as a yes. Thank you. I want to go to another matter because I think what we're looking at here around whistleblowers and the treatment of them in the KPMG is a pattern. Mr Baird, Mr Brendan Lyon contacted you directly in July 2025, correct?
Yes.
He raised concerns about unpaid ICAC-related costs.
Yes, he did.
You met with Mr Shepherd to raise the issue, is that correct?
I did.
He had no memory of it earlier today, as I recollect. You raised the issue at board level, is that right?
No, with him personally.
With him personally?
Yes.
Did he agree to or make any undertakings in relation to pay the costs before you resigned from the board?
He agreed to look at it.
He agreed to look at it?
Yes, he did. My view is he's someone I've got a lot of respect for. He's done a huge amount of work. I wasn't involved in the challenges he had with KPMG, but my request was that he was treated well. I think there's an opportunity for him to treat him well, despite the differences he may have had.
Thank you. And Ms Akio-Pants and Ms Hemstridge, you are both aware, I understand, of the former partner, Brendan Lyon, also a KPMG whistleblower. Ms Hemstridge, are you aware of him and also that a KPMG has refused to pay his costs related to his compulsory IPAC examination on the Tahi matter, the matter on which he was a whistleblower?
I do know of Brendan Lyon, but I was unaware of anything to do with his compensation.
Can you take that on notice, and we'll indicate there will be further questions on notice. As I said, unfortunately, we may need to call you back as more material becomes apparent to us.
One last question. Did the board decide this in relation to the payment to Professor Lyon, or has it been handled by management without the board's oversight?
Okay.
Can you ask current board members?
I don't know.
Take it on notice.
So you have no notice of it's been handled by management, I would say, from what you've said, Ms Semstridge?
Yeah.
Certainly I never saw it at the board.
Never saw it at board
We
level.
never saw it at board that I can recall.
Thank
Senator.
you.
Last word to Senator Scarr.
My only question, we've run out of time, but thank you very much for your attending today. It's been reported that 3 KPMG partners have been sanctioned in relation to the Westpac audit matters involving Lendlease. To what extent were the independent directors involved in determining the sanction, and what was your part of the process?
I'm happy to take that, Senator.
And what were the sanctions?
Yep. The sanctions were brought to the independent subcommittee in April, and it was the end of a meeting, and it was a very short discussion about what the sanctions were. The ER panel, the Employee Relations Panel, had recommended a set of sanctions, and the CEO had recommended a different set of sanctions for the individuals. There were numerous questions from the independent members and a request that we have more time to consider the matter because there was no paper and there was no head of HR there to be able to ask questions of.
So you weren't given a board paper and you weren't, the head of HR wasn't there?
No.
Okay, go on, please.
So I personally requested more time to consider the matter and advised that that was not possible because the meetings were occurring with the individuals. And it was a very difficult position to be in. We came to the conclusion that the CEO, in the partnership agreement, the reserve matters are one of the reserve matters are consequences for partners. So it's actually the CEO's decision. And so I don't want to say. I mean, the words were endorsed, but it was not what I would call a good governance endorsement. And I have made it very clear that that can't happen again.
Was this the equivalent of putting a tourniquet on a very major wound just to try and close it up and keep KPMG alive?
I can't speak to the intentions sort of behind that. I think there were people trying to move, to close things off, to be able to finalise these things. But
so they could then make an announcement on the 29th?
Yeah, but I have to say it did not, I don't think it sat well with any of us, Senator, and so I'm just trying to be
So the committee does have to close, but there is one question Ms Lawrence wants to put to you.
Thank you. Just given your opening remarks about legal professional privilege, have you or will you raise a resolution to the board seeking to waive legal professional privilege?
Look, it's an excellent question, but, we actually don't sit on the Australian Governance Board anymore. We're on the South ASPAC Board, so it's a different governance structure now. So I haven't been on the Australian Board for almost 9 months. So
very important piece of information.
Yeah, and so we actually haven't been part of the decision-making process around privilege, and it's a very strange position to be in, to actually be on the subcommittee, but then not sort of involved in some
Perhaps
of the
the
other.
structure is intentionally designed to be strange.
I think part of it.
I think the answer to your question is that responsibility to raise this issue, for it to be reconsidered, sits with the Australian Governance Board. And lots of people that were at the table here, several of them are on that board, and think that would be a question that, and that would be considered by the Australian Governance Board. It's a matter for them, yeah.
All right, many more questions remain, but we do need to close. The committee will suspend now and we will break. Returning to matters, discussions with Ashurst, Allens and the New South Wales Law Society at roughly 3:30. And then KPMG will return at 4:30, and if we can keep that tidy at 5:45, we will ask ASIC to come and provide us with some guidance. We encourage you to provide any further information on notice, and we will have questions on notice, and sadly we may need to call you again, but thank you for attending and thank you for the clarity of your responses. Independent directors have a vital role to play. But the structures need to allow for that, and the relationship of the CEO and the chair in honouring and really facilitating your independence is critical, and I fear that that is not what we're seeing in this circumstance. I caution those who retain your role, and I congratulate you, Mr Baird, on stepping away. Thank you.
Thank you.
Away. Thank you.
Thank you.
Ask a series of questions, and I'm not sure how well I'm going to go with these, but we do have some concerns about the nature of the engagement, and despite having read everything that's come before the committee, I have absolutely no clarity about how many reports, investigations, legal advices have been given. It would be very helpful if somebody could clarify for us what it is that you've been engaged to do in a sequential way, and what is the status and definition of those tasks that you've been asked to undertake. So we might start with Allens.
Senator, so as we set out in our opening statement, we have tried to set out as clearly as we can, having regard to those constraints, the work that we have undertaken. So perhaps just in a minute or two I might try and just step through that as best I can. So it is on the public record that there were internal investigations of allegations raised by a whistleblower, and then an external legal review by another firm of those investigations. So it was after that that Allens was engaged, and that was in and around September 2025, to provide legal advice whether certain of those allegations expose breaches of any legal obligations. So
Can I just clarify, yes. Were you treating the person as a whistleblower or as an individual without the protections of a whistleblower status?
We were asked to investigate certain allegations. That's when we were brought in September 2025, in around that time.
Your understanding the person raising the allegations didn't have the protections as a whistleblower?
Well, I think that question might go to our advice. Could we perhaps...
Yeah. No, just because you're using it, I just want to make sure we understand that our understanding is this person had no status as a whistleblower. We're using that terminology now.
I beg your pardon?
But I just want to be clear, for the term that you were doing the investigations, that person did not have that status.
I use the term whistleblower because that's how we have been referring to them. So that's the context in which I was using it.
Yeah.
Sorry, Richard.
Thanks.
It may just be useful to take you through the chronology before that, and then Richard can carry on. Is that useful, Senator?
Yeah, because things are coming at us from a whole range of different documents, and they're described in such varying terms.
Yeah.
We don't have a clear chronological order with dates attached, even with these statements.
Well, thanks for the opportunity to appear, and I will refer to our opening statement. And we do see this as a very important task of the committee, and we're here to assist as much as we can. So thank you very much for the opportunity to appear. We were involved prior to that, which is why I just interjected that, and we were involved from January. I will get my colleague Jane Harvey, who was the relevant solicitor, involved from the inception of the matter, assisting KPMG on this matter. But we were involved from January, and then we were asked to...
Can we get the year? Because this does go...
Sorry, January 2025.
Yep.
We were then asked to provide a piece of advice to KPMG in respect of an internal investigation.
Okay, let's be clear about the distinction you're making there. So by January 2025, what do you know about the whistleblower?
I will get my colleague Jane Harvey, who is the relevant solicitor on the matter, to actually take you through the chronology in some detail prior to the August advice that we gave.
Okay.
Thank you. Jane Harvey from Ashurst. I received instructions in January 2025 to provide a piece of advice in relation to employment issues. I provided that advice in February 2025.
Okay, so to be clear, the advice sought was from whom? Like who commissioned you to do the piece of work?
I was instructed by KPMG, the Office of General Counsel.
Which is Miss Capon.
The particular instructions came from James McClelland.
Okay. So you were engaging with Miss Capon's office, but Mr McClelland was the one who gave you advice to deal with this matter. Okay. Now this is Mr McClelland, who had received a disclosure from the whistleblower on the 30th of May 2024, the words of which, part 10 was read into the record this morning.
No, I think it's someone else, Chair. I think the disclosure dated 30 May 2024 went to the head of audit. And I think
not McClelland, McPherson, sorry.
And Ms Harvey's referring to the Deputy Counsel.
I've got my Scots confused. Okay, so Mr McClelland, thank you for the correction. So Mr McClelland, and the advice that you provided in February was about an employment issue.
Yes.
Did it have anything to do with matters relating to the breach of APES 110 and the acquisition of confidential information and sharing within KPMG?
It was solely related to employment issues.
Thank you. That's very, very helpful. Okay, we start there. And it's advice. That's your first engagement?
Yes.
And do you have a number of other engagements over the course of time?
Yes.
How many?
I was engaged to provide another piece of advice in June 2026, which related to the internal investigation.
2025.
Sorry, 2025, yes.
June 2025. So January 25, employment issues. Second piece, June 2025. Again, what was that one about?
It related to the internal investigation.
Okay, it related to the internal investigation. Now, who did the internal investigation, which is separate from the advice that you'd given them in January?
I don't think I can disclose those details because they relate to the terms of my engagement.
And the important point there is, Senator, that we did not conduct an investigation, Ashurst, and we were not asked to conduct an investigation. We were asked to provide a piece of advice in relation to the investigation, internal investigation, as Jane just mentioned.
So it says it's called internal investigation, and we do know that through the documents that provided to us by KPMG that the Office of General Counsel was asked to engage in an internal investigation. So I don't think we're going too far off the reservation if we say the internal investigation was the responsibility of the Office of General Counsel and that they undertook that
and then they asked for you to come in and give them some advice on that internal investigation in June of 2025. Is that roughly the shape of it?
Yes.
Okay, great. Now, have you done any other work, Ashurst?
In relation to the allegations that are subject of this inquiry?
Yes.
No.
Have you been recently commissioned to do anything?
Not in relation to the matter before the inquiry.
Okay. Have you been recently commissioned to do anything adjacent to this committee?
No.
Okay. So there's only 2 pieces of work from Ashurst. Both of them reside in the year 2025 and January 2025. Advice on an employment issue referred to you by Mr McClelland under the watchful eye of Ms Capon, and then have a look at our internal investigation. Provide legal advice in June 2025.
Yes, and that advice was delivered, though, in August
of 2025. Okay, so my question is, can we have a letter of engagement with KPMG for these items of work that you did?
No, my understanding is those matters are subject to the client's privilege.
Okay.
So KPMG would have to provide that, Senator.
It's their document.
Yeah,
it's theirs to share with
document.
the committee, and they're choosing not to do so.
Correct.
Right. So they could say, "Oh, you've got a copy. You could provide it to the committee."
Correct.
And that's how I understand. I haven't had much experience in
you're
this,
right.
but you've got a locked box of documents. If I can just step you through that, as I understand the communication with the committee, we said we want all of this information. We also sent the same correspondence to KPMG. They said, "Okay, put it all together in a box. You've got it there, waiting. It's all locked up. The person with the key is KPMG. All they have to say to you is, open the box and let the Senate see."
That's correct, Senator.
But they own that. You can't do anything.
They own the privilege.
Yeah.
We've got competing obligations. We've got an obligation to you as a committee. We've got an obligation to the court to honour legal professional privilege. So, as you say, it'll be up to KPMG to release that privilege, and it's not for their lawyers to release.
Okay, thank you. That's really helpful at this point of time. Could I go to Allens, just for the sequence?
Well, could we ask some questions more of Ashurst and maybe finish Ashurst off and then go to Allens?
Do you mind if we get the timetable? Because I think there's going to be an interaction. Right. And it's once we've got that, I'll come straight back to you. Mr Spirio.
Thank you, Senator. It was in and around September 2025 that we were engaged to provide legal advice about whether certain of those allegations expose breaches of any legal obligations.
Okay, so help me understand this.
Yes.
You get a letter of engagement and it asks you to provide legal advice to KPMG board, CEO?
So the scope of that work,
yep.
We were instructed by and reported to the subcommittee of the board.
The subcommittee
of the KPMG board.
Okay, so this is the one with Mr Baird, Ms Ackyer-Pants.
Well, I don't think Mr Baird was on at that point, but certainly the other independent directors, I believe,
were on. So the independent directors board, you're providing them legal advice.
We are providing KPMG legal advice. We got the scope of our instructions, the scope of our work, and we reported to the subcommittee.
Okay. So in your report to them, you gave them a document and a briefing or a briefing?
Well, we were instructed in early September.
Yep.
And around early September-ish, we concluded our work in December, and that resulted in that's when we delivered our advice in December.
Okay, so and it's legal advice. It's not an inquiry. It's not an investigation. It's advice.
It is legal. It is legal advice.
Yep.
Yes. We undertook our own investigation to support that advice, but it is ultimately the product is legal advice.
Okay. And what you investigated was determined by the letter that you received, the terms of engagement. Is that correct? Mr. Dryden?
It might be
Dryden
helpful.
Or Drennan?
Drennan.
Yep.
Might be helpful if I assist there. From the beginning of the very commencement of the work, our instructions at all times came from the board subcommittee. Just to be clear, that was comprised of the Deputy Chair of the firm, Ms Mortel, and the 3 independent directors, Ms Copiance, Ms Hemstreck and Mr Abid. As Mr Spiro said, Mr Baird had either finished or was about to finish, and I had never had any interaction with him in relation to this matter. And we, as Mr Spiro said, were instructed by the board subcommittee to provide advice in relation to certain of the allegations, and that included undertaking our own investigation.
Okay, and certain of the allegations, I understand there were like 15 key points that were provided, and based on the material we have from the whistleblower, that items 5 to 15 were the matters that were investigated. Is that the right word? Is investigated? Is that what happened?
I need to be careful, Senator, so that I don't disclose any communications I've had with the client in the course of this work, but I think it was, you're correct, it was confirmed to the whistleblower which of the allegations identified in the letter we were to look at.
Okay. All right, so that document is 2 parts. It's advice to the board, and you also embedded in that some work that was an investigation into items 5 to 15 on the document provided by the whistleblower. Is that correct?
It was advice based on our investigation, yes.
Okay. What else did you do?
Our report of that work, the advice and investigation, was delivered in December, and our work at that point came to an end.
Okay. So you're calling it a report now?
Well, sorry, Senator, the reason I'm calling it a report, it was advice based on the investigation we'd undertaken, and I think on the cover page it was described as a report.
Okay, that's quite helpful. Now, and that's it? That's all you've done?
Well, sorry, may I pick up the chronology again,
Yep.
Senator? So that piece of work ended in December, as Ross has said. In late March, we were instructed to provide further legal advice.
March of which year?
March 2026.
Yep.
And our work for the board subcommittee and our advice more generally to KPMG in relation to these matters is ongoing.
Okay, so you were commissioned by whom to do this work as of March 26?
The part of the work we were asked to do was to provide further legal advice, and the scope of that work was the scope and our instructions, and reported to the subcommittee on that piece of work. There's also ongoing.
So does that mean that they determined what you looked at, or was the CEO or the board determining what you looked at? Like,
well,
who was in control of engaging you?
At all times, the scope of work we were undertaking in terms of investigation for the purposes of giving our advice has been solely at the instruction of the board subcommittee. But as Mr Spiro said, from this time forward, there are other matters beyond the work in relation to allegations that we were undertaking.
So that work is not complete? You have not reported in the way you use the term report briefly, which is like the end of it? I've given you the document for the work that you commissioned?
The work in relation to providing advice and undertaking further investigations on matters identified by the board subcommittee is ongoing.
Thank you. Over to you, Senator Scarr.
Thank you very much. Can I first go to Ashurst and can I say I appreciate the issues with respect to legal professional privilege, and I respect the position of both firms in that respect. Ms Harvey, just going to your chronology, and that was very helpful, I think, to the committee to get that on the record. Your first instructions weren't received until January 2025, is that correct?
Yes, that's correct.
So if I put to you that this committee's received a copy of a letter from one of the independent non-executive directors of KPMG, Ms Hemstritch, and this is an email from Ms Hemstritch to the whistleblower dated Monday 25 November 2024. And I want to read it. Dear whistleblower, thank you for your email yesterday. The firm has already commenced an external investigation into your concerns, which is being overseen by the independent directors. To assist with this investigation, would you please provide details in writing to Jane Harvey at Ashurst? Jane's details are as follows. Regard, Jane Hemstritch. So this email was sent to the whistleblower just before they signed a deed of release, saying that an external investigation, and we'll get to what you were instructed to do, had already been commenced by Ashurst. That was not correct, is it?
No, that was not correct.
So have you got any knowledge as to how Ms Hemstritch would have that view, that an external investigation had been commissioned to be undertaken by you as the lead at Ashurst in November 2024, some 2 months before you were actually engaged?
I don't. What I can say is that we were never engaged to conduct an investigation.
But you weren't engaged at all to provide advice in relation to these matters in November 2024, is that correct?
That's correct.
Or in December 2024?
I wasn't engaged to provide the piece of advice that I was asked to provide, and I provided in February until mid-January.
So you had no engagements on foot with KPMG in relation to the employment matter related to the whistleblower in November or in relation to an investigation, we'll come back to what that means, in November 2024?
I wasn't engaged until January 2025 to provide the piece of advice that I provided in February.
Okay.
Which was about the employment issue.
That was about the employment issue.
Nothing to do with the other matters that we've been discussing throughout the day, Dexus, Optus.
No.
Lendlease.
Okay. So, and if I can ask you, Mr Jenkins, to your knowledge, no one within Ashurst, no one else within Ashurst was engaged to provide any advice in relation to these matters before Ms Harvey was appointed in January 2025?
Not to my knowledge. I'll just see whether my colleague Leah, who
No,
was...
and nor mine, Senator. There wasn't any other instructions we're aware of.
Okay. And then, Ms Harvey, your evidence is you were then engaged in June 2025 to provide advice regarding an internal investigation undertaken by KPMG. Is that correct?
That is correct. Could I just, though with apologies, correct one matter that I was asked about earlier? I was engaged to provide one other piece of advice, which I provided in early May 2025, which was unrelated to the allegations that are in question.
Was it in relation to an employment matter, in relation to the whistleblower?
It was in relation to this matter, and it related to sorry, I'm just trying to make sure that I don't disclose something that I shouldn't disclose.
Senator, just your question to be answered by Ms Harvey will necessarily require her to disclose legal privilege. And we've said in our statement, I know the committee is obviously aware of the difficulty that we find ourselves in on this exact
we're
topic.
aware of that. So if Ms Harvey, if you need to say that falls within the scope of legal professional privilege, I can't share it.
Say what it actually relates to, but it did relate to the matter in the broader sense.
Yes.
Okay. In terms of who engaged you in relation to the
In May?
Well, I go back. In terms of January 2025, you're engaged by the Office of General Counsel, correct?
Yes.
So your client was KPMG?
Yes.
Okay. So your obligations in terms of legal professional privilege and other obligations arising from that lawyer-client relationship were owed to KPMG?
Yes.
And it is only KPMG who can waive legal professional privilege in that regard?
That's correct.
And that is KPMG's decision, isn't it? It's not yours?
It is.
Correct. And they've instructed you that they do not waive legal professional privilege, correct?
That's right.
Right. So
Senator,
then...
Sorry, just on that, if I could just say, our opening statement says exactly what you've just described.
I know, I wanted to get on Hansard.
Okay.
Yeah.
And I'm happy to...
It's not our first rodeo.
We've got your document and it'll show up in the papers, but we are trying to get things clear for everybody who's
thank
paying
you. I
attention.
appreciate that. Thank you.
And I understand you made that clear. So then in May 2025, you're engaged again by the Office of General Counsel?
Yes.
So KPMG was your client
Yes.
in terms of that engagement, and, for the record?
Yes, that's right.
And KPMG has chosen not to waive legal professional privilege with respect to that engagement?
That's correct.
Okay. And then in June 2025, you were asked, and the evidence you gave was, you were asked to give advice regarding the internal investigation undertaken by KPMG. That's the evidence you gave us. And then your advice to us is that you cannot disclose the terms of engagement because that's subject to legal professional privilege, correct?
That's correct.
But that legal professional privilege is owed to KPMG, and it is KPMG as the client who refuses to waive that legal professional privilege. Is that correct?
That is correct.
Okay. But you made it clear, and I just want to emphasise this point, and I'm coming to your opening statement, which I assure you I read, that, and I'll quote, Ashurst is appearing before the committee because were you part of drafting this opening statement, Ms Harvey? You're aware of what's in it?
I'm aware of what's in it.
So you're completely comfortable with what's in it?
Yes, I am.
Okay. Ashurst is appearing before the committee because we provided a piece of external legal advice to KPMG in 2025 which relates to this matter. Importantly, Ashurst was not asked to conduct, nor did it conduct an investigation of the allegations which are the subject of the inquiry. Why was it important for you to put that on the record?
Because it's been contradicted. Because it is just the fact that we were providing a piece of external legal advice. We were not engaged to undertake an investigation, and we did not conduct an investigation.
Well, can I put it to you, it was important to put on the record, and I'm happy for you, Mr Jenkins, if you want to answer this. It was important to put on the record because, amongst other things, this committee has a letter from one of the independent directors to the whistleblower saying that, in fact, you, Ms Harvey, had been engaged to conduct an external investigation into the concerns which is being overseen by the independent directors. But that never happened, did it?
It did not.
Oh, okay.
Does it concern you that your company's name has been used in this way to present erroneous information to the Senate and the House?
I see that email as being a mistake, and clearly that is not correct on our evidence. We were not asked to conduct an investigation, so I wouldn't go beyond that. But Yeah, all we can say is what the facts are, which are that we were not involved in an investigation, and I'll leave the conclusions up to others.
No, well, I appreciate that, Mr Jenkins, but I do take somewhat of an issue with your characterisation of a mistake. It's not like it's a typo. Obviously, the independent director who we received evidence from earlier today was of the view that Ashurst, Ms Harvey, to lead it, had been engaged to conduct an external investigation into the concerns of the whistleblower, which is being overseen by the independent directors. And that was not true, was it?
That was not true.
Yeah. This committee has been misled.
Okay, was there a clarifying question?
Look, I just wanted to understand the extent to which KPMG has continually been presenting to us that up until the very, very recently, the 11th hour, all of the claims that were made were unsubstantiated based on the investigations, the reviews, the legal advice that was presented by yourselves at Ashurst and by Allens. And I'm just trying to understand, to your question, Chair, how that has affected your reputation, where you guys are being thrown under the bus and, you know, essentially presented as the shield to their incompetence. Like, I mean, do you want to challenge the fact that they are making representations as though you had a very broad mandate to look into these matters when, in fact, the scope of the mandate sounds very narrow? In fact, it sounds like it was on employment grievance and not on the actual allegations that the whistleblower had been raising, and yet it's been represented to us.
I will correct that. It did relate to the internal investigation that KPMG had conducted. As we said in our evidence earlier, it wasn't solely in relation to the employment advice.
So that's the June 2025
that's the June and the
piece of advice?
August advice that was issued. But yes.
So would you have advised then KPMG to give that person whistleblower status to protect them, for example, from having their devices being covertly surveilled?
I'll have to ask my colleague in terms of what the specifics are. And we can't go into that given the legal professional privilege.
Okay.
If I could say, we're here to explain to the extent that we can what we did, and I think Ms Harvey, I think Ms Harvey has explained that. We gave an external piece of legal advice to KPMG in 2025. You've got now the chronology.
Yep.
And to Senator Scarr's question, it was important that we put what we said in our opening statement about what it was that we did do. We did
so
not
any of the
undertake
published information that you've seen from KPMG, did you want to correct anything else that they have been perhaps misrepresenting the extent of the work that you undertook for them, for either of your firms?
It's not for me. Look, there's been a lot of use, and I think this was mentioned earlier
It's your reputation,
today.
if you're happy for
No.
Just
if I could finish, there's been a lot of use of the words review, investigation, advice, and they seem to be used interchangeably.
Not by us.
What we're here to do is to tell you exactly what we did do. So what we did do was provide advice. We did not undertake an investigation of the allegations which are the subject of this inquiry. So I think that's about as far as we can take it.
Well, that in itself is substantial.
And it's very clear. Okay, back to you, Senator Scarr, because I think there's a similar line of question for Allens now.
There is. So, Mr Spiro, thank you for the chronology. And again, just to be clear in terms of this issue of legal professional privilege, your client, with respect to both of the engagements you referred to, the September 2025 engagement and also the late March 2026 engagement, your client is KPMG, correct?
Correct.
And your obligation of legal professional privilege is owed to your client. It is up to your client whether or not they decide to waive legal professional privilege. Is that correct?
Correct.
Right. So you're engaged in September 2025 and you described it as conducting investigation review of allegations and whether or not they exposed KPMG to breaches of legal obligations. And then, as I understood your evidence, you conducted your own, Allens conducted its own inquiries in terms of discharging its terms of engagement, correct?
Correct, but I might pass to Mr Dridden, who might be able to clarify further.
That is correct. We undertook our own investigation as part of that work in order to advise on whether or not there had been any breaches of legal obligations.
So I just want to hone in on what you actually did. So it's one thing to be advised that there are allegations that X occurred, Y occurred, Z occurred, and then you give advice with respect to, well, if that did occur, that would then have these legal consequences, A, B and C. It is another thing to engage in a forensic investigation as to what actually occurred. What was it that Allens did?
Senator, I am constrained. I cannot disclose communications with my client that would reveal the nature of the instructions and the communications that were necessary to undertake the work. We've said as much as we can say in that we were engaged to provide advice in relation to questions of whether or not legal obligations had been breached, and in order
with regard to the whistleblower or with regard to the entities that they were auditing?
Senator,
or both?
Senator, I'm similarly constrained. Well, our professional, legal and ethical obligations mean we simply are not in a position to be able to say any more about the nature of our instructions in this forum.
And you're constrained because you owe an obligation of legal professional privilege to your client, namely KPMG, and KPMG has not waived legal professional privilege, correct?
Well, that's part of the equation, Senator. We also have wider professional obligations, which mean not only do we need to observe and respect our client's instructions in relation to privilege, but we also have our own professional obligations that sit around that.
So how do they impact on whether or not you disclose to this committee these matters? Can you give some particularity?
Well, I suppose all I'm trying to acknowledge, Senator, is they intersect, is that it is the claim for legal professional privilege which sits around the work we do, which means while that claim is maintained by our clients, our professional obligation is to observe those instructions and to respect them.
Correct.
And that is what we are endeavouring to do in the evidence we're giving.
But the reason I asked the question, Mr Drennan, is you seem to suggest there's something more to it. There's nothing more to it?
I'm not suggesting there's anything more to it.
Okay. So you completed that work by December 2025, correct?
Yes, that's correct.
It's correct. And so after you completed that work in January, February, you had no ongoing retainer or instructions with respect to that work?
Senator, the file remained open. To the best of my recollection, we were doing no substantive work after the advice was delivered in December.
Right. And then, Mr Spirio, you said you then had a further transfer of work which commenced in late March 2026. Was that after Senator O'Neill gave her speech in the Senate?
Yes, it was.
So it was Senator O'Neill's speech in late March 2026, which was the catalyst for Allens receiving further instructions from KPMG.
That was certainly the timeline. I'm not trying to be difficult, but obviously we don't know. I don't know what was going on in our client's mind, but certainly it was after the Senator gave her speech in the Senate.
That was March 24?
March,
you were engaged?
No, March 26.
As in March 2026, I beg your pardon.
Yeah, but no, it was the 24th on 26th.
Oh, March 24th.
So on the 24th of March, I gave the speech. On the 26th of March, you received a new job from KPMG.
Sorry, I was referring to March 2026. I don't have the precise date of when those matters came in.
Okay.
But it was after Senator O'Neill's speech, correct?
It was, yes.
Correct.
Mr Drennan, correct? Correct?
Yes, correct.
Right. Okay. So I'll put it to Ashurst. There was nothing, you did nothing in 2024. You weren't instructed to do anything in 2024 when the protected disclosure was made, or the disclosure was made by the whistleblower. The whistleblower, under pressure, signed a deed of release in November 2024. The whistleblower understood that an external investigation was underway. Independent director thought Ms Harvey was leading an external investigation, but that wasn't the case, was it?
No.
And then Allens, you weren't asked to do anything through 2024 before the deed of release was entered into by the whistleblower. It wasn't until September 2025 that you received initial instructions in relation to this matter. You prepared your report, your advice, whatever we want to call it. And I understand the limitations around legal professional privilege, which KPMG is claiming. You provided your report in relation to that matter in December 2025, and then it wasn't until after Senator O'Neill gave her speech on the 24th of March 2026 that you were asked to do further work, correct?
Correct.
Thank you.
Can I ask a clarifying question
Sure.
of Mr Drennan? You said that you are constrained, and then you went on to say that Allens was engaged to provide advice on whether legal obligations had been breached.
Mm-hmm.
You're not prepared to tell us whether those legal obligations related to an employment matter or to the allegations of the whistleblower. However, just to be clear, you weren't engaged to do an investigation. Is that correct?
I'm sorry, Senator, what time frame are you talking about now?
I'm talking about September 2025.
In September, I'm making sure I'm just being very careful here, but in September 2025, we were instructed by the board subcommittee to undertake the work we were to do to provide advice, which included undertaking an investigation. And I think I mentioned earlier that we were very clear about saying that was certain allegations, and I think that's as much as I
And did the
can say.
board sign off on the mandate? Did all the board sign off on that subcommittee, sign off on your mandate?
The board subcommittee certainly were responsible for giving us instructions and certainly trying to think of what the right word is, but approving the scope of work we were to do.
So when KPMG put to us that there has been a lack of rigour and that has resulted in now the unsubstantiated findings being substantiated, is that your fault, your Allens and Ashurst's fault of demonstrating a lack of rigour in the work you were tasked to undertake, or was it KPMG's lack of rigour in defining the scope and mandate?
Ms Lawrence, I apologise. I really can't respond to that question because...
Do you stand by the quality of your work, Mr.
Absolutely.
And I should add that...
So let's get that on the record. Do you stand by the quality of your work, given the task, which we still don't know, that you were set?
Absolutely.
You did a great job with what you were allowed to do?
We did a great job.
Within the limits that you were set?
Can I ask both of you?
Yeah,
does get the same thing?
Thank you, Senator. And I was going to add that before. We absolutely stand by our advice. We see it as the highest standard, and we acted with diligence, seriousness and rigour with our advice. And
so you're not frightened that KPMG are going to come and sue you because you didn't do a good job?
No. We're very happy with the standard of our advice.
Right, so the failures that manifest in the resignation of the CEO cannot be sheeted home to the quality of the legal work that was done. It was something else. You stand by the quality of your legal work.
Correct.
Mr. Drennan?
We stand by the quality of our work.
Excellent.
Thank you. Just want to clarify. I know we want to move on, but did you hear the evidence of the independent directors earlier?
No, I didn't.
I heard most, probably not all of it.
We heard independent directors reflect on the nature of their role, and one of them, I think it was Ms Akopiance, said, we asked, did you oversee an investigation, which is what you're both implying occurred, and she said, I wouldn't put it like that. So I'm just wondering, is there a and we can certainly look at the transcript on this, but was there a misperception about the role of the independent directors here? Because there was clear evidence, I felt before lunch, that they did not feel they were in charge of these projects themselves.
Well, we didn't conduct an investigation, so that's not relevant for us, but it may be for Allens.
Mr Drennan?
Senator Pocock, all I can say on this topic, as I've already said, is our work in what I might call phase 1 between September and December, and now beyond March, so far as it concerns investigation of allegations, has at all times been overseen by the board subcommittee. Our instructions come from them and we report to them.
So you meet with the independent directors without any other KPMG personnel in the room and take your instructions in that way, is that correct?
Senator, two things. Firstly, I did mention earlier the board subcommittee includes the Deputy Chair of KPMG, Ms Mortell, with the 3 independent directors we've identified, and at all times our reporting on these 2 matters we're talking about has been to them.
So critically, Ms Mortell is the link between the board and the subcommittee. Everything that the subcommittee does, she knows about because she's on that as an ex officio almost appointment. But she is the connector between the board and the independent director board.
And she is one of the decision makers in crafting instructions.
I can't comment.
She's a member of the board alongside the independent directors.
Senator Scarr.
Oh, do you want to respond to that before I ask a follow-up question?
I'm sorry, there were a couple of things happening. I might have missed
she's a member of the board. Go back to...
So we have a subcommittee of which we have 3 independent directors and a Ms Morell.
Ms Mortell.
Mortell, sorry. Yeah, a lot of names today. So 4 people who are equal members of the committee who are instructing your work.
That is,
in both projects.
Just being in the first phase, the investigation of the advice and investigation of the allegations, and since March I was very careful to say, so far as we have been asked to provide further advice in relation to allegations beyond that time, that work has at all times been under instruction from and reporting to that subcommittee. The reason I just want to be careful is there is other advice that has been given since March which is of a different character.
By you to the subcommittee?
No, to KPMG.
To KPMG, other work.
And what's that? Is that a report or an investigation, or what do you call that, and how many pieces?
Senator, I'm sorry, I've been as clear as I can in relation to what we're doing without disclosing the nature of our...
Are the same Allens personnel engaged in both pieces of work?
Senator, I'm sorry, I don't think we can answer that question. Where these are matters that go to our communications with our client that are the subject of a claim for legal profession.
So can I just say, that on the record today, the independent directors, without Mr Baird, who has resigned his position, so Mr Abid, Ms Akyapants and Ms Hemstridge, said that given the change of structure for KPMG, now it's based out of Singapore, that they no longer have any real connection to the board, that they don't attend meetings. However, Ms Mortell, as the deputy chair, would be the person who is attending those board meetings. So it looks like she's hoovering up all the information and she's directing them, and that's the cover. This is what it's looking like to me. So how fundamental is Ms Mortell in this set of directions that relate to the board subcommittee?
Senator, all I can assist you with is to be clear about the composition of the subcommittee that we were reporting to, which I have been. As to matters that you've raised concerning, I suppose, the governance structure and the composition of boards, they are matters that KPMG will be best equipped to explain.
We'll get to those shortly. There's one detailed piece that follows on from a line of questioning a little earlier from Senator Scarr. It goes to Ashurst. You said, Ms Harvey, in addition to standing by the quality of your work, that you were given directions by Ms Capon as the Office of General Counsel and interacted with Mr James McClelland, acting on her direction, acting on Ms Capon's direction. Is that correct? What's the relationship? Who talks to you?
So, in relation to the first piece of advice,
yes,
in January,
yes,
the instructions were from Mr McClelland.
Okay. And it was the middle of January. You said that you got those instructions.
That's right.
Okay. So can I just let you know that I'm in possession from the whistleblower of a document from Mr McClelland, James McClelland, sent on the Thursday, the 19th of December 2024, in the afternoon to the whistleblower. And it says this: I refer to your below email to Laura. You previously shared information with Laura that has been passed to Ashurst. No further information is required at this stage. I will let you know if they need anything further. Referring to you, they need anything. So the information shared with Laura that had been passed to Ashurst, where does that sit in relation to Ashurst, seeing as you didn't receive direction to provide advice on an employment matter until the middle of January 2025?
Yes, I will correct the position there. I did receive a communication from Mr McClelland in very late December about these matters, but I was not instructed to do anything until January. So I was aware of the issue in late December, or the matter, I should say, in late December, but I did not receive instructions to perform any advice or provide any advice until January.
Okay, so I'm not a lawyer, but I'm kind of thinking, okay, I'm Mr McClelland, I'm going, okay, we're going to call Jane Harvey from Ashurst. Hey Jane, have a look at all this stuff. I haven't given you a direction yet, but just take it anyway and have a look. That seems really risky behaviour to me when you haven't actually been engaged. Is that a common practice?
Senator, I cannot comment on, I cannot answer that question.
No. In other contexts, so is that a normal thing that somebody says, "Hey, we've got a bit of a personnel issue here to deal with. HR are in on it, and we've got this person we want to sort. Here's all the dirt. You've got all the info, and that's it. There's no engagement letter with that. Is it normal for something coming out of the Office of the General Counsel, you know, by somebody as senior as Mr McClelland, just to be sharing information with you when you haven't been engaged? Because that just does not sit right with me, but I'm not a lawyer, so enlighten me, please.
If I could have a go at answering your question, because I would appreciate the opportunity to do so. As lawyers, we get instructions from clients, and those instructions are limited in the way that the client wants to limit them. That's not to say we don't inquire about things and ask questions, clarifying questions, but until we have an engagement, actually have been asked to do a piece of work, then that's the point in time in which the engagement commences. From that point in time, there might be. I'm not giving a view on your exact question that you just asked or the example that you gave with KPMG. I'm answering generally. So when we receive instructions, and I think Ms Harvey has said that she didn't receive instructions until January.
Yes, the middle of January.
Might it be possible that a client might call us and say, well, there's potentially something going on? Is that common? It really just depends on what it is. In an employment context, quite possibly. It might be something that we might receive some information at some time, and it might be that we asked, what would you like us to do? How can we assist? What might that look like? The client might say, we need to think about what the scope of the instructions are. We'll do that. We'll get back to you. I mean, I'm giving you a very general sort of answer to your question.
Nonetheless, it's helpful.
But it's about as far as I can take it.
We need some specifics here, right? Because I asked Ms Harvey a chain of questions and I did it very deliberately because this is of key importance to the whistleblower, who has given us cogent evidence that the whistleblower was put under pressure to sign a deed of release in late November has advised us that they were potentially threatened with termination in the first week of December in the event they didn't sign that deed of release. And the whistleblower understood that an external investigation had been commissioned, had commenced, that's what the independent director says in her email, before they signed that deed of release at the end of November. So I want to be very particular. Was there any other communication prior to December between Ashurst, between you, Ms Harvey, and KPMG in relation to this matter that could even be considered preliminary to the issuing of instructions?
I don't think I can comment on that question, given it's about client communications.
Well, sorry, you say that now, but you gave us evidence that you didn't commence the investigation until January.
Sorry.
I put to you...
Senator,
sorry, I'll finish my question and then you can
you.
respond, just for the benefit of our wonderful Hansard operator. So I put to you this email and the advice you gave was no, you hadn't commenced an external investigation. That's still your advice?
That's right.
Okay. But then the chair produced an email which has been provided by the whistleblower. We have a lot of information from the whistleblower. And you said, well, we could have, may have, I'm not sure if you're definitive, received information in December, preliminary to receiving instructions to commence the legal work. So in that context, don't you feel obliged to give us some sort of indication as to whether or not you received anything from the client before December 2025? Because otherwise you're leaving the committee and the public in the terrible situation of wondering, well, on what basis did the independent director say that? So again, I put it to you, did you receive any communication from Ashurst, from KPMG in relation to these matters before December 2025?
I can say there were communications. I cannot disclose the nature of those communications. What I can say is that I was never engaged to conduct an investigation. I was engaged in January 2025 to provide a piece of advice relating to employment issues.
So you're now confirming, so you told us you weren't engaged until January 2025, then you admitted to the chair that you did in fact receive, Ashurst did receive information in December 2025, and now you're saying there was other communication prior to the end of November 2025. Is that correct?
Yes.
When did you
commence receiving
When did you commence receiving information from Ashurst, from KPMG in relation to this matter?
I first received some information in November.
Okay.
2024.
Okay, and can you tell us the day, the first time you received information in relation to this, which is relevant, and I'll tell you why, because the whistleblower's account
25th of November.
was gone into by KPMG without the whistleblower's knowledge.
By IT on the 21st.
By IT on the 21st and 25th of November. Did you receive communication from KPMG in relation to the matters after 21 November?
I will have to take that question on notice. I do not recall the exact date that I received that communication.
Okay.
We'll take it on notice.
And I suppose that the key point, Senator, is that there was no engagement until January, and we were not engaged to conduct an investigation on your email.
Okay, so Mr Jenkins, you're saying regardless of the timing in relation to these communications, sorry, let me finish just for Hansard. It's just for Hansard, so they can get the order right. So what you're saying, Mr Jenkins, was there was communication between KPMG and Ashurst before the formal engagement, but you're saying in any event it was not an external investigation.
That is correct. That's
so,
my understanding.
Regardless of the timing in terms of when the first communication occurred, this representation from the independent director, and I'm not in any way casting any aspersion on the independent director, but their understanding that there was an external investigation had commenced in late November. That was simply incorrect.
That is my understanding.
Because there was never any external investigation.
And
Ms Harvey was never engaged to conduct an external investigation.
Not by Ashurst.
Correct?
And that's an open
Correct,
statement.
not by Ashurst.
Right. Thanks.
Can I ask a letter received from Mr Yates and Mr Shepherd on the 25th of March.
Can I just follow on from that bit, please, Chair?
Yep.
Can I just follow on?
We still have to get the Law Counsel, and we're cutting into our KPMG
I haven't asked the
returning
question
time. Yeah.
Mr.
But I'm just letting everybody know.
Yeah, sure. One of the things we're tasked to do as a committee is to try and understand a sequence of events. Now, at the time that both your organisations were engaged, the language coming out of KPMG and the evidence that we have that there's nothing to see here. Today, when we received KPMG senior executive, past and present, as witnesses, their language has shifted significantly to an acknowledgement or failure acknowledgement of breach. So when the Senator is asking you as individual firms what your role was there, we're trying to understand was your advice, and I know you can't give us your advice.
KPMG won't let you.
KPMG has made that abundantly clear that they're not in that realm of playing. But the document that the Senator referred to, Senator Scarr, about KPMG advising the whistleblower that an external investigation was underway. My question is, in your investigations and in your advice, did you interview the whistleblower?
No. So from...
Thank you. Did your firm?
We didn't. We did have contact with the whistleblower, but we didn't.
And my point is then, is that standard procedure for investigating an external investigation into what it appears to be a conflict resolution, that you would only draw your conclusion and evidence from one party? Is that standard operating procedure from the legal counsel?
I should say, from our perspective, we didn't do an investigation.
Sorry, I'm only led by the email from KPMG that advises us that you were instructed to conduct an... Mrs Harvey was instructed to conduct...
It's a fair question, and we didn't conduct an investigation. So
okay, thank
it's
you.
a good question. Yeah.
And just to be clear, that was not our scope of work.
Okay. Yeah. Thank you. Thanks, Chair. That's...
Thank you. A couple of final ones. After I made my speech in the Senate on the 24th, I got a letter from Mr Yates and Mr Shepherd on the 25th in which they said, the firm has treated these allegations seriously since they were first raised in 2024. In response, KPMG commissioned 2 independent law firms, which I'm assuming is you. You haven't heard about anybody else? 1 to review our firm's investigation into the claims and 1 to conduct its own external investigation. Are we clear? Is it you, Ashurst, who did our firm's investigation into the claims? Review?
No.
That is not what you did? And 1 to conduct its own external investigation. That wasn't you either, was it?
No, Senator. What we were engaged to do was the review of the internal investigation.
Okay, but it's at odds with the letter that I received after my speech from Mr Yates and Mr Shepherd. So I'll read it to you again for Alan's response. KPMG commissioned 2 independent external law firms, 1 to review our firm's investigation into the claims. Was that you?
I think I've been very clear about our instructions.
This is the language we're trying to deal with, yes. Right? So I've got to go with what they're telling me.
That was us, Senator. We did a review into the firm's KPMG's review of the investigation. So we gave a piece of external advice.
Okay.
So
that you're the first one. The second one to conduct its own external investigation.
That's you.
Senator, please go ahead, Ross.
I don't know what was in the mind of the person drafting that, but as I've explained, between September and December we were engaged to undertake the piece of work we've been talking about, to give advice which included us undertaking an investigation.
I have to say I'm starting to get very concerned about the mind of the person who was writing a lot of that document that's been provided to us from KPMG. And I note that KPMG have stated that after all the investigations, no allegations are substantiated. But after the speech, it took 2 weeks to actually get what was going on the public record. We don't have the resources of big entities like yourself, but it's amazing what a whistleblower's information to senators can do. So I think we need to restore our faith in democracy, which is much maligned in the public place. Has KPMG sought damages for botched investigations? Because basically they're blaming you.
Senator, I actually don't accept that they're blaming us, and
they're relying on your
there hasn't been any
investigations.
suggestion from
Go on.
There hasn't been any suggestion from KPMG that I'm aware of that we've botched our work.
They're not unhappy with what you did. They're not suing you because you didn't do a good enough job. No.
You should put the answer. No, thank you.
Are they suing you?
No, they're not.
Okay.
Can I just clarify, Ashurst, Mr. Jenkins, are you a preferred supplier to KPMG?
A preferred supplier.
Yes.
We do work.
I don't know what the right term is for it.
We do a relatively small amount in the scheme of our overall revenue in Australia with KPMG, less than 0.5%.
Sure.
Of our revenue.
And yourselves, Mr. Spurrier at Allens?
We have a long-standing relationship with KPMG.
Right. So when you were tasked to undertake, and appreciate we don't know the scope, we don't know the mandate, but did either of the people who were to then lead that body of work disclose to the KPMG board about any of, appreciate your point, might only be 0.5% here, sounds like it's a little bit more for Allens, around that commercial dependency and that the ability for which you could be investigating very senior executives that ultimately has culminated in the resignation of a number of people might hinder your ability to do that independently?
If I could just take it back one step, I think I've been practising for over 30 years and been in this role for over 10. In my experience, clients come to us because they expect us to do our work properly. They expect us to do our work, to comply with our professional duties, to do so with integrity, with objectivity.
Mm-hmm.
So
and with independence?
I'm sure they have that expectation, and we aim to deliver that. And in my experience, clients would be horrified if they thought we were pulling punches.
That said, what's the average relationship economically year by year between Allens and KPMG? Ballpark.
In terms of the work that we do,
yes, what are you billing?
In terms of the work that KPMG does.
Requests
sorry,
of you?
I beg your pardon. The amount of the work that we do for KPMG, similarly, by coincidence, it is roughly less than 0.5%.
And the amount?
I don't have the precise number.
Could you on notice give us, say, the last 3 years?
And just to close that line of questioning out then, and I'm happy for you both to respond, but given what we're hearing today is, potentially governance failures, or perhaps there is in fact some criminal matters that do need to be investigated by the relevant regulators and authorities, would you recommend to the KPMG board to waive the legal professional privilege to ensure that this isn't a cover-up over governance failures, or is it the LPP needs to be protected because there is concerns about criminal breaches?
I think there's a lot of considerations to go into that question, and it's difficult for us to talk about what advice we've given or not given.
Independent directors have suggested it be waived.
Yeah, the independent directors have said
they've all said it needs to be waived, which makes us think it's governance, it's embarrassing, people are going to potentially have to fall on their sword. But from what would you recommend? What would your advice be? that they waive it to prove there is no cover up here, that there is a genuine desire to see accountability and transparency of a leading body that is ultimately accountable for $4.2 trillion in people's company superannuation funds, so we know we can in fact trust this company? Or are you going to be part of the shield of protection?
I'm not sure we're Mr Spurio's client, but anyway.
That's a fair question.
But the independent directors are not ours either, but they can make a statement.
I think that's unfortunately that is straying into difficult territory in terms of the advice we may have given or not given to KPMG.
Okay. Can I thank you?
Could I just ask, because I have an opinion on that. Clients understand, will understand the concept of legal privilege. We all understand it. It's something that we are briefed about. It's not something just to be shopped around. And the question that you ask is a matter for the client to decide what it wants to do. I don't think it's for us to say do this or do that. I mean, we might get asked to what are our options, for example. That would be something that a lawyer would advise a client if asked the question. But ultimately, the privilege is not ours. It's not Ashurst, it's not Allens. It's actually KPMG's, and it's for KPMG to decide what it wishes to do.
And just to that point, though, would you have been asked advice about reclassifying this whistleblower as a workplace grievance? Would that be a matter that would have been put to you in their response? Because all the information we were provided up until the 11th hour was that this is a workplace grievance. Would that have been a matter that was put to you as part of the request around legal advice?
Well, first of all, I didn't do the legal advice. Ms Harvey did, as we've explained. And you're asking again about privileged information. That goes to the very heart of the communication that a client and a lawyer would have. But I just wanted to make it very, very clear from our perspective. You raised the word independence. Lawyers have to act independently. We do act independently. It's the way that we're trained. The rigour that we have, the quality of the work that we did, certainly from our firm's point of view, we stand by that. And I want to be really clear about that. You said the word reputation earlier, which, does that cause me concern? Of course it would cause Ashurst concern. It probably causes my colleagues concern as well. But, we as lawyers, at least from the Ashurst point of view, we undertake advice in accordance with the instructions that we've got. Sometimes we tell clients things that they don't want to hear. I'm not saying that that's the case. I'm speaking very generally now. And that's
we're just trying to understand has the work that's been undertaken over these last couple of years been intended to protect the company or to understand the claims that the whistleblower has been made, and I'm not sure that we're there yet based on the information.
Senator, may I add one more thing to
yes,
an earlier
because
question?
we need to call the Law Counsel. They're here before we get KPMG back.
I should be very quick. There was a question about the relationship with KPMG. I talked about them being a long-standing client. They are. For completeness, they are our auditor. I just wanted to make sure that was on the record.
And do you have a register of potential conflicts of interest that you manage?
Managing conflicts is part of my role in the broader team at the firm.
That's great, because it needs quite a moral compass to actually discern the conflict in the first place, and I am very concerned about, some of the behaviours of people who should know better about hospitality and other matters as well. Anyway, let's just thank you for being here today. If there are questions, I notice we're asking for a response, I think, by the 17th of July. Could I invite representatives of the New South Wales Law Society to come forward? And thank representatives of Ashurst and Allens for your attendance today. So, colleagues, I might ask one set of questions, and we'll get KPMG back, unless you...
I don't have any questions. Yeah, I have no questions.
I'll waive.
Great.
I've got one
so
if we need.
It's a long trip to Canberra from Sydney. We appreciate you coming, but I hope that you have been here for a fair bit of the evidence today. It's great to do our jobs, but it's always good to get out because you see other bits of the world that you might not normally see, and I think you've seen a few bits today perhaps that you'd rather not have seen. Could I ask you to indicate that you understand the conditions of the Senate with regard to parliamentary privilege and the protection of witnesses here in the Senate?
We do.
Thank you. For the Hansard record, will you please state your full names and the capacities in which you appear today? We'll start with you, Mrs Dawson.
Good afternoon. I'm Jacqueline Dawson. I'm the Senior Vice President of the Law Society of New South Wales, and I'm also the Chair of the Professional Conduct Committee.
Ronan McSweeney. I'm President of the Law Society of New South Wales.
Kenneth Tickle. I'm the CEO of the Law Society of New South Wales.
And my name is David Miller, and I chair the Ethics Committee of the Law Society of New South Wales.
Thank you very much, and thank you for the work that you do in those roles. Are you surprised about any of the evidence we've received here today from the legal firms representing KPMG?
Mr.
McSweeney?
I'm generally familiar with the facts of the inquiry. And I'm certainly surprised with the general revelations about the treatment of the whistleblower. It seems very disappointing that KPMG don't seem to have been absolutely forthright with the committee. It's not apparent to me that there's any issues with the advice that the law firms have given, but I'm not across all the facts or details, and so I'm reluctant to comment on the circumstances in which they gave advice, unless I was across all those details.
The circumstances in which advice is given is tied to a thing called a letter of engagement. Okay, and remember, we're not talking to lawyers here. We represent the full breadth of the community and all its glorious diversity. Hopefully many of them never engage in any way at all with the legal profession for any reason, right? However, does it concern you that KPMG appear to be positioning advices that they're requesting as a defence and not exposing to the general community, to this committee in any way, what it is that they sought these firms to actually undertake? Like there's a blanket. We did a thorough investigation. We got these external people in to do these investigations. Investigations covering all things, but an investigation can mean very different things depending on the letter of engagement. So, not to go to the specifics, could you explain what a letter of engagement should be? And with regard to ethics, can a letter of engagement be constructed in a profoundly unethical way to deliver a finding that you want to have rather than one that is in the public interest?
So, Senator, I think it's important to note that lawyers, solicitors are obliged to follow their clients' lawful, proper and competent instructions. There was nothing I heard from the evidence of either Ashurst's or Allens this afternoon which would indicate to me that they haven't done that.
They did what they were told.
Indeed.
They stand by the work that they did and the quality of it.
And ultimately, Senator, any advice given to a client, in this case KPMG, is privileged in the hands of that client. It's called client legal privilege for a reason. It's ultimately the client's decision as to whether to waive privilege over that. And it would be remiss of a lawyer to waive privilege over advice without their client's specific instructions to do so.
Okay. Can we go to the construction of a letter of engagement?
A letter of engagement or retainer, in ideal terms, would set out the work that's been required to do, the time frame for that work to be completed and the output that would be required from that engagement.
So we heard from Ashurst that mid-January, the engagement letter followed, we don't know how many pieces of information that flowed from what we now know was November in 2024 through to mid-January when the engagement letter arrived. I think it's fair to say that the engagement of Ashurst has been characterised in the public place by KPMG as an investigation. Today, it's clear to us that it was a request for legal advice around an employment issue. and that's got nothing to do with matters that are exercising our minds with regard to the, let me put it bluntly, theft of confidential information from clients who had a right to expect professional behaviour, ethical behaviour from their auditor. So this is why I'm very concerned about how critical these letters of engagement are. Can they be constructed in such a way as to prevent the lawyers from looking in the places that they would need to look if they were doing an authentic external investigation as the normal person in the street might think of it?
Well, Senator, I preface some of my remarks by saying a lawyer is obliged to follow proper and lawful instructions.
Okay.
Now, in determining whether or not the client is providing proper and lawful instructions, the solicitor is going to have to exercise their own objective review of those instructions, determine what's required under those instructions, and in the extreme circumstance where a lawyer was convinced that those instructions were not lawful or proper, they would refuse the retainer.
That's very helpful. One of the issues that's before us today, and you've made it clear once again that the legal professional privilege rests with KPMG, who are refusing to provide the documents for the committee to have a look at, even in confidence. There's been some discussion in the public place about the use, the misuse, the overuse of legal professional privilege. As leaders of the New South Wales Law Society, are you happy with the current practices around legal professional privilege, or is it getting a bit out of hand?
Well, we keep data on the number of complaints that are made about legal professional privilege. I don't have that data at hand, but I know that our CEO has that data at hand, and it's relatively small in the scheme of the amount of complaints that we receive, which doesn't suggest that is considered to be a problematic issue.
Look, could I add to that?
Yes, Ms.
It
Dawson.
doesn't follow necessarily that because there have been reports that privilege has been improperly claimed, that it has indeed been improperly claimed. So the starting point is to, I think, consider whether or not those reports are accurately framed. If the client claims the privilege, then any document which has been produced for the dominant purpose of obtaining legal advice or for the purpose of litigation will fall under that privilege.
But Mrs Dawson, there have been court cases where claims of legal professional privilege over vast quantities of documents have actually been considered by the courts, and the courts have actually found that legal professional privilege has been improperly claimed. Is that correct?
That is correct anecdotally.
Well, sorry, it's not anecdotally. There have been
I guess
cases.
what I'm saying is I know of those, but I haven't done an analysis of the number of them. What I would say about that, though, is reasonable minds can sometimes differ about those things, and if minds do differ, then the appropriate place to go to get that decision is to a court, to have that adjudicated.
We, in the course of the work of this committee, saw the abuse of legal professional privilege with regard to frustration of the Australian Taxation Office acquiring information about Mr Peter John Collins and PwC's practices of stealing information from the Australian government and then setting up a scheme to help multinationals avoid paying their fair share of tax in Australia. We know it's been abused against regulators from our experiences on this committee. Does it concern you that that is a practice?
Well, any improper use of any doctrine is obviously a concern.
So I note that you have a document here, November 25, protecting your client's claim to client legal privilege. Do you think that's a document that dissuades people from abusing it? Or is it an instruction in how to use it?
I'm not familiar with that document, but I would expect that it gives proper ethical guidance to practitioners as to how to properly advise clients and how to properly take instructions in a manner that protects privilege and that you're not waiving that privilege. As you know, Senator, privilege, the right to waive privilege sits with the client.
Look, we may have some more.
Sorry.
Last one?
Yeah, last one. I'm sorry.
You heard the earlier evidence, and it's my belief that this committee has been misled by KPMG in relation to the shield it has created through its use of these two legal firms. And I want to hear your opinion of that. But before I do that, I want to read to you and on to Hansard, because it's very relevant to what we've just been through, the letter signed by both Mr Yates and Mr Shepherd on the 30th of April, and it says, over the past 2 years we have identified 38 allegations from the whistleblower which we have investigated where possible. Some allegations concern matters relating to the whistleblower's employment by KPMG and others concern unethical conduct. As this matter has continued to evolve, we've escalated our oversight and response accordingly. Many of the allegations were initially expressed at a high level. Initially, we undertook internal investigations into these allegations. Given the seriousness of many of the allegations, we then engaged Ashurst to review the internal investigations. Upon receipt of a formal letter from the whistleblower on 19th of August 2025, setting out further detail in respect of a number of allegations of unethical conduct, we established a subcommittee of the board, including 3 independent directors from our board. Fails to indicate that Ms.
The non-independent was engaged.
What's her name? No.
Hemstridge.
Matrell, thank you, was also a member. This subcommittee engaged Allens to conduct an external investigation into the allegations of unethical conduct raised in that letter. The subcommittee of the board will continue to oversee the ongoing investigation of allegations of unethical conduct in the event further information comes to light. They then exonerate themselves entirely. Based on the evidence identified to date, the allegations have not been substantiated. I think we have seen a piece of theatre here today which is performative. There's been no real investigations, and these firms, acting in good faith, have been used as a shield by KPMG. What's your opinion of that use of lawyers and law firms in this way?
Well, I think I'm happy to take that question at first instance. I think you go back to the whole notion of proper and lawful instructions, Senator. It would be entirely improper for a law firm to be complicit in a deliberate attempt to misuse client legal privilege. I don't think there is anything in the evidence that I heard this afternoon that implies that that's the case on the part of Allens or Ashurst's.
Yeah.
They have been instructed by their client not to waive privilege, and ultimately it's a decision for KPMG.
Any further comment?
No.
Thank you. Thanks, Chair.
I agree with everything that you have said, but Mr Miller and Ms Dawson, your titles carry some gravitas. The Chair of the Ethics Committee and the Senior Vice President and Chair of the Professional Conduct Committee. Can you just, in a very short statement, each of you, give me an idea of, in what you have learnt from in the public arena from the KPMG handling of the whistleblower incident, do you believe it's been in any way a breach of professional conduct or you an overstep on ethics?
I haven't seen anything that would indicate that Allens or Ashurst...
No, I didn't ask about Allens, about KPMG's behaviour.
I think what's important there is to realise that the regulatory framework for accountants and lawyers is very different.
Yeah, I understand that. Yep, I understand that. I was asking you as the Law Society, and particularly your titles. You must have an opinion on not the relationship between KPMG and their lawyer, your opinion on how KPMG have handled this whistleblower incident.
Ultimately, any profession relies upon the competence and integrity of its members. And my own personal view, there are issues that have been ventilated in this committee which would cause some concerns in relation to the integrity of KPMG in the investigations they have either undertaken themselves or commissioned. Now, that is something that, if this committee makes findings, obviously we will, in conjunction with the rest of our profession through the Law Council, take on board and seek to address. It may be, for example, that we say we need more ethical training ourselves. I think lawyers generally are pretty ethical. They have a concern for ethics. That's shown through our queries that we get on our ethics hotline. But the more ethics, the better, in my view.
With all the caveats of obviously not knowing if exactly what appears to have occurred has occurred, I would endorse everything Mr Miller has said.
Yeah. Thank you.
Thank you very much.
Thank you
Thanks
very
for
much.
attending. We will suspend for a moment to return with the KPMG witnesses. Thank you. Mr Shepherd, Mr Stavros, Miss Mortell, Miss Hoggett, Mr Rogers, Ms Bell, Miss Capon, and Mr McClelland, Ms Hisgrove, and Mr Guse. We also have questions for KPMG International. Okay, I'm going to start this session for the first time today with my colleague Miss Lawrence, who will run through a quick series of questions. Then I will come to Senator Pocock, who will have questions for a different witness. So let's start off with you.
Thank you. If I could perhaps direct my first line of questions to Ms Capon. Did you have the opportunity to hear the evidence provided by Ashurst in particular and Allens? You did? I just wondered whether you might put on the record what you deem as the chain, like the order of events, the chronological events of when you first became aware of the allegations raised by the whistleblower, when that person's devices were surveilled without that person's knowledge, when you sought advice, legal advice, which we understand was related to an employee matter and not to the substance of the allegations the whistleblower was raising. I just wonder if you could just set out the record for the chain of events in that respect.
And if I miss any of your points, please let me know.
Thanks,
Lawrence. So, my team was asked to support Ms McPherson.
Sorry, Mr Capon, either we need to get the volume up or we need to ask you to speak up. So let's start with volume up.
Thank you. My team was asked to support Mr McPherson in his response to the letter that was received on the 30th of May 2024, shortly thereafter. I was notified that the request had come in. It was a combined support with our P&I team and OGC. Over that period of time from the whistleblower side of things, or the ethical concern side of things, there were some very serious but non-specific allegations in that letter, which was read out earlier this morning. And there were attempts to try to obtain specific information over that period, and I know we've discussed that throughout the course of the day. It wasn't until November that we identified the more specific information that sort of gave us the hook to do the investigation into the matters. There were attempts to try to extract further information, but we weren't able to obtain it until that
So can
point.
I just pause you there just for a moment? So we heard from Mr Mr McPherson that the whistleblower's computer and devices was first surveilled, I think it was around June, and then in November,
Yes.
was it?
It was not something that was done through OGC, so I'm sorry, I can't comment on that
But
one.
my understanding is that the surveillance in November was authorised by the OGC?
Again, I might actually ask my colleague to help me on this one, who was involved in
Yes, I'd be very keen to know who authorised it. And when?
So the document of the 21st of November, which has been referred to, was a document that was picked up. My understanding is it was emailed by the individual to themselves, and it's not uncommon for KPMG to monitor external emails which are going to private email addresses.
So you authorised the IT department to undertake a covert surveillance of his devices?
KPMG in its policies makes clear that...
You authorised it?
That it's all KPMG devices...
No, I understand the policy, but who authorised it?
...are monitored by KPMG.
Sure.
I'm the person who instructed the document of the 26th to be searched for, and it was identified.
And who authorised the 21st search?
I don't recall. That was picked up as an email which was sent by the individual to a personal email address.
But so who authorised the 21st of November search? No one? Can we get that on notice then to identify who authorised that?
It may have been picked up through our normal monitoring processes of emails going to personal.
All right, well, if we can get that confirmed, that would be helpful. And in the timing then of seeking legal advice, not in relation to providing this person with whistleblower status, which perhaps would have changed the course of action you chose to undertake in instructing that person's devices to be investigated, what was your rationale for pursuing it as a workplace grievance over a whistleblower status and giving that person the legal protections that ultimately has culminated in why we're here today? So they've been vindicated. So what was your rationale at that time to do something quite opposite?
Senator, I don't think they are to the exclusion of each other. So there were workplace matters that needed to be resolved, and there were a large number of them that needed to be worked through. As I mentioned before, we have a whistleblower policy, and that
which wasn't applied.
Well, that whistleblower policy provides for confidentiality. It provides for non-retaliation.
But no legal protections for the person to be able to name names. So you were saying in the statement just a bit earlier, you were frustrated by the lack of evidence that was provided, but the person kept saying, I'm not able to provide it without those legal protections from defamation or anything else. So why, as your first default position, was it not to giving that person the legal protected status that they were seeking in order for them to be able to do that and then ultimately protect the firm and everybody's jobs going forward, and importantly, the confidence in the sector plus the companies that are now exposed with their confidential data being circulated to the advantage of KPMG?
And Ms Lawrence, is a very good question, and our policy specifies the challenges with the way that the whistleblower protections are set up in law at the moment.
Yep.
And then goes on to say that we seek to, in policy, replicate those protections for our people under policy.
So your rationale was, I think there's sufficient complexity with the legal definition of whistleblower status that you don't qualify for it, and therefore I'm going to progress this as a workplace grievance.
No, we're going to progress it as a matter that is covered under our whistleblower policy and our protections, and I'll ask Ms Hisgrove to talk to some of the things that were put in place to try and make sure there was no retaliation in relation to this.
But that's quite contradictory to some of the correspondence I've seen from Mr McClellan to the whistleblower, where there was very much a shutdown of his request for additional investigation into the matters. It was, nope, the matter's been investigated and I'll remind you of your obligations under the deed, and no, there is no whistleblower status. So I'm trying to understand. It seemed like a very firm position, clearly informed by the advice you were receiving, and the investigations you were undertaking found that the allegations were unsubstantiated until this 11th hour. Just want to be clear about the timing, why the default was not to whistleblower protection status. So can you point to evidence that absolutely demonstrated he did not meet the threshold?
So the whistleblower was seeking legal advice from us that he had protections under legislation that is uncertain. And we did not want to give him legal advice around something that may not have actually been true. Whistleblower protections do not occur because their employer tells the person that they have whistleblower protections. They occur because the law works to grant them those whistleblower protections.
So, Ms Caplan, did you offer the whistleblower the benefit of independent legal advice and to fund that?
No, Senator, we didn't. But what we did do is we sent the whistleblower to the guidance that is on the ASIC website, and we provided the same advice that ASIC provides to whistleblowers in relation to these matters.
But you didn't fund external. You weren't prepared to fund external legal advice to help this whistleblower navigate what is, I'm sure you would agree, an extraordinarily complex matrix of law relating to whistleblower protection. That's correct.
But you will now.
Well, sorry, that's correct. You didn't offer to fund external legal advice.
We didn't offer to fund external legal advice. What we did is we tried to send him to ASIC guidance, which we thought was inappropriate, to help to explain that it is a complex matter, and ASIC guidance refers people to get their own legal advice.
Was it just a convenient way to keep him quiet?
No.
Well, it looks like it worked that way. And it worked for a really long time until he finally got to me. He had a pretty good go everywhere. He tried to tell you. You did the first investigation. Can I just put it to you that you bear responsibility for at least 3 preceding internal investigations that failed to substantiate the whistleblower's allegations, raising serious questions about their rigour and independence. You oversaw all that. You did the first lot. Nothing to see here. You went and got Ashurst to look at it as an employment matter. Finally, you go to Allens and you call it an external investigation. You still can't find anything wrong. But all the while, the information that drove Mr Yates to offer his resignation to Mr Shepherd was there, on the records, in the files that
he's been completely consistent.
Senator, can I just take you through a history?
But can you also, in that history, make sure you clarify how it is that we've been, on the face of it, misled with the way you've represented what's the legal firms have what work they've done for you, but also based on the email that Senator Scarr read out from one of the independent directors about their understanding of an investigation happening, which turns out there was no investigation that Ashurst was requested to do. So if you could include that clarification as well.
Senator, it might be better if I discuss the engagement with Ashurst. It was me who was engaging with Ashurst, so it might be easier for me to explain that timeline.
When did you start sending them information?
Sorry?
When did you start sending Ashurst information?
Ashurst, I discussed this matter with Ms Harvey on the 20th of November 2024. And an email was then sent to Ms Harvey on this matter on the 21st of November 2024.
Something else happened on that day too, didn't it, Mr McClellan?
It did, what Senator. That was later in the day. We identified the document that the individual had sent to themselves.
And you identified it through what means?
Just to be clear, the matters which were referred to Ms Harvey in the earlier email were employment-related matters.
And that's all you found when you went into the search on the same day of the 21st?
Later in the day, the document that we're talking about was identified, and that document was sent to senior leadership.
So no alarm bells about the Optus, Telstra matter, Dexus, nothing. You weren't concerned about anything about that. You were just worried about what
I don't believe Optus is mentioned in that document of the 21st. I don't believe Optus is mentioned in that document of the 21st.
Oh,
what is?
Many of the allegations which are set out in the document that KPMG provided to you, the summary of factual findings, but I don't believe that Optus is mentioned in the document of the 21st.
And what date? Just remind me.
21st of November 2024.
Yeah, but what date did the whistleblower provide to Mr McPherson his detailed outline of his concerns?
So the paragraph which was read into the letter earlier today, which was paragraph 10 of a long list of issues, he provided on the 30th of May 2024, and there were a series of communications after that seeking information from the whistleblower.
So you already had that? You already had that?
Yes, Senator.
Before you went in to look at his documents and find this workplace matter, you already had that document, and paragraph 10 is now a matter of public record.
Yes.
That wasn't enough for you to do anything?
That paragraph doesn't identify any clients, any individuals, any teams,
yes,
anyone who we could actually move forward and speak with, which was why there was an effort to try and engage with the whistleblower to seek further information. Now, the difference is the document of the 21st of November does contain that information.
And so why do you find him now meeting the threshold as a whistleblower? Like, what's shifted in your minds that have you arrive at a different position that he does have the protections?
So, Senator, he's always had the protections under KPMG's whistleblower policy. Under the law, that's a separate issue. And so we don't bestow whistleblower status on anyone. That's a legal question. And you need an eligible whistleblower, which undoubtedly he is. The communication needs to be received by an eligible recipient, which Mr McPherson is not an eligible recipient. He is a partner in a partnership, as opposed to being an officer of the corporate entity. You need a communication in relation to wrongdoing within the entity that you're complaining about. And again, there are issues about, is it in the partnership, is it in the corporate entity? Not things that we want to get into, and it also needs to be based on reasonable grounds. The individual undoubtedly is in the best place to make that assessment. And in addition to that, workplace grievances are carved out under the law on these issues. So rather than get into that, KPMG has a policy which seeks to emulate the Corporations Act and say, we will treat all issues in the same way as the Corporations Act does and afford individuals with the benefit of whistleblower status.
Thank you. If I could just go to Ms Hisgrove, what's your involvement in the matter?
My involvement in the matter really started around about the end of May when my team was asked to support some advice on a relocation matter that had been underway for about 2 to 3 years.
And did your role change after the whistleblower's exit from the firm in November 2024?
My role in regards to?
In the matter.
Well, for the 3 months that I was supporting this with my
who's been through the tumbler in terms of the treatment.
I appreciate that. I was answering the question in the context of the support that we were providing the whistleblower for the 3 months, but if you'd rather I do not.
Let's be careful though.
Yeah, absolutely. Well, there was a lot of support provided, and during that particular time there was a lot of, what I would call, regardless of the capital W, lower W whistleblower debate that's here today. We did at the time meet with his people development manager. We met with the national managing partner, Mr. McPherson. We met with the teams that the whistleblower was working with, and we made sure that there was absolutely no retaliation, that he shouldn't be left off any jobs, that he should be included in team meetings, that the team meetings he was participating in, he should continue to participate in. And we also encouraged him every step of the way, is my understanding. Just about every second day there was a conversation from my team with the whistleblower. We strongly encouraged him to report his matters to the international hotline at the time.
We've got KPMG International to answer questions about that shortly. So
just to maybe wrap up there, so what does it mean for a HR manager when your CEO resigns over something that starts as a workplace matter?
Sorry,
what does it mean for a HR manager when your CEO has had to resign over something that started as a workplace matter?
Well, I didn't see it as a workplace matter. I saw it as a very serious concern from the 30th of May onwards. And as we were managing through the raft of taxation, superannuation, bonus issues, and there was a lot of employment issues that we were working through, but at the same time we were giving every opportunity for the whistleblower to give us a little bit more detail about the what, the when and the why, so that we could actually start a formal investigation.
Are you serious that everything that's on the record in item 10 was not enough? It was not enough for you to go, holy moly, this is outrageous. Get the guy a lawyer. This is huge risk to KPMG.
Yep.
Let's find out absolutely everything. Give him every protection he needs. This guy's gold for us. Let's get in and let's get it sorted. Instead we get, no, we can't help you. Go and read what's on the website. Go to someplace else, find out a little bit more. Just look after yourself there. We're going to treat this as a workplace matter. We're going to commission inquiries about workplace. Nothing about profoundly unethical behaviour, nothing about the sharing of confidential information. None of that triggered an action of alarm and response to that. It was just, let's manage this person. And it looks like it was less, let's manage this person.
Senator, thank you, but to the best of my ability, we absolutely tried.
But you are only in the HR part. Is that correct?
At the time, I saw it as a broader than a HR issue. I had concerns about what was in the 30th of May
so
email.
who did you light a fire under? Who did you go to and say,
we can't do this. Who did you raise your concerns with? Was it to the CEO? Was it to the chair?
Well, our CEO was aware of the matter at the time. So, but quite regardless...
So he should have been acting already, is that what you're saying?
Quite regardless, we also, time and again, Julian, Mr Macpherson offered for me to meet with the whistleblower. And he agreed to do that on the 31st of October and the 15th of November. When I met with him on the 15th of November, I felt at that time that I had created a strong connection with him to the point that he was starting to open up to me. I gave him a lot of assurances about confidentiality. I made a promise to him at the time, given that he shared information with me at the time, that it warranted our referring it into our OGC team for an independent external investigation at that point.
An independent internal investigation.
External investigation. Yeah.
That is not what happened. There was no external investigation then.
But that was the promise that I made to him, yes.
But it never happened. It never happened. Ashurst has given us evidence that they were not commissioned to undertake an external investigation.
They never interviewed the whistleblower.
They didn't even interview the whistleblower. How can it be, Ms Capon, that one of your independent directors is in a position where she wrote to the whistleblower and said, we have commenced an independent or commenced an external investigation when it never had been?
Senator, I believe we understood we had made contact with Ashurst and that investigation was starting, and that there'd been correspondence between Mr McClelland and Ms Harvey around starting that investigation.
No. They said, they've given evidence under oath that they were never instructed to conduct an external investigation. Are you saying they're lying?
Senator, I can just refer to conversations that I understand occurred.
Mr McClelland?
Senator, they were not. Ashurst have given an accurate account. They were not instructed to conduct an independent investigation. They were instructed to review the internal investigations in relation to the employment matters and in relation to the ethical issues.
So, Ms Capon, with all this going on, you just told me they were instructed to conduct an investigation. You told me they were instructed to conduct an external investigation, and then Mr McClelland says, well, in fact, they weren't instructed to conduct an external investigation. What am I to make of that?
Do you guys talk to each other?
Senator, at the time that the email you're referring to was sent, it was sent to the employee to enable an external investigation to be conducted.
She said the external investigation had commenced.
The whistleblower, as I've said, communications were there with Ashurst, a discussion on the 20th of November 2024, an email on the 21st of November 2024, and at the time that the email was sent, offering the whistleblower the opportunity to communicate directly to Ashurst. The intention was that they would communicate to Ashurst and it would all form part of an external investigation.
But Mr McClelland, you just told me that you didn't instruct them to conduct an external investigation.
Senator, the work that was actually conducted in the end, because the whistleblower did not provide information through to the law firm. They didn't provide any information through to the law firm. Was eventually undertaken by the firm.
And this is, sorry Mr Shepherd, this is important because the whistleblower has told us, and I'll go to our HR representative, that they were under pressure to sign that deed of release, that they were being threatened with termination in the first week of December. So they were under a lot of pressure to sign that deed of release, and they understood an external investigation was going to occur. It did not occur. And so they signed that deed of release in good faith under enormous pressure, and then what they thought was going to occur did not occur.
And Senator, I was going to offer that, on the 29th, our statement acknowledged that the investigations process...
And what year, please, Mr Shepherd?
29th of May this year.
Thank you.
That release acknowledged that across the various investigations, we just didn't meet the whistleblower's requirements, which is the point that you're making.
Didn't meet the whistleblower's requirements, Mr Shepherd. It's like I parked my car in 10 minutes over time. This has real-world consequences to this whistleblower.
Of course it does, Senator.
Look where you are now.
Senator, the deed, as part of the deed, there was a commitment to do an investigation. The investigations that took place, and you've heard there was an internal investigation, there was an Allens review of that, and there was an external investigation. That commitment to do the investigation was honoured. It just never met the requirements of the whistleblower, and we accept that.
Because they didn't speak to the whistleblower.
We accept
they didn't even speak to the whistleblower.
Well, so that's not to say, and again, I've been clear on this morning. That's not to say that there wasn't real attempts in order to speak with and engage with the whistleblower.
You even had a director leave, an independent director leave because of dissatisfaction with the process.
I dispute that, and I don't think Mr Baird said that.
I think he did.
Well, I had the
look, Mr Baird said you should release the documents that you're claiming LPP.
I'd like to come to that in a minute, but just in relation to...
Are you going to release them? That's all we need to know, Mr Shepherd.
Just in relation to the
yes or no? Are you going to release them, Mr Shepherd? Are you going to release the LPP documents?
I had the conversation with Mr Baird, Senator, so I'd like to reflect on that conversation.
Well, you can do that in
I'll do it very
writing.
Briefly, Senator, very
But
briefly.
I want to ask you, if you're going to refer to Mr Baird, who said release the LPP, is it your intention now, after this today, Mr Shepherd,
so when Mr.
are you going to release the LPP? Are you going to release the documents, yes or no?
I would like to have closed the last issue, but since you've taken me there, let me go to that
Well, that's
point.
where you went. You brought in Mr Baird.
Well, I did. So would you like me to talk to the
No, I
circumstances
just want you to
of his
answer my
departure?
question. It's a yes or no. Are you going to waive LPP
So, Senator,
and provide the documents to the committee or not?
Senator, as I explained this morning, there's been testimony from people here today that have
I'm not interested in your reflections by other people.
I was going to
Answer
offer something, Senator, but I need to be able to finish the sentence.
Answer the question.
May I finish?
I want you to answer my question and then
position?
we'll see. Answer my question, please.
Senator, from what I've heard today, I am minded to move on the furnishing of those documents.
What does that mean? Can you tell me, are you going to do it or not?
I'd
You
like
may
to
be minded, but are you going to do it or not?
Maybe.
May I speak to the circumstances, Senator?
Please be clear.
So as I said this morning, I am the individual that is in command of more information than others in relation to this issue, and I have taken advice in relation to legal professional privilege and how it works, and that includes, and I know you heard from the lawyers, but that includes advice directly to me from a very, very senior Australian
and you're entitled to do that, but that is not what we're not talking about.
And I've done that, Senator. So if I could finish.
I'd love you to.
So the information that I'm in possession of takes into account all stakeholders, and that includes the investigations, which could become criminal. I have information around the sanctity of the way that an investigation is performed and people's opportunity and right to give information fairly and in a protected way. I'm trying to balance that against the Parliament's requirements as well. The advice I have from a very senior silk is that if confidentiality is not preserved on those documents, my privilege will be worth nothing. So, Senator, my concern and the advice that I've taken from a senior silk is that really it doesn't come down to waiving privilege, which you're asking about. It comes down to the confidentiality of the documents which are provided, Senator.
And we've given very clear information about that, which is the way we treat all of the documents that come before us.
Yes.
So I go back to my question. I gave you a chance to finish a few sentences there and put some position. You still haven't answered my question. You're minded to do something. Are you minded? Will you, in fact, provide the Ashurst and Allens documents that are the inquiry documents that you're relying on? Are you going to provide them to the committee? Will you waive your privilege claim that has frustrated the work of this committee?
Well, everyone has agreed today that legal professional privilege is an appropriate legal right. Everyone has agreed that today.
That's not my question.
So I am asking you to create an environment where I can give you what you want without me waiving legal professional privilege, which I think is a reasonable ask.
Oh, well, I don't believe so at all. I think that's just wordsmithing. Once more, Senator Scarr, I hope you're as disappointed as I am.
Very quick question. What sanctions were imposed upon the partners in relation to the Lendlease Westpac matter? What were the actual sanctions imposed upon Ms Laurie, Ms Hoggett and Mr Rogers?
I can't speak to that for the reasons this morning I explained. I was not part of the board subcommittee that had carriage of these issues.
Mr Stavros, what were the sanctions imposed?
Senator, I don't know the exact numbers, but I know someone here will be able to give you those numbers.
So you're telling me you're here as acting CEO. You don't know the answer to the question?
I roughly know the numbers. I wasn't involved in those sanctions.
And I'm
very happy to provide.
Chair, you don't know the numbers as Chair?
Well, I appropriately don't know anything to do with the sanctions imposed on those individuals because I had a conflict. That's why I wasn't on the subcommittee.
Okay, who knows?
Ms Grove can answer that question, Senator.
The sanctions are applied through what we call our Employee Relations Conduct Panel, and Ms Capon and myself and our Chief Risk Officer sit on the panel together, and what we do is just look at misconduct issues across the firm, as part of that we deliberated on this issue. We felt around July 2025 we had sufficient information to base an outcome of a sanction on, and at that meeting we agreed on a financial consequence of 20% of Ms Hoggett's bonus, 20% of Mr Rogers' bonus and 10% of Kim Laurie's bonus for year end.
Okay, so how much were they?
78, 38 and 22 respectively. 78,000, sorry, 78,000.
So 78,000
for Ms Hoggett?
78,000.
Yes.
And what percentage of your remuneration for the year, Ms Hoggett, was 78,000?
Senator, just to clarify that Ms Hisgrove is talking about the recommendation. The final outcome of that went to the subcommittee board was 10% of my bonus, which, based on current estimates of income this year, would be about 40,000.
Oh, 40,000. So why was it originally proposed at 78,000 but it ended up at 40,000? How'd that happen?
Well, it's the role of the ER conduct panel to make a judgment call and refer it to the decision maker. In this case, we referred it to our CEO.
Who was?
Andrew Yates.
Mr Yates. So you made a recommendation it should be 78,000 and Mr Yates determined, no, it should be 40,000. Is that correct?
Well, I wasn't in the subcommittee of the board meeting when the change was made.
Gee whiz, it's like pulling teeth, isn't it?
Yep.
Mr Yates determined it was 40,000.
Yes.
And did you hear in relation to Mr Rogers?
The original recommendation was 38,000.
And what was the ultimate decision?
I think it was half of that, so it would have been 70.
Mr Rogers,
70.
what was the ultimate decision?
I think it was 20% of my year-end bonus.
Sorry,
so
Senator,
around 20.
if I could just help you out here.
No, sorry. I'm trying to get the figures. So we got 78,000 original recommendation in relation to Ms Hoggett. 78,000 became 40,000. That's what the CEO determined. Mr Rogers, the initial recommendation from the relevant HR committee was 38,000. The ultimate amount was?
I think mine was 20% of my bonus. So.
Mr Rogers was 22,000?
Yeah.
So the ultimate amount was 22,000, so decreased from 38,000 to 22,000?
No, sorry, I beg your pardon. Mr Rogers' original recommended from the ER panel was 22,000.
And how much was it?
22,000.
Okay, so yours didn't change?
No.
Okay. And then Ms Laurie?
Ms Laurie's recommended was 38,000.
And what was the ultimate decision?
Half of that.
19,000.
Yeah.
19,000. And Chair, Mr Shepherd, you heard the independent directors. They were absolutely aggrieved with the process in relation to the consideration of the sanctions. It was in their testimony, it was raised right at the end of a board meeting. There was no board paper. It was thrust upon them and they wanted further time to consider it, and they found the whole process to be totally unsatisfactory. How do you respond to that?
Well, Senator, as I've said, I wasn't there, I didn't participate in it, but my understanding is that the independent directors had a dedicated meeting just on this issue. And they would
Goodness
give
me, have we got the right? Have you got the same independent directors as I think you have? The ones who appeared and gave evidence earlier today.
There are others that were in that meeting that can confirm that, but that's my understanding.
Senator, I was in the meeting. It was a singular meeting that dealt with sanctions, where Mr. Yates came in and provided his decision to the subcommittee of the board. It was a requirement, given the seriousness of this matter, that the subcommittee of the board endorse that recommendation, and the subcommittee of the board did endorse the recommendation.
Okay, well, we're getting this on Hansard. You're saying, Ms. Capon, that the independent directors we heard from today endorsed, agreed with Mr. Yates's decision in terms of decreasing those sanctions for each of those partners. Is that your testimony?
Yes.
They agreed with it?
Yes.
That's your testimony?
Yes.
Gee, okay.
In the interest of time, it may need to be on notice, and I appreciate there is still an investigation underway with those parties involved in the Optus Telstra matter, which culminated in the CEO resigning. But I'd be interested to understand, are they on gardening leave? Have they been taken off the cases? Like, what action has already been taken, and what's the likely next steps in terms of managing that affair as well? And Chair, I do have some questions for Ms Mortel, who I understand is not able to be with us now, that I'd like to put, which relates to what's been framed as Project Magenta.
So I might have an attempt at your first question on behalf of Ms Mortel, because it really is a question for her. My understanding in relation, I think she said this earlier today, that in relation to the Optus Telstra matter, the legal report was received, I think she said very recently, maybe last Friday.
I think it came in Sunday night.
Sunday evening. And I don't believe that the ER panel has met yet to work through sanctions.
Right. And they could have investigated that back in 2024.
I'm not sure that issue. Well, I can't speak to whether that was visible at that
what
time
triggered the contemplation of it being in such a serious manner that it was expected back in 2024 when the whistleblower raised it to today? Like, what was the transition, the shift in thinking that went, actually, maybe there is something to see here?
I think, but again, it's difficult because I wasn't part of that investigation process, but I think some new information was discovered fairly recently that gave more information to further the investigation.
It'd be so much more efficient, so much more respectable, and so much more ethical if you were willing to provide the reports on which you rely to the committee in confidence in the way that was offered to you, which is the standard practice. Mr Shepherd, will you comply?
I would love that, Senator. We've got nothing to hide, and as I said early this morning, I've been trying to navigate this ground where I protect collective interests. I do think that the summary document that we've provided with you with is a really good and accurate summary of what is in those underlying reports. I understand.
And relying on your own voice.
Yes,
it does not.
Want them.
I beg your pardon.
It offers no evidence. Your document of the 30th of April.
That wasn't your strongest card.
It's 38 allegations of which you exonerate yourself on every single one of them, and you don't even say here is the evidence to come to this viewpoint. You say there is no case here.
So
that is completely unsatisfactory.
Will we see the documents? Will we see the reports?
Senator, in your letter to me, you've undertaken that the documents will be held confidential. Should you choose to release them, you'll consult with KPMG, which is very helpful. I know it's not my place to ask, but would you consider agreeing to that discussion, including whether you releasing them would waive my privilege, accepting that it is KPMG's privilege, not the Senate's, Senator?
Mr Shepherd, I'm not about to make procedure on the run in the Parliament of the country.
I accept that.
That I am very proud to be a citizen and a senator for. So I will not give you a response to that request. I think that's entirely inappropriate, frankly. I will give you this information, that this committee, and I've served on this committee now since 2012 in a range of capacities, has received thousands and thousands of pages of highly confidential material that, frankly, some of it would make this look a little less important than it might be to you right now.
we receive confidential information all of the time, and we very cautiously and judiciously examine that, and only where we think it's absolutely in the public interest to put those things on the record would we consider doing that, and in doing so, we would approach the person who's provided to us in confidence to let them know and potentially have a discussion about it. That is our standard practice. We're not going to make a special rule for KPMG in this circumstance particularly. So they're the terms and conditions. No special deal for KPMG. This is the standard operating practice of the Australian Parliament. All we're saying, will you comply with that and provide the documents that we have sought?
On the basis, Senator, of what you've just framed, I'll provide those documents to you, and I'd like to provide those with an accompanied piece of advice that I've received from a top silk as well, if that's
We're
okay,
happy to receive whatever you want to send us in addition to the things that we have requested.
Thank you.
And I understand that Ashurst and Allens can take a direction from you to provide a key, and those documents can be unlocked post-haste for the committee's consideration. And let me emphasise how much more smoothly and perhaps more civilly the day might have proceeded had you acceded to the request of the Senate in the first place.
Senator, I do hope, though, that you understand the very difficult position that I've been put in based on the advice that I've got from the legal profession, frankly.
Well, I have some sympathy for you, Mr Shepherd, but let me tell you, my far greater sympathy is with the whistleblower.
Of course, and mine. Of course, and mine.
Right.
And mine.
Okay. Over to you, Senator Pocock,
Thanks,
and we
Chair.
have ASIC waiting in the wings.
Yeah, I have a couple of lines of questions. I want to come to you, Mr Stavros. In your email to staff when you took over as acting CEO, you said you were, quote, uninvolved in the current whistleblower matter. Is that right?
That's correct, Senator.
You've been a member of the National Executive Committee since July 2021. Is that correct?
That's correct.
When were you first made aware of the current whistleblower allegations?
About 3 months ago, Senator.
Were those allegations reported to the National Executive Committee?
No, they weren't. And the 3 months ago was basically there's an existence of a whistleblower, no details.
What was the substance then that you were provided?
The substance at that time was effectively that there was a whistleblower and that effectively it had been managed for a number of years, but nothing more than that, Senator.
So 3 months ago you were told there is a whistleblower, no detail.
Senator, if you want me to give you the timeline, in the week that I got appointed, so the 29th of May, is when I first was exposed to details.
Did you personally take any steps to ensure that the KPMG whistleblower policy was followed, yes or no?
In respect of what, Senator?
When you heard this information?
On the 29th? Or
Yep.
in
As
29th?
CEO, yep.
Effectively, we'd made that announcement at the time that I became the CEO, so there was an acknowledgement, effectively, that the whistleblower process hadn't been appropriate.
So what specific steps have you taken in relation to this whistleblower?
Senator, the only thing I've done is really to understand the situation at the moment. Clearly one of the actions out of this, and one of the significant actions out of this, is the whistleblower policy and process and ethical culture of the firm, and that is almost the number one priority for me in respect of going forward.
And did you personally request any reporting on how the whistleblower was being treated, yes or no?
I was given access to the reports that we had.
So you didn't. The answer is no. So when you say you were uninvolved, you meant you were aware of it from 3 months ago, but you thought it was...
Senator, I'd say that 3 months ago I felt that it wasn't appropriate for me to probe that situation because effectively it was a whistleblower situation, so that was understandable that would be held tightly and that the people involved were dealing with it.
So we've heard that the whistleblower was not formally recognised as a whistleblower until recently, correct?
Yes, I've heard that today.
Yes. So for several years they were not a whistleblower under KPMG's policy, but they...
No, under our policy they were always a whistleblower.
Under your policy,
Correct.
voluntaristic
not
KPMG policy.
And I think you also heard, Senator, that they were seeking something that we couldn't provide.
They were seeking recognition.
They were seeking whistleblower status under the legislation, which we were not able to provide, Senator.
Which you didn't provide.
But they were always a whistleblower
Yes.
in our context.
So you are now acting CEO, Mr.
Yes.
Stavros. Do
Yes.
you accept responsibility for the firm's treatment of whistleblowers? Yes or no?
I'm part of the leadership and part of the firm, so I feel just as accountable.
Are you part of it? You're the CEO. Is that not a distinctive role, a leadership role?
Absolutely, Senator.
So have you previously had any contact yourself with this whistleblower?
No, I don't know who it is, and I haven't, Senator.
Have you had any contact with any prior whistleblowers in KPMG?
Probably the only person that's been sort of labelled as a whistleblower is Brendan Lyon.
Pardon?
Brendan Lyon.
Mr. Brendan Lyon, have you apologised to any whistleblower ever? Yes or no?
Can I take an opportunity here, Senator, to make a statement around that? Brendan was part of my group at KPMG, a partner in my group. I provided him support in a way that I thought was appropriate. What has become clear is that support fell short of what Brendan expected or needed, and I do want to take the opportunity to apologise to Brendan.
Fell short or failed? Fell short, that's a phrase we've heard a few times.
Sorry, it fell short in the context of it certainly I could have done more in that respect. So it's something I've reflected on over the years around what else could I have done for
And what
for
else
Brendan.
would you have done? What have you done?
Well, part of it is probably just the putting my arms around him, getting him out of that environment, and bringing him to Melbourne to be with me. That's just one of the things that I think of, Senator.
I'm going to come back to that.
Yeah, sure.
In the time you've been an executive partner, there have been at least, I think, 4 public whistleblower scandals in KPMG,
Sure,
which I summarise: an ethics exam matter first, a second ethics exam matter, the Tahi matter, after which the whistleblower, Professor Brendan Lyon, left the firm. The whistleblower of the first ethics exam left the firm. The current matter, the whistleblower has left the firm. In each case, the whistleblower's employment was adversely affected, correct?
Senator, potentially yes. Yeah.
Do you accept that the pattern raises concerns about KPMG's systemic treatment of whistleblowers?
Senator, I don't have the information of all those whistleblowers, so I can't make that conclusion.
Do you accept that each of these 3 or 4 whistleblowers have suffered irreparable harm because of the conduct that saw the dismissal of your predecessor, Andrew Yates?
Senator, again, I can't make that comment because I don't have the details. I've heard the details of the current whistleblower, and I think we've all acknowledged that his treatment wasn't appropriate and he has suffered.
Is Brendan Lyon now a whistleblower under your policy, Mr Stavros? Yes or no?
Senator, I don't know. I can't answer that.
You don't know. Can anyone at the table tell me the answer, yes or no? Is he a whistleblower recognised in KPMG under your policy?
Senator, anyone who makes a complaint through a hotline is a whistleblower recognised within KPMG, and the whistleblower policy generally applies to anyone who raises concerns within KPMG.
And you can still undertake surveillance of their equipment when they've made a disclosure without their knowledge as a whistleblower, according to your policy?
Senator,
that's normal?
Everyone is aware it's part of our employment terms. It is well known that all our devices...
But if they're endeavouring to hold evidence to be able to back in their allegations, and the firm that is the subject of those allegations undertakes a secret surveillance of their equipment to find out what they know without telling the whistleblower, you don't think that gives rise to concern about integrity amongst a raft of other issues?
I think that's a statement, isn't it? I think
I don't know. Is it a statement? I think it's a question. Like you're saying on one hand,
we were trying to find out what was going on. We were trying to understand where the challenges were. We were trying to,
but without actually asking them directly.
We asked them directly on many occasions.
But Ms Capon, you were also in the process of negotiating a deed of release with them. You had the sword of Damocles hanging over the whistleblower's head, and you're accessing their internal documents whilst you're negotiating a deed of release which would have substantial consequences for them as an individual and for their family and for their future. Do you recognise that?
Senator, I do think on that point,
So we need an answer, I think. It's pretty important for your legal counsel to...
There was always a commitment. There was always a commitment to the whistleblower that post the settlement of the deed, that there would be an investigation in relation to the matters. Now we've talked,
and that's why they've come to us, Mr. Sharma.
Of course, I mean that is
worked very well.
That is the reason that we've made the apologies. We put the statement out on the 29th. I mean, we don't want anyone to have to turn up on the steps of Parliament House to be heard, Senator.
If I want to come back to Mr. Stavros and the pattern here, because there are really important questions about the treatment of the current whistleblower. I absolutely agree. But you were Mr. Lyons' manager, were you not, Mr. Stavros? Meaning, as a partner, he reported directly to you. Is that correct?
That's right, Senator.
So Mr. Lyons' 2021 evidence in the New South Wales Parliament shows he directly reported serious concerns about KPMG's misconduct and internal reprisals against him to you. Did you do anything about Mr. Lyons' concerns? Yes or no?
Senator, his concerns were well known in respect of the leadership
That makes
team.
no difference to my question. Did you do anything?
I did talk to people at the time around some of his concerns or views.
Protect him.
Mr. Lyons' 2021 evidence is that you said you would not assist due to the seniority of those involved. Did you say that?
No, that's not right, Senator. Senator, my understanding of the situation was there were some views he had around the execution of the Tahi engagement.
Not just his views. It was.
Sorry?
They were continue.
They were views. They were his perspectives on it, and that those perspectives were being dealt with by the engagement team, which did include senior people, and so therefore it was being dealt with, or those people were dealing with it. It wasn't about anything in terms of being afraid of raising those issues. It was that they were being raised, dealt with.
Mr. Lyon was sacked on the 30th of June 2021, and you were promoted by Mr. Andrew Yates 12 days later. Is it fair to say that Mr. Lyons paid a very high price while you benefited within the firm?
Senator, those two things are unrelated, and my understanding is him being sacked is not my understanding as well.
Mr. Stavros, are you aware that Mr. Lyon incurred legal costs of some tens of thousands of dollars for representation in compulsory hearings by the New South Wales Independent Commission Against Corruption?
No, I'm not aware of that, Senator.
So, for clarity, this is not historic, and I want to go to you, Mr. McClellan. I want to table a letter from Mr. Lyons' solicitor to you on the 7th of July, 11 months ago. I ask that that be tabled. It includes a clear request from Mr. Lyons seeking reimbursement for their legal costs from KPMG. If we could have that distributed.
You want a question, Spark?
Can I finish this line?
Yes, please. Yes.
Nothing.
Can you give a copy, please, to
I'm doing
yes, it's the entire package. So on the front is a letter requesting a reimbursement, and as I would just ask you to confirm that KPMG has refused to pay those costs. Is that correct?
Senator, I'm not aware of this request.
You are now.
Well, it's, sorry. What's the date of that letter? If you've got it in front of you.
I'm trying to work through this.
The date is 8th of July 2025, and it's signed off by James McClellan. Mr. McClellan, can I come to you? The chronology for the seeking and the background to that solicitor's letter is there, tabled before you. Can you see that the Chief Commissioner of the New South Wales ICAC had to make an order, if you see further into the pages, the Chief Commissioner of the New South Wales ICAC had to make an order in the public interest, as he's declared it, to allow Mr. Lyon to specifically state why he sought those costs from you. And I'm going to quote, I, the Honourable John Hatzisteragos, Chief Commissioner, quote, being satisfied that it is in the public interest to do so, hereby vary restriction of publication to permit Mr. Lyon to disclose to KPMG as his former employer for the purposes of seeking indemnity for his legal costs in relation to a summons issued by the Commission. Do Professor Lyons' legal bills remain unpaid? Yes or no?
Senator, I don't. Do you mean has KPMG paid his legal bills? I don't know whether he has paid his legal bills separately.
Oh, he has not paid them. Have they been paid by KPMG?
I don't believe so, Senator.
So I should say I'm not aware of whether Mr Lyon has paid those bills. I want to come back to you, Mr Stavros. Do you consider forcing a whistleblower to fund a whistleblower you've declared you wish you had wrapped your arms around more securely? I'm not sure whether he would be saying that at this moment, after many, many years of argument with KPMG, forcing a whistleblower to fund their own legal costs for an investigation caused by misconduct within your firm, and which has had untold costs, yet again, on another whistleblower, is consistent with your stated position and KPMG's stated position, yes or no?
I'd need to understand more about it, Senator.
Do you accept that the failure to assist Professor Lyon could be perceived as adverse treatment or reprisal?
So this is the first I've heard of that, Senator, so I don't have all the background.
Mr McClellan, you have not communicated that issue to senior leadership in KPMG?
Senator, that letter is dated the 8th of July 2025. Mr Yates was the CEO at that point in time.
And you discussed it with Mr.
responsible for the whistleblower. You didn't share it with him?
You shared it with Mr Yates, did you?
Senator, at that point in time, instructions in relation to this matter came from Mr Yates.
And what was his instruction in relation to the treatment of these legal costs?
Senator, I'm an Australian lawyer. I'm not able to share the details of the instruction, but the letter makes clear that that KPMG is not paying those legal costs.
Well, why don't we ask Mr Shepherd, do you waive legal professional privilege now? So, Mr McClellan, can I answer the question?
Well, my understanding... Sorry,
that's will you waive legal professional privilege? So Mr McClellan can answer the question.
Well, I think... I don't know if I can do that, can I? I mean, was there a deed or anything... I mean, there's a...
He's an internal lawyer. You're chairman of the firm.
I can come to the deed, and I want to go to you, Mr Wingrove, if I may. You worked closely with senior KPMG Australian leadership, correct? And that includes working with Mr Stavros, Mr Shepherd, and you also have a close long-term relationship, I understand, with Mr Peter Nash, who we've heard a little about today. You became aware of the current whistleblower matter, no doubt, some time ago, and it has been raised with KPMG International. Is that correct?
You're on mute.
We can't quite hear you. I think that you're still on mute. I know you've been on mute for many, many hours, so we understand.
Sorry, Senators, can you hear me now?
We can.
Okay, thank you. To answer your question, Senator, yes, I know those individuals, of course I do. I've worked with them over a number of years. In terms of any involvement in the current matter that you are referring to, the current whistleblower matter, I first became aware of that when it was announced in the Parliament by the chair of your committee in late March. And you may be aware I step into the global CEO chairman role with effect from the 1st of October.
So you were CEO of KPMG of Australia at the time of the ethics exam, the first round, misconduct matter. Is that correct?
Yes, that is correct, Senator.
A whistleblower raised concerns about that conduct, and that individual is no longer employed by KPMG. Is that right?
I'm not sure about their employment, Senator. What I can say is...
Are they employed in KPMG, Mr Wingard? You don't know?
I don't know the answer to that question. I don't know the answer to that question.
Did that individual? Well, then, are you aware that did they sign a deed as they left KPMG?
I'm not sure of that. I can't recall, Senator. What I can say is that it was raised. My understanding is the issue was raised in an exit interview by that individual.
So they have left.
I'm not sure whether they. No, I'm not sure whether they actually exited in the end. It was raised as they were discussing arrangements to either leave or potentially be retained. The issue that was raised was taken on board by us, because that's how we became aware of it. we conducted an internal investigation. We immediately advised the PCAOB, our regulator. We also, importantly, took a number of steps internally to address that issue, including preparing a set of materials where we would look at the individuals who had been involved in this. There were a number of people that came forward. We provided an amnesty period for people to come forward, and we provided penalties and sanctions of people involved, including a number of partners leaving the firm as a result.
And clearly a limited effect, given that we're in round 2 of exam cheating. As CEO, you were responsible for decisions related to that matter. Is that right?
Yes, that's correct.
And Mr Grove, you personally sacked a partner, Brendan Lyon, for his exposure of major ethical and professional misconduct in work for the New South Wales government, didn't you?
That is not correct. I was asked to go to a meeting with Mr Lyon in late June, I can't recall the date, late June 2021. That was as I was about to retire as a partner of the Australian firm and as CEO. I attended that meeting at the request of Mr Lyon. That request was passed to me by the leader of our business, one of our businesses at the time. I was actually on leave that day and I received a phone call that morning. I came into the office specially at the request of Mr Lyon to sign his retirement deed. That was because a retirement deed can only be signed by the CEO of the firm. I came into the office, I met with him personally. I signed the deed at his request. The reason he wanted the deed signed, my understanding, was that he wanted to commence other employment quickly and he wanted the deed signed. So I said to Mr Lyon that I was sorry that circumstances had arisen whereby he wanted to leave. But he was not sacked. He left of his own volition, and so any premise that he was sacked is not correct.
So did you insist on removal, in that you negotiated the exit package for Professor Lyon, did you insist on removing liability for mental harm caused by that whistleblower's experience?
I did not negotiate the deed. The deed was negotiated by the leadership of that area in conjunction with our HR area at the time, is my recollection.
And was that clause that I have quoted part of that deed of signed by KPMG and Mr.
I do not recall, Senator. I signed many retirement deeds for partners over the course of my time, but I do not recall that.
Thank you, Chair.
Thank you very much. I just have a couple of questions for the International as well. You might be familiar with the Big Four. It's a book by Ian Gow and Stuart Kells. Talks about the auditing sector and how once upon a time there wasn't one and how important it became because fortunes were being lost as companies were standing up and putting fake books into the market. Auditors came along and said, you can trust us. And that's where it all began. And today has been a revelation of some break in that concept of trust for the public around the services that are provided by one of the Big Four. This book describes the value of having a global office as a valuable marketing bauble. For smaller practices bidding for work, the ability to call upon global resources and international centres of excellence adds another touch of magic dust, another layer of glamour with which to dazzle current or prospective clients. But it goes on to say that the model, a network of separately owned franchises with a weak head office, is unusual and inherently unstable. The decentralisation of the firm's governance and risk management is one cause of the observed diversity of conduct among the Big Four personnel, which in turn is one cause of the recurring scandals. This is what we're talking about, a franchise model where it's a little unclear about who's in charge and where you should go if you have a whistleblowing complaint, and there seem to be cavernous gaps between head office in a country and the international entity. Can I just table a document written by Nick Fildus in Sydney and Stephen Foley in New York from the Financial Times for your consideration? While that is being provided to you, and hopefully digitally to you over there in London,
I understand that the matter from this financial reporting in the Financial Times, that KPMG International was contacted about the whistleblower matter that we've been discussing in the course of the day. Is that correct?
Sorry, Senator, who are you posing that question to?
To either yourself, Mr Wingrove, or Ms Collins as the international representatives.
Thanks, Senator. I think Ms Collins is best placed to answer that.
Thank you.
It is correct, Senator, that the whistleblower contacted KPMG International, but a long time after first contacting KPMG Australia.
So they tried to knock on the door of the Office of General Counsel, no result there, things were promised, some made-up things were promised and not delivered. Then we end up with communication with the independent directors here in Australia, frustrated by that whole process not delivering any transparency. The whistleblower then communicates with KPMG International. It's reported here that KPMG global bosses repeatedly refused to investigate concerns raised by the whistleblower in its Australian business, a decision that threatens to widen a crisis that's prompted the resignation of its two most senior executives in the country. Why did KPMG International handle the matter of this whistleblower in this way?
That's not an accurate summary of what we did, Senator. We took this incredibly seriously and we engaged with the whistleblower multiple times over months to understand the concerns he was raising. The issue was that he refused to provide us with information that would allow us to look into the matter properly, and indeed also insisted that we not speak to KPMG Australia about the matter.
Can you understand the level of betrayal and frustration that the whistleblower has by the time he turns to the international entity? And I've looked at the whistleblower policy and I can see it goes, go internal first, you'll be treated really well, but we've just heard from Senator Pocock's questions how badly that turns out. If that doesn't work out for you, go to international. And you get the same runaround, it seems, from report of the whistleblower and from this article in the Financial Times.
I don't accept that that's a fair assessment of the situation,
So what
Senator.
did you do What did you do for the whistleblower?
We repeatedly asked if he could provide information to us which would allow us to look into the matter properly. We wanted to do that, but we couldn't do it without some information that would enable us to do that. And indeed, in one letter, we were explicit as to the sort of information that we needed so that we could look into the matter. And he did not provide that information until November 2025, at the same time as he provided a lot of information to the Australian firm.
So, Ms Collins, you're the Global General Counsel. You're not with us today because you're not in the country at the moment, but I understand you do work from the Sydney office. Is that correct?
I am located in Australia. I very rarely go into the Sydney office, but I do work in Australia.
And your workspace in relation to key figures in the Australian operation, do you on a regular basis run into your colleagues such as Mr Shepherd or Mr Yates or other senior leaders? Are you co-located with KPMG Australia?
No, I very rarely, as I just said, go into the office because I work from home because of the hours that I need to work predominantly, but there is space in the office allocated to us. It is nowhere near Mr Yates's office, for example. It's not even co-located with the Australian legal team.
Is it in the same building? Is it in the same building?
It's in the same building.
So you might share a lift occasionally with Mr Yates, or not anymore, but maybe now with Mr Shepherd. Mr Stavros?
I do. Look, I go into the office perhaps 5 times a year.
Right, so you don't see them that often.
It's very rare that I see them.
What assurances has the international firm sought from KPMG Australia with regard to this matter?
We haven't sought assurances from the Australian firm because we honoured the whistleblower's insistence that we not speak to them about the matter. What we knew was very high level.
Only somebody had honoured the whistleblower's insistence that he be treated as a whistleblower. This wouldn't have ended up this way.
The Australian firm can answer how they treated him, as whether he was a whistleblower or not, Senator. You've heard a lot about that today already.
I don't believe the whistleblower is any more happy with the treatment he received from the international entity. A whistleblower also alerted Mr Thomas and yourself. It's quoted, the quote in this article says, Mr Thomas was previously accused by staff in KPMG's United Arab Emirates business of ignoring complaints about the boss of its business in the region. KPMG International said at the time it took all reports to its hotline seriously, taking appropriate action. Do you share the same vocabulary as the Australian group and the same kind of failure of response to your whistleblowers?
I don't recall if that's an accurate description of what we said to that particular individual, Senator, but it is the fact that we take every report to the international hotline seriously.
Okay. And after you take every report seriously, then you take the matter to a lawyer. So the next step you undertook with regard to the allegations about your Australian business was you engaged lawyers at Freshfield. And I had to find out what a Magic Circle law firm is. Apparently it's law firms located geographically somewhere near one another in London, and it's the primary corporate law of and the most profitable businesses with regard to corporations law in the Magic Circle law group, whatever they call themselves. So Freshfields, you went to Freshfields about this matter. What did you say to them, and what did you ask them to do, and when?
We sought some advice from them and about whistleblowing protections under UK law, because KPMG International is incorporated under the laws of England and Wales, and the whistleblowing provisions in the UK are different to Australia. And we asked Freshfields to work with us on this matter.
So your competitor, PwC, used a law firm in London called Linklaters to bury a report that they refused to make available to the Australian Parliament. Will you, in the same spirit that Mr Shepherd has come to acquire at the end of this day of hearings, will you commit to providing the committee with the Freshfields reports?
I want to be very clear, Freshfields have not provided any report to KPMG International because we were unable to look into the matter because we didn't have sufficient information.
So any correspondence you have with Freshfields to help us understand the scope of the inquiry that you were proposing would be very welcome by the committee. I would direct you to the letter that we've already provided to you, Senator, in the bundle of documents that we sent to you, dated the 1st of September 2025. And that's all there is?
That's not all the correspondence with Freshfields, but that's the substance of what I think you're asking for. So can you undertake to review any correspondence you have with Freshfields about the matter that's under discussion today and provide us with those further documents? I will need to go away and consider that, Senator.
Thank you.
Can I ask a question, Chair?
Last one, and we'll
have we tabled the opening statement to our committee from the whistleblower today?
Is it? Yes, it's been published.
So I just want to ask a question out of it, because it's a very succinct statement of a page and a half from the current whistleblower. And it's very interesting because he draws out the three things that brought him to this and the need for change: regulation change, change in ownership structure and whistleblower protections. But he then writes this: but the most serious failure is not local, it is global. It is evident that when allegations concern the leadership of a member firm, KPMG International will not or cannot intervene. It will not investigate. In effect, it does not care. That is the opposite of what its own policies and public representations promise to people and its clients around the world. What do you say to that statement, Mr Wingrove?
Senator, let me start by saying that first of all, I'm sorry personally. I'm a human being. The The whistleblower is a human being. I'm sorry for what that person has gone through. In terms of KPMG International's position on this, KPMG International, I think you are aware, has oversight responsibilities of all of our member firms globally. Each member firm operates as a standalone business. It's run, owned, operated by the partners in the relevant geography that they operate in. Our role is, as I said, oversight. That comprises a few different components that I won't go into here in the interest of time. But what that means is decisions in terms of how the business
we have had schooling about this. Management. I want to interrupt you there, Mr Wingrove. We had a lot of schooling about this from PwC. What we see here and what the whistleblower is saying is that this is a massive global enterprise which has failed for this individual and has failed in terms of its international obligations to its workforce and to the many, many people around the planet and companies that use KPMG. So I think that is a very powerful statement and an indication of a massive gap in KPMG internationally. Thank you, Chair.
Okay, we're just about to draw to an end the evidence from KPMG today. I expect there will be questions on notice. I hope that we very rapidly receive whatever's necessary to unlock the documents that are already awaiting in boxes at Ashurst and Allens. But I want to take the opportunity to call on partners. It's a long time since we started this morning and we had partnership law quoted here in the Senate. But I want to call on all partners, 680 of them, to respond to what they've seen of this matter and their leadership team today. I remind all partners that any reading of the law makes them all joint and severally liable for what's happened, and that the leadership that we have seen, or the failure of leadership, is a very serious concern, not just for us, but in terms of its implications for the financial markets. I acknowledge the release of the reports, investigation and legal advices, internal, external and other documents that we've asked for coming promptly to us. I encourage partners to talk promptly without requiring the government to act at this point. Structural change to address what you already know is rotten in your entity. Any of those who are out there who have not yet reported to CANS or ASIC what they have seen, what they've heard, not just self-report themselves, start talking up about what's really going on and start talking up early and you might get some change of culture. And can I put it to you, Mr Shepherd, that it's not just the Parliament of Australia that deserves your cooperation. I refer to PwC's gross ethical failure in its interactions with the ATO, frustrating the ATO for years from getting information with really outrageous LPP claims that were sanctioned by the court at a later date. You've got an opportunity to provide the documents to ASIC, to the TPB, without claiming legal professional privilege. And I urge you to do that because every time one of our regulators who are acting on behalf of the Australian people have to go to court with you, that's money that they have to spend on getting you to comply instead of you doing the right thing in the first instance. So I conclude the evidence from KPMG with those words of imploring some ethical behaviour in the days that come and the weeks that come. Thank you very much.
Thank you, Chair. And, as I've said, it's never been the intent for us to hide anything. I don't believe we have anything to hide. Absolutely, I'd like to end the day where I started it, which is, we are unhappy with how we've managed this process and we apologise, but we don't have anything to hide. We do want to be cooperative. As I said, I've tried very, very hard to navigate that difficult territory. I think the commitment to provide the documents to you, I hope Chair will help. And I think in terms of the other matters that you raised, in terms of structure, I think there is always room to think about governance and structure of organisations. And we
do too, but we see how you've constructed your independent board and have no confidence in the window dressing that seems to be part of what's going on. So if you want to add further words, I will encourage you to do so, Mr Shepherd. But
as much as it is appropriate that we are going to see these documents, let's not
I think,
play nice about it.
No, Senator, I'm not trying.
You've had to be dragged kicking and screaming to doing what you should have done in the first place.
Not trying to do that, Chair, at all. And I'll just refer to the Swikowski report that came out of.
Oh, please don't. We've got concerns about that as well. We don't want to go there. Go and read the evidence on it. So I will close this part of the day, and I will release you and call ASIC forward, please. Thank you, Mr. Shepherd. Thank you, everyone. Okay. Thank you. The committee is continuing to broadcast, and we now move to ASIC. I need to say special things here. I understand information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full names and the capacities in which you appear today?
Yeah, thank you, Chair. Sarah Court, I'm the ASIC Chair.
Kate O'Rourke, ASIC Commissioner.
Chris Vandra, Executive Director of ASIC's Enforcement and Compliance Group.
Peter Soros, Executive Director, Regulation and Supervision Group.
Thank you very much. We might go straight to questions from Ms Lawrence.
Thank you. Thanks, Chair. I'm not sure the extent to which you've had the benefit of hearing some of the evidence today, but what we have heard is KPMG has admitted that audit data, they framed it as displayed to win commercial data was displayed to win commercial contracts. Does this, in your view, fit the profile of unauthorised use of information for commercial gain? If so, given they've admitted particularly that confidential audit intelligence from Optus Lendlease was weaponised to win work from their direct competitors, do you see it as meeting the threshold? Or is it something that you're looking to see whether in fact it does meet the threshold of theft of confidential information or fraud under the Crimes Act? And is that then a matter for which would be then referred to the AFP or the NAC, given the firm's admitted also their rigour deficit in its own internal investigations?
Yeah, thank you, Ms Lawrence, and good evening, everyone. Could I start? We have had the opportunity to observe all of the evidence in the course of the day, Ms Lawrence, and so can I just take a moment to make a couple of observations about what we've heard and then come to your question about what does ASIC make of the particular examples. So I think this entire episode has been deeply troubling, and the evidence that we've heard in the course of the day has only served to deepen our concern. We think there's been an egregious and serious breach of trust that contravenes some of the most basic tenets of integrity and honesty in this profession. And there are a couple of points I want to make about that, if you bear with me. I know it's late in the day, but firstly, the relationship of trust between an auditor and the companies that it is auditing is critical. It goes to the heart of integrity in our financial system. A company has to be able to make itself vulnerable to its auditor and have the confidence in its auditor to fully expose its books, records and extensive commercial in confidence information, and the integrity of our markets depends on that disclosure. The misuse of confidential information by an auditor in the way that you've just outlined, Ms Lawrence, is a breach of trust. It goes to the heart of the professional obligations of an auditor, and high-quality, independent audit is critical to market integrity and to informed investor decision-making, and that is why we think this is so serious. The second point I want to make is that there are, in our view, clear gaps in the regulatory settings. Our jurisdiction in relation to audit firms as opposed to individual auditors, as we have discussed on several occasions, is extremely limited. We can only investigate individual registered company auditors within the partnership, and only then in relation to their conduct of an audit. We have long called for reform in this area, and we remain firmly of the view that the jurisdiction of the Corporations Act needs to extend to deal with big partnerships in the way we've been talking about today, and we also think that the sanctions applicable to breaches need to be significantly increased. We also consider the current whistleblower protections to be deficient. They need to be extended so that those that are seeking to make disclosures in relation to the conduct of partnerships such as KPMG are clearly protected. In relation to the governance of audit firms, a related observation is that we find efforts to include some company-type governance oversights to partnership models, and we've heard evidence about that today, does not provide any meaningful check or oversight of actions by the leadership of accounting firms. Coming now to your question, Ms Lawrence, in relation to the matters, we have formal investigations underway in relation to the conduct of individual registered company auditors within KPMG relating to two distinct issues. The first involves the potential misuse of Lendlease confidential information, and the second involves the misuse or the alleged misuse of Optus confidential information. Both of those are now formal investigations, and we have had extensive engagement with KPMG in relation to those issues. The final point I want to make is that this committee has heard extensive evidence today in relation to privilege claims. We recognise this is a fundamental right of parties. However, the committee's experience in trying to get to the bottom of what has gone on here reflects our very regular experience in undertaking investigations into issues of this kind. It poses a constant challenge for regulators, and while we do challenge it regularly, it is resource intensive, it detracts from our other work and significantly contributes to delay in our investigations.
Thank you. So just to confirm, the unauthorised use of proprietary information for commercial profit and potentially what we're seeing is a systematic weaponisation of client confidential data that's been entrusted to them is a matter that you can investigate, but you're limited within this, the individual partners, or
That's
how?
Right.
Like, can you just unpack a little bit about the scope?
I can.
And whether there are other bodies who may have. Like if it is a matter that if it is deemed meeting the threshold of theft of confidential information, is it a matter that the AFP can look into, or the NAC? If it's systematic, like can you just give us a bit of an understanding of the scope?
I'll do my best.
Limitations that you have.
Ms Lawrence,
describing.
We cannot look as things currently stand into systemic misuse of confidential information. We can only look at individual instances of misuse by registered company auditors. So if somebody within the firm who is not a registered company auditor, misuses confidential information, we do not have any regulatory hook at present to deal with that. So what we are at the early stages of investigating, and we are being challenged by claims of privilege to actually get to the heart of what's gone on here in the same way the committee is if there are particular registered company auditors within KPMG, then we can investigate those. And as I say, we are formally investigating in relation to those two instances, in relation to Lendlease and in relation to Optus, but we don't have a broader, wider investigation underway. In relation to your question about, well, what about other laws? It may be that there are other criminal, that there's been other criminal conduct here in terms of theft and misuse of information. I'm not an expert on those laws. We certainly have a very close relationship with the AFP. In the event we came across information that we were concerned raised those kind of issues, we could, of course, engage with those. I'm not saying that's the case.
Well,
but
the companies themselves that have been impacted adversely.
well, certainly, that's right. So that's right. And then in relation to the NAC, Mr Savandra will correct me if I'm wrong here, but I don't think these issues would raise NAC-related issues because, as I understand it, at least on what we know so far, these allegations involve the misuse of confidential information that does not relate to government tenders or work for the government.
Unless there's a systemic issue which might then relate to some other contracts, but we don't know what we don't know.
We don't know.
Yep.
No. And we are in the same position as the committee is. In fact, we may have less information than the committee at this stage, I suspect.
Thank you. Senator Pocock, second call.
Thank you. You have very clearly set out a series of challenges before the Parliament and the government in relation, and I want to make sure I've understood them correctly. Clear gaps in regulation, and I can hear Commissioner Longo's words in my ear, a sliver of possibility of regulation under current arrangements. Then you mentioned that corporations law, if I got this correct, yes, needs to extend to those big partnerships. And correct me if I've got that wrong, that sanctions need a very significant increase. We've certainly had extensive evidence today about sanctions that can only be viewed as trivial in terms of the pay packets of people who have seriously transgressed, and we find the leadership of KPMG has halved the two of the three sanctions were reduced by half, and they were sanctions that are only applied within that firm to their bonuses, not to their full salary. So the whole question of sanctions, and I think of the US and its capability to impose very large sanctions relative to here. And then extension issues for whistleblowers, improving arrangements for that, and the overall governance. We've seen really very weak governance. And in the PwC inquiry, there was enormous reliance on the shift to use of independent directors. I think we have seen the display today, no matter and I'm not making critical comments about the individuals, but the weakness of their independence, their reliance on the partners and the leadership of the firm, and their inability to stand up for true independence, especially in a crisis circumstance like we're currently seeing. So that's what I've heard you say. We need to have governance which provides a meaningful check on leadership of firms. Is that a fair statement? And have I understood your agenda that you're suggesting correctly?
Yes, you have, Senator.
And what about a whistleblower authority? What we have in the case of this particular whistleblower is their reliance on informal supports. They've shopped around very creatively in an attempt to keep themselves afloat and to find support, and we've seen how they've worked their way through a whole bunch of different systems to eventually arrive at the Parliament. What a terrible waste of the Parliament's resources. Really, it's not the function of Parliament to regulate our financial system directly, case by case, whistleblower by whistleblower. Yes. So what's your view about the need for infrastructure to support whistleblowers who are so critical to the integrity of our financial system?
Yeah, I think it's a very fair question, Senator. As I say, our position on this is that, as I said, that the current protections are deficient. They have to be remedied to enable people in the position of the whistleblower that the committee's been talking about today to have clarity as to their protection, because I think a lot of these issues, and clearly from the evidence today, the whistleblower has been attempting to get reassurance from a range of entities, and I need to include ASIC in those range of entities that the whistleblower attempted to seek reassurance from, and we were in a position to not be able to give that reassurance because of the way that the law stands at the moment. So that I had not been aware till I heard the evidence today of the lengthy previous attempts by the whistleblower to deal and raise these issues. But I think one clear way to remedy that issue is to amend those whistleblower protections. To make it clear to make it clear where the statutory protections kick in.
But Ms Court, the other issue is who's in the whistleblower's corner.
Yeah.
So we've heard about former partners getting the benefit of their legal expenses paid, and the whistleblower's left alone to their own devices to try and navigate this complicated maze, and without having an agency or someone there that's just looking out for the interests of the whistleblower. Do you recognise the second component with respect to Senator Pocock's question, that they need some sort of support?
Yes, I absolutely recognise that.
Okay.
So in the US, whistleblower incentive programs have been very effective, and I was very sceptical about them to start. I mean, you know, do we want to bring forward a population of false accusations? We certainly do not. But there are whistleblower incentive programs that have been extremely effective in helping high-quality information of wrongdoing come to the attention of regulators and lead to improved enforcement outcomes, including the recovery of hundreds of millions of dollars in fines and penalties. Would ASIC also support consideration of evidence in relation to those whistleblower incentive programs where they have proven to be effective?
I think, Senator, I'm aware of that regime in the US, and I know there's been a lot of work done by various committees, I think, over time to work out whether or not that would be a good regime to introduce here. I mean, I don't think it's self-evident that it would be, but it may be. And again, Mr Savundra might correct me if I'm wrong, but as I understand it, there is a review of the whistleblower provisions going on as we speak. And so,
are you going to make a submission? Because, you know, given what's going on, and this is an unbelievably effective case study in where the critical failure points are, and there is, as you allude to, the work of this committee prior to, probably I think it was 2017-18 that we were undertaking the review into whistleblowers.
It dates back a long way, that's right.
So, you know, can I encourage you to go back and have a good detailed look at it, because it does traverse the matter that Senator Pocock's just raised with you. And I urge you to put a set of practical solutions that deal with the very real challenges that are now very known to you about what you can't do and how beautifully designed, carefully thought out structures simply aren't meeting the reality of the real world.
Yeah, no, absolutely, Senator. And I recall we've made submissions in the past and we will make a strong submission again. As I say, we are strongly of the view that the current provisions are deficient.
And if we did the program that you've laid out and we saw change in all those domains, what would that mean for ASIC's resourcing? I mean, we can enlarge ASIC's functions, we can give you a whole lot of new jobs and create different regulatory ambit, but without resources, that won't be effective, will it?
We always are keen for additional resources, Senator. That won't surprise this committee. But having said that, what it would enable us to do were, for example, the whistleblower protections amended, would be that we could engage quickly and with clarity with a whistleblower so that they could have the confidence to give us books, confidential information and the things they have available to us without fear of retribution and retaliation, and with some protection from ASIC. And that's what we would like to be able to offer. That's what we can offer a whistleblower in relation to, you know, another corporate entity that is clearly within our jurisdiction. Now, were, Senator, the Corporations Act amended to bring large audit partnerships within our clear jurisdiction so that we had responsibility for regulating the firms in addition to the individuals within the firms, I think it would be helpful to have a discussion with the committee about resourcing at that stage, because these are very large, complex entities, and were ASIC to take a more active role, then yes, resourcing would be a considerable issue there.
Well, there's also the counterfactual, isn't it? The resources it takes today and to get to today, and all of the hard work by not just the whistleblower, their family and community, but all of the people who have made this happen today. We have to consider the cost-benefit analysis here. I want a final question. We've heard a lot today about deeds and how workers sign deeds, partners sign deeds, and the role they play in inhibiting, in dampening people's ability to speak. In ASIC's experience, are organisations using non-disclosure agreements and confidential clauses to inhibit the raising of concerns to regulators? And in your view, are such clauses enforceable?
I think, Senator, I'd have to take that question on notice if I could. I'm sure they do have a role to play in some of our investigations. I can't say it's something that gets brought to my attention frequently, unlike, for example, privilege issues that we've been discussing today, but I'd be very happy to find out for you and report back.
Thank you. I'd really like to know what you think about that and the incidence of it that you're seeing.
Yes,
thank
Senator.
you. Thanks, Chair.
Thank you. I just want to go to transparency reports. Do you see them?
I'm not quite sure what you mean, Senator, by a transparency. Oh, but the Big Four. Commissioner O'Rourke does, so that's very helpful.
Yes, that's right. I understand you to be referring to the reports that need to be lodged with us, the transparency reports.
They look like this.
Oh, right, yes. The annual reports that the firms prepare, yes. That's right.
Who's the audience for this?
Senator, sorry, I'm not personally familiar with what you're holding up, but
Well, we've
happy
got
to
some
take
for you to have a look at. So these transparency reports, I understand, are required to be produced, and they seek a degree of information. They look like lovely glossy documents. I can't imagine how much people would pay consultants to prepare them. Like, they look like $1 million documents to me, based on some of the jobs I've seen for $1 million. But one of the things that it does at the beginning of the KPMG documents for 24 and 25, which is the area we've been traversing, is it's got a little section, we're about 3 pages in, on both of them. One's landscape, one's portrait. The culture and tone set by audit practice leadership promotes the importance of audit quality for audit and assurance engagements. Transparency rating, 86%.
Yeah, I can see that number on
How useful
slide 3.
is this, given what we've been hearing today?
Yeah, I'm not sure that's a very useful number, Senator.
So the same thing, page 3 on the 2024 one, 86%, the culture and tone set by the audit practice promotes the importance of audit quality for audit and assurance engagements. 86%. I mean, that must be the easiest self-test ever, because the reality of what we've traversed today is completely at odds with this transparency report.
I think just picking up with what Chair Court said earlier, to the extent there have been efforts to include some governance-like arrangements in relation to the firms, I think that you could extend, I think the point made was in relation to independent directors, but I think you could similarly extend that to reporting, financial and other reporting. So it's an aspect that ASIC's been particularly keen to progress, is the preparation of audited financial reports by the firms. They're not currently required to do that.
Thank you.
They are required to prepare transparency reports, but because they have so much more latitude over what's included in them, we don't think they're as useful as audited financial information would be.
Can I ask you to put your minds to measuring what matters instead of measuring what's easy to measure? Because clearly the ethical dimensions of this, the compliance with APES, which is observed through a range of regulatory elements, it clearly is not working. So what sort of documentation needs to be produced to ensure that audit quality is of the right kind? And I'll come to you for a bit more detail on that. But I also just want to point out, before we jump off these beautiful documents, they're saying everything's going grand at KPMG while we've got a whistleblower screaming, shouting, knocking on every door, trying to blow the whistle on horrendous behaviours, which I think were aptly described in paragraph 10 that was read into the report today. Under the title of Independence and Ethics, it says there were 0 whistleblower complaints related to audit quality. It doesn't match reality. Same thing in the 2025, 0 whistleblower complaints. So can I just draw your attention to
what a waste of time, really. That there needs to be a better measure. Finally, as we draw the day to a close, can I just commend you once again on ASIC Report 817. One of the concerns I think that the committee has is how much interconnection there is between people in the audit sector. We've got people leaving the audit sector, going on to be the chair of the audit committee for companies that they used to audit. The gaps don't seem like they're very big. The old boys network, the old girls network now, we can actually claim that it's beginning to happen. But this loyalty to firm seems to be a huge problem as opposed to loyalty to professional ethical standards. I think that's been documented. Ms O'Rourke, I think you're responsible for this report.
Our team is responsible,
team.
but I've had the opportunity to speak to the report to the Senate
Humble
before.
as always.
Thank you for
Wonderful
that.
team, yeah.
14 auditors did not meet the requirements for independence in relation to 20 audit clients, is one of your findings here. You talk a little bit about rotation schedules, etc., but prohibited relationships and the reporting of relationships, conflict of interest management around relationships seems to be one of the very significant concerns that you raise in this report. And it's almost like you knew what was happening when you wrote about, you gave an example of auditors spending a long time on the audit of the client, 24 years you wrote. First auditor spent 16 years playing a significant role on the audit, while the second auditor spent 12 years. You also go on to talk about the focus on relationships with office holders who are ex-partners. We've been seeing an awful lot of that. Office holders had been the auditor's former sponsor to partnership. Office holders and the auditor had ad hoc catch-ups. We didn't get to questions about whether ad hoc catch-ups were happening at Taylor Swift concerts, but we know that tickets were proffered. We did get to the weekend visit of Mr Nash, who was an ex-KPMG partner who was working on the Westpac audit team, who stayed with Mr Shepherd and Ms Bell. These things seems quite problematic to me. I just want to get your thoughts on what you observed, how concerned you are about it, and what you propose to do about the issues raised in Report 817.
Yeah, no, thank you. As we've talked about at prior hearings, this effort to have a deep dive in relation to independence and conflicts was because ASIC recognises the importance of these issues, and I think just to reiterate our chair's opening comments about this being at the trust and the management of confidence and conflicts is at the heart of the relationship and the issues here. So that's why we resourced and prioritised this work. As you've alluded to, there were findings across both the specific requirements about independence and conflicts, but also the general ones. And those general ones include managing some of those threats to independence about relationships, about prior working relationships or tasks. And we did seek to be as persuasive as we could in our findings by including case studies. So I think you've read a couple of them, and I can agree they really, there's some echoing with what we've been hearing through the course of the day. So we remain very concerned. Our efforts when we prepare reports are to try and influence behaviour and change behaviour, because that can often be incomplete. We also take enforcement action as well as preparing reports. So there is, I think, a description here of some of the enforcement action that ASIC's been taking in relation to auditors, but since then, October 2025, we have commenced additional proceedings, both in the Company Auditors Disciplinary Board, but also we've commenced for the first time civil penalty proceedings in relation to an auditor. So, yeah, there's a range of work because of the importance of this topic.
Do you think it's a bit of a closed shop? And I'm interested in the concept of enculturation, you know. We've had the rotten apples, we've had the strudel throughout the course of the day.
was the best analogy during the
Yeah, but there's kind of a stewing in the juices of a particular industry or a particular workplace that leads to cultural practices that could be very, very flawed and very difficult to change. You said that amongst those that you sought information from, there seemed to be little consideration of what a reasonable person may think in relation to cumulative ties and personal relationships and the management of real and perceived conflicts of interest. What can a regulator do when the cultural stew is rotten?
Well, I think, Senator, as Commissioner O'Rourke said, what we can do is call it out. That's exactly what the report that you're referring to attempts to do. As Commissioner O'Rourke said, we are expressing to the profession our concerns about these issues. We're outlining case studies. And I think, unfortunately, given, as I said earlier, the limitations on our jurisdiction here, apart from dealing with failures by individual registered company auditors, we are to some extent limited to doing the surveillance, as putting out these reports, talking about these issues and calling them out, and we will continue to do so.
Thank you. Now, before we wrap up, I wanted to give Mr Savandra, Mr Soros and Ms Labouchardie an opportunity to just put anything on the record in response to what you've seen and heard today.
Chair, I'd endorse the comments of Chair Court. I think what we've seen today has been enlightening, I think, and deepens our concern and resolve to get to the bottom of what went on. You know, the challenges around privilege are a real one. I think the reforms around whistleblower are really important. You know, I think the evidence was given earlier today, and I think we've given the evidence previously. We don't confer upon a whistleblower status. And I think that is a challenge where the whistleblower situation could be deeply complex, where the protection's only afforded if the alleged conduct relates to a corporate entity or an entity that falls within the whistleblower laws. So. I think that's, you know, I'd really just endorse what Chair Court's had to say in terms of the reforms that we think would be required.
Any further comments?
We'll keep doing the regulatory work that we can within our remit, but the law reform is an important
necessary.
Conversation. Yeah.
Yeah. Okay.
Just before you go, the investigations that are underway with some of the members of KPMG who self-reported, any idea of what timeframe your investigations will take?
I think, unfortunately, Mr Pocock, it's hard at the moment to estimate that. They are at a relatively early stage, but I can assure you that we have resourced them well, and we have a very dedicated team that is working hard to bring them to a fruition as soon as we can.
So in previous or similar situations, what's the scope of a timeframe look like? Quick time would be this, an awkward time frame would be this.
I'd say a quick time would be within 12 months or so.
Yep.
Awkward time frame would be longer.
Yep.
But I do need to caveat that with it is entirely dependent on when we get the information that we need to get to do our work.
Maybe we can assist with that.
Well,
it's not our job.
No, I've encouraged them to not cost the taxpayer any more money.
Yeah.
But we shall see, and I'm sure that you'll keep us informed.
Yes, we will, Senator.
Can I draw your attention to two documents that are now live on the committee's website, which is the opening statement received in an in-camera session from the whistleblower, and the whistleblower's document, which will be followed by an appendix of a couple of other reference documents early to mid next week, I'm thinking.
Thank you.
Absolutely a shocking read, but very, very worthwhile. So that is now another gift from the whistleblower to put on the public record about the frustrations and to contrast with the assertions of the very big and powerful KPMG. That really brings us to the conclusion of the session. Can I ask for, if there are any questions on notice, that you reply by July 17? I want to thank you for your evidence this afternoon. Can I sincerely thank members of the public who have been with us all day, who are here representing the good people of this great nation, who have high expectations with reasonableness attached to that for these big entities to do the right thing. Can I thank the Secretariat? It's been a huge task to undertake this, particularly when we had such hostility in response to the work we need to do here. Can I thank Senator Pocock, Senator Scarr, Deputy Chair Mr Buchholz, Ms Lawrence, Ms Whiteaker, Ms Jarrett and Mr Moncrief, who are very active members of this committee and have undertaken a huge amount of work to prepare ourselves to be here for today. And can I just close by saying it's not a normal way to spend a Friday for many Australians, but as a Senator of Australia, can I just say that I am so pleased to sit here with my colleagues today and undertake this work in the national interest, and I am very grateful for your evidence, your continuing work as ASIC, and I look forward to seeing how you attack the problems that are manifestly obvious after this, and I know that the government will be looking very carefully at the reports that have already been tabled through this committee, the evidence received today, and I have confidence that there'll be further action. Thank you very much.
Thank you, Senator.
The committee stands adjourned. Thank you very much.
Thank you, Senator.
The committee stands adjourned.